Assalamu alaikum wa rahmatullahi wa barakatuh. Good morning, our guests in-house and those who are online. We welcome you to this People and Justice Summit by the Mediation and Arbitration Center for Muslims in Uganda. And we are truly honored and privileged to have you here today, where we will have in-depth, insightful, and informative conversation around justice in the Muslim ecosystem. My work and my job today is to welcome you formally and properly, but we're getting started in a few minutes, so I just wanted to let our online audience know that we are settling in the physical room, and we'll be joining you shortly to have the official start of the program. Thank you so much for sparing time to come and be with us today. And we will be starting shortly as our guests settle in. Assalamu alaikum wa rahmatullahi wa barakatuh.
البدر كطلعته وجه جميل والشمس كبسمته ظل ظليل هو عبد الله سيد الخلق ومصطفاه وحبيب الله خير مبعوث بوحي الله مولاي صل وسلم دائما ابدا على حبيبك خير الخلق كلهم مولاي صل وسلم دائما ابدا على حبيبك خير الخلق كلهم يا رب صل عليه يا رب صل عليه يا رب صل عليه صلوات الله عليه هو خير عباد الله خير البرايا حي فينا بهداه حلو الوصايا نسألك الله تجمعنا يوما برسول الله من كوثره يروينا فتقبل يا ربنا مولاي صل وسلم دائما ابدا على حبيبك خير الخلق كلهم مولاي صل وسلم دائما ابدا على حبيبك خير الخلق كلهم يا رب صل عليه يا رب صل عليه يا رب صل عليه صلوات الله عليه طاهر القلب نقي ذاكر لله المصطفى الصفي صلى عليه الله أخلاقه وصفاته سبحان من سواه هو قدوتي وحبيبي ودعوة النجاة يا رسول الله يا حبيب الله فاكتب لنا نلقاه ندعوك يا رباه مولاي صل وسلم دائما ابدا على حبيبك خير الخلق You're here, you're always near, and I know without a doubt that you always hear my prayer. सच की राह पे चला करो, खुद ना किसी को दिया करो, जो दुनिया का मालिक है, खामोशी का लिया करो। अल्लाह ही अल्लाह, अल्लाह ही अल्लाह, अल्लाह ही अल्लाह किया करो, दुख नसीहा, अल्लाह ही अल्लाह। So many bright stars like diamonds in the sky. Oh, it makes me wonder, anyone can be blind to all the signs. So clear, just open your eyes, and I know without a doubt you will surely see the light. तेरी ही दुनिया, तेरी ज़मीन, ये कहकर शाहे तू है करीम मेरे मौला, सुन ले दुआ हम बेबस है तेरे बिना, रोशन कर जमा। ऐसा जुल्म न किया करो, दुख न किसी को दिया करो, जो दुनिया का मालिक है, खामोशी का लिया करो। अल्लाह ही अल्लाह, अल्लाह ही अल्लाह, अल्लाह ही अल्लाह किया करो, दुख न किसी को दिया करो, जो दुनिया का मालिक है, खामोशी का लिया करो। अल्लाह ही अल्लाह, अल्लाह ही अल्लाह। अल्लाह ही अल्लाह किया करो, दुख न किसी को दिया करो, जो दुनिया का मालिक है, खामोशी का लिया करो। अल्लाह ही अल्लाह, अल्लाह ही अल्लाह, अल्लाह ही अल्लाह किया करो, दुख न किसी को दिया करो, जो दुनिया का मालिक है, खामोशी का लिया करो। अल्लाह ही अल्लाह, अल्लाह ही अल्लाह, अल्लाह ही अल्लाह, अल्लाह ही अल्लाह। We're here on this special day, our hearts are full of pleasure, the day that brings the two of you close together. We're gathered here to celebrate a moment you'll always treasure. We ask Allah to make your love last forever. Let's raise our hands and make dua like the Prophet taught us, and with one voice let's all say, 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 Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma bil khair. Barakallahu lakuma wa baraka friendship, support each other. Together worshiping Allah, seeking His pleasure. We pray that He will fill your life with happiness and blessings, and grant you kids who make your home filled with laughter. Let's raise our hands and make dua like the Prophet taught us, and with one voice let's all say, Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. حبهما الله صل وسلم على رسول الله. الله تب علينا، الله ارضى عنا، الله اهد خطانا على سنة نبينا. Let's raise our hands and make dua like the Prophet taught us, and with one voice let's all say Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair.
Assalamu alaikum wa rahmatullahi wa barakatuh once again. You are most welcome to the MAMC People and Justice Summit. And before we do anything this morning and today, we would like to make our intentions clear and present them to the Almighty Allah. And our niyyah is to make sure that we have discussions that uplift the Ummah, that add value to the Islamic justice system, and all in all contribute to the reform for lillah and the goodness and the benefit of the Muslim community. My name is Mariam Nansambaiga. I am your hostess for today. And the first order of business is to invite Sheikhat Warda Warusimbi to lead us in a prayer.
السلام عليكم ورحمة الله وبركاته. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. وإذ قال موسى لفتاه لا أبرح حتى أبلغ مجمع البحرين أو أمضي حقبا فلما بلغا مجمع بينهما نسيا حوتهما فاتخذ سبيله في البحر سربا فلما جاوزا قال لفتاه آتنا غداءنا لقد لقينا من سفرنا هذا نصبا قال أرأيت إذ أوينا إلى الصخرة فإني نسيت الحوت وما أنسانيه إلا الشيطان أن أذكره واتخذ سبيله في البحر عجبا. صدق الله العلي العظيم.
Alhamdulillah Rabbi Alamin. Thank you very much, Sheikhat Warda Walusimbi, for that dua. And Alhamdulillah, our intentions are now very clear before Allah. I would like to welcome you once again, those who are in the room present and those who are online. We thank you so much once again for sparing time to come and be with us on this day when we will add a brick, and I believe a cornerstone brick, on the justice system of Uganda, specifically in supporting justice that is restorative, especially for the Muslim community. The Muslim Arbitration and Mediation Center is proud to have this inaugural summit here in Kampala. This will be an annual event, and this year's theme is uncovering gaps and exploring solutions. To take you back, around May this year, MAMC, as we know it, was launched, and we had many goals. But the theme of the launch was justice that heals. And within 6 months of the launch, it is very evident that as MAMC has rolled out to contribute to the justice system in Uganda, furthering Muslim interests, it was just a timely launch, because within this short spell of time, it also so happened that in the ecosystem, in the legal system of Uganda as we know it, there were a lot of reforms, there are changes, and it was just a nick in time that MAMC started such initiatives. The topics we are going to discuss today are very, very pertinent. And if you see, we are in a more formal and serious setting compared to where we were. Dr. Hafiz will confirm. When we were launching, there were mood lights, there was cake, there was a swimming pool. But this is to show us that today we mean business. Our sleeves are rolled up, our knuckles are oiled. We're not going to fight, but we are going to peel. Those who come from my culture, when we are going to peel matoke and you don't want the sap to get sticky, you oil. So we are oiling our knuckles so that we can safely peel and uncover the layers in the justice system, so that we give a timely contribution to the reform that will benefit Uganda and specifically the Muslim community. I'm very excited for the topics for the day, as you can see according to the program. I'm equally excited for the panels and the speakers that have been very carefully curated, because one, the topics are very important, but also they are very sensitive to a degree. When you talk about succession, there are a lot of stakeholders there. When you talk about alternative dispute resolution, when we speak about Qadi courts. So my humble request and prayer is that, one, we take this discussion very seriously. There will be a town hall at the end of this day where we will hear from you. We will take your thoughts. Where we are able to, we will put them into action. Where we are not able to, we will definitely pass them on and escalate them to the powers that be. Without taking much of your time, I will be back to guide the program for that day, but I would like to take this opportunity, one, on behalf of MAMC, to thank from the bottom of our hearts the Islamic University of Uganda, our gracious hosts. Please give them a clap. They have given us a place, they've given us a home for this summit, and it's only befitting in this Ummah spirit that we let them officially invite us into their space. So at this point, I would like to invite our hosts, the rector or their representative, to officially invite us into their space. Thank you very much.
Thank you. Bismillah ar-Rahman ar-Rahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala Rasulillahi sallallahu alaihi wasallam wa ba'd. Assalamu alaikum wa rahmatullahi wa barakatuh. My name is Dr. Taha Ahmad Kasule. I am the director of IUIU Kampala campus. I'm standing in this morning for the rector to welcome you, distinguished participants, to this People and Justice Summit of 2025. Briefly, I would just, for those who have not been at IUIU, take a moment to inform you that this Islamic University in Uganda is a project of the Organization of Islamic Cooperation called the OIC. It was established, or the idea to establish it was arrived at during the Heads of State Summit in 1974 in Lahore. And at that particular time, they were proposing to establish 2 universities in Africa, one for the Anglophone Africa-speaking countries, English-speaking Africa, and the other one for the Francophone. So the head of state of Uganda, who was in attendance then, immediately requested that the Anglophone university should be established in Uganda. So that is how even the name is crafted, Islamic University in Uganda. It is in Uganda, not of Uganda, because of the fact that Uganda is just a host for this particular project. Many years passed because of our political turmoil at that time, and IUIU could not be established. But in 1988, alhamdulillah, IUIU formally opened its gates at the former Nkoma Secondary School in Mbale, starting with 2 faculties and 80 students. And over the years, the university has been growing. After 13 years, it was found necessary to start spreading around the country to bring the education services closer. That is how IUIU Kampala campus was mooted, and it was brought here at Chivuli, where we were happily welcomed by the leadership of this hill and graced with about 5 acres of land from the Uganda Young Men Muslims Association. And we have been here as IUIU Kampala campus for the last 23 years. Other campuses were established, one at Kaboja for female students, and another one at Arua in northwestern Uganda. I would like to take this opportunity to welcome you. IUIU is one of the players in the legal field by through the Faculty of Law by educating many, many lawyers. Our School of Law currently is the biggest faculty in IUIU, as a matter of fact, by student enrollment here at Kampala campus. And if you add the numbers elsewhere, you'll find that the biggest faculty is actually the Faculty of Law. We would like to thank all those who have contributed to it. And the good thing about this particular faculty is that our keynote speaker, the Honorable Justice Musa Sekana, is the brain behind that particular faculty. Every time we host Honorable Musa Sekana, we tell him, you started the faculty, you nurtured it at the beginning, and for us, we only have the obligation to make sure that it does not fail. So the challenge of IUIU is always to make sure that the Faculty of Law is performing and growing and taking its true place in the legal education sector in this country. We are happy to work with the Muslim Arbitration and Mediation Center in hosting this first summit, the People and Justice Summit. We are grateful that you have decided to come up with this kind of initiative, uncovering gaps, exploring solutions. We know that as Muslims in this country, we have got a lot that we need to take care of in terms of legal, in the legal spectrum. We have got our own unique laws that we want to make sure that they are captured in the legal system of the country. But we are also, in particular, have got specific interest in some sectors that are emerging, especially the Islamic banking and finance sector. It's an emerging sector. We are players in that particular area as well. It has got a very different legal framework from what the rest of the financial system has been doing. And we are already happy that the government of Uganda has passed it, but we are cognizant of the fact that the story has not yet ended. Some of the players in the ecosystem in the Islamic finance area, such as insurance, such as capital markets, who are actually players in this particular area, still have got things to do to reform either their own laws or their own regulations as regulators of those particular subsectors in order to ensure that the Islamic financial system can work effectively and without legal hiccups here and there. We are happy that we have got judges in this particular forum. We are going to learn a lot from you. We are going to create an audience here, and our students have been requested to join online as well. We hope that a lot of benefit will come out of this particular exercise, and inshallah we can be able to come up with the steps that can ensure that we work together to change the legal obstacles, inshallah, either through advocacy or any other manner that is befitting. I want to welcome you once again to the Islamic University in Uganda. This is a journey we are willing to walk together with the Muslim Arbitration and Mediation Center and other stakeholders in this way. And anytime you want to hold events of this nature and partner with IUIU, we are just a call away. Let us know that there is something we want to work with, and then we can be able to do it. Once again, on behalf of the Islamic University in Uganda, we welcome you and we welcome the participants. Feel at home. This is your home, and we are partners in this together. Assalamu alaikum wa rahmatullahi wa barakatuh.
Alhamdulillah Rabbi Alameen. Thank you very much, our gracious hosts. We appreciate the warm welcome. And just to be a little more guided, especially the online audience, today's summit is going to be a little bit different. One, we do appreciate that the nuances around the topics we are going to discuss are not very easy and they need to be simplified. And because we are particularly going to address something that has been, let's say we are jumping on a moving train, especially when it comes to the ADR clause and Article 28, we want to address it from first principles. We thought it wise that in the interest of everybody being on the same page and leveling the ground, the discussion that will happen in this room will be translated in a local language that is spoken by the majority, summarily, so that we don't just talk to ourselves. Some of the concepts, especially in arbitration, can be complicated, as well as the other legal discourse that will happen here. We truly understand that the end user, as the summit theme is the people, and we do not want to leave anyone behind. Because once we uncover these gaps and explore solutions, we hope that the solutions that we come up with at the end of this summit will be the ones that benefit the people the most. So our international audience, please understand our why and join us, speak a word or two in Luganda. And as you keep in touch with this family, you just never know, you might be bilingual in a short time. Abatuwuliriza n'abatulaba tubaaniriza nnyo mu lukuŋŋaana luno olusoose mu kifo kino ekya Islamic University naye nga lutegekeddwa Muslim Arbitration and Mediation Center, ekitongole ekyatondebwawo okuyamba okutabaganya n'okuyamba mu mateeka okuyamba eggwanga n'abasiraamu okutegeera emiwaatwa gye basobola okweyambamu nga wazzeewo obutakkaanya n'okufuna obwenkanya naye nga tuvudde mu nkola eri ey'ekkooti nga bwe tuzimanyi, traditional court system. Tugenda kubannyonnyola n'obayigiriza n'obalaga emiwaatwa olunaku olwaleero gy'osobola okuba ng'oyambibwamu naye nga tukusomesa era mu nnono z'amateeka agatambuza ekintu kino ekya obwenkanya wakati w'ekkooti nga bwe tuzimanyi. Twetonda nti tetujja kusobola kubabuulira kigambo ku kigambo ng'abateesi bwe banaaba bakikoze wano olwaleero, naye nga tubasuubiza nti tujja gezaako mu busobozi bwaffe okufunza mu ngeri ebayamba okutegeera ekigenda mu maaso, nti olunaku olwaleero we lunaaba luwedde tujja kusobola okwongera okuwuliziganya naye nga emirandira gy'okutegeera amateeka n'obwenkanya bw'osobola obufuna wabweru w'ekkooti eza bulijjo ng'ensigo yeesimbiddwa. Amannya Bampita Nansamba Mariam Iga, ngenda kuba nga mbayambako nga ndi kabalaba b'omukolo naye era nga ndi omu ku bagenda okuteesa era okutambuza olunaku luno. You're most welcome, and without further ado, because we do have an international speaker from Nigeria who will be joining one of the panels. So please stay tuned, get ready for a very insightful, educative discussion, but most importantly, we hope that we will live with mindsets changed and we will carry the reform to wherever we will go to dispense justice with a bid to make this restorative. So thank you very much. Welcome with me, Zubeda Namugenyi, the ED for MAMC.
Assalamu alaikum rahmatullahi wa barakatuh. I am so honored to be standing before you today. This is an idea that we have been curating and crafting as the Muslim Arbitration and Mediation Center, and to see it come to fruition is such an amazing honor. My name is Namugenyi Zubeda. and I am the CEO of the Muslim Arbitration and Mediation Center, Uganda. Your Lordships, leaders of the Islamic community, scholars, land friends, and other friends, members of the Uganda Police, who also double as my students of mediation, Dr. Umar Oseni, the Secretary General of the Organization of Islamic Cooperation Arbitration Center, who is joining us from Geneva, Switzerland, the Registrar General of the Nigerian Chamber of Commerce Arbitration Center, who is also joining us online. I am so honored to welcome you to the first People and Justice Summit, and we hope that we can continue this initiative every year. I am more especially honored to welcome the keynote speaker, Honorable Justice Sekana, who has contributed immensely to this cause. I write a lot, and every time he sees my work, he texts me and says, I see you, keep representing Islam, keep representing Islam. So on small and big ways, he's always supported. Cave Hills campus, a Bachelor of Laws from Makerere University, a postgraduate diploma in legal practice from the Law Development Center. He has over 20 years of legal and judicial experience. Justice Sekana has served in the private sector at Nyanzi Chiboneka and Mbabazi Advocates, and later as a partner at Sekana Associated Advocates and Consultants, where he handled civil, commercial, public law, and taxation matters. He has been instrumental in legislative drafting and law reform, contributing to projects under the Uganda Law Reform Commission, and including compiling the Compendium of Electoral and Local Government Laws. Beyond the bench, he has taught at several institutions, including our host, Islamic University in Uganda, and I was surprised recently to learn from one of his students that he taught at Uganda Christian University. He has also authored books such as for civil procedure, criminal procedure, and public law. I would like all of you to join your hands to welcome our keynote speaker, Honorable Justice Musa Sekana, Justice of the Court of Appeal and Constitutional Appeal.
Assalamu alaikum wa rahmatullahi wa barakatuh. Mama Mamuk Zubeda, thank you for the flowery introduction. And we thank you for putting these thoughts together. And we hope that inshallah we shall be able to maintain and sustain it all through in order to bridge that gap of the Muslim intellectuals. And I think, as the director, Kampala campus said, we should take our space as Muslims, and IU being our key convener should really take that lead as well of breeding or bringing together the Muslim intellectuals. I believe we have been lagging behind, and it's high time we took our space and took our position and take guidance in most of the things the world or the country needs from the Muslim community. I don't want to waste a lot of time. Let me just read out my keynote address. Distinguished guests, fellow speakers, respected elders, students, friends, Assalamu alaikum wa rahmatullahi wa barakatuh. It is an honor to welcome you all to this first ever People and Justice Summit, a truly historic gathering. I want to thank Muslim Arbitration and Mediation Center Uganda and the Sharia Department of the Islamic University in Uganda for lighting this flame, for creating a platform where law meets faith and where people can finally talk about justice in a language that feels familiar and true. This is the beginning of a new chapter that asks, how can justice serve everyone, not just in theory, but in our daily lives? The theme, uncovering gaps and exploring solutions, could not be more befitting, because when we look closely at our justice system, we find not only laws, but people. People try to solve the family conflicts, inheritance disputes, land wrangles. The people who want justice often find it too far and too costly or too slow. Nowhere, now it is even more evident than before that in the area of succession and inheritance, which has just been amended, many of our Muslim brothers who have come to courts to have these disputes resolved have found challenges. The recent amendment was meant to bring about fairness, especially for the widows and children. Of course, for some reason, society believes these are the most vulnerable persons, widows and children. Although in exceptional circumstances, there are some males who are also victims of unfairness. Yet to our Muslim community, which forms about 14% of the population, the act sometimes clashes with our religious beliefs. Islamic law has clear faith-based rules on inheritance, who inherits in what proportion and why. But the national legal system, though well-intentioned, often operates from a different foundation premised on the Constitution, which enjoins equality before the law. The result, therefore, is usually confusion. Families are torn between following their faith and obeying national laws. Cases that drag on because courts are unsure on how to reconcile. We are usually faced with this challenge for a fact that we are very few in the judiciary, and these disputes don't end up with us at all times. They end up before our colleagues who are non-Muslims. And when they are faced with them, sometimes they don't even want to look at the other side. And these are the challenges that we need to have a solution to. I will tell you that I'm taken to be the most knowledgeable amongst, at least let me talk for the Court of Appeal now. They think I'm a Muslim. Therefore, I know everything about. So any decision they want to take touching the Muslims, they summon me or someone calls you and says, no, I want us to brainstorm on this. So, of course, I've always told them I'm not an expert and I don't even have the knowledge of Sharia. That's a fact. But usually I ask for time and I come back and confer with, I will not hide it, it's usually Dr. Hafiz. I tell now we have this challenge, what do we do? And then I go back and give the guidance whenever required. Because I know the decision is going to come out and it's going to impact on all of us, the Muslims. Now, if these non-Muslims decide without factoring that, it will definitely be extremely detrimental. So some of the decisions, I don't want to say all, but at least some, whenever they've consulted me, I've tried to give the proper guidance expected so that we are not affected by wrong precedents, as you all know that we operate on the doctrine of precedent. This is where the constitutional promise of Article 129 becomes so vital. It allows for Qadhi courts that would handle matters of marriage, divorce, and inheritance according to Islamic principles. Yet, over 2 decades, the promise still awaits to be fulfilled. And just this year, you took a hopeful step. Uganda took a hopeful step when Cabinet approved the National Alternative Dispute Resolution Policy 2024, a powerful reminder that justice doesn't always have to be fought for in courtrooms. It can be built around dialogue, forgiveness, and community understanding. ADR in many ways mirrors what faith has always taught us, that peace is often found not in the victory, but in reconciliation. Because as Muslims, I think we have always tried to use ADR as the most amicable way. I know Chibuli here, they try to do ADR in family disputes. Supreme Council, headquarters, they're equally involved in those disputes. The challenge we have is these are only in Kampala. So you can imagine what happens. We know Muslims are all over the country, Arua to Kisoro to all the extreme ends. Now, how many would be coming to Supreme Council to say, I have a family dispute? It's basically a few, extremely few, who can make it to Kampala to have a complaint addressed. Therefore, I think ADR comes in handy, and I think that's why MAMC would be available to address some of these challenges through ADR to the Muslim community in Uganda. Therefore, as we think justice for a changing Uganda, we must face the truth. Faith and law must not compete, they must cooperate. If our justice system is to be fair, it must speak to the hearts and the realities of all Ugandans. It must allow Muslims to resolve personal matters according to their faith, while ensuring that the rights and dignity of everyone, especially women and children, remain protected. This summit is therefore a call to action to turn policy into practice and promises into lived experience. Let this be the beginning of a Uganda where Qadhi courts move from the constitutional pages into real communities. Succession and inheritance are guided by both law and faith. Justice is not just written in statutes, but felt in the lives of ordinary people. Justice in the end is not measured by how loud we speak in court, but how deeply people trust the system that serves them. May this summit plant that trust anew and afresh, and may it mark the beginning of a fairer and more faithful Uganda. Thank you. May God bless you. Assalamu alaikum.
We thank our brother, the Honorable Justice of the Court of Appeal. My name is Kaketo Mahmoud. I am an advocate, a practicing one, managing partner of Luminous Advocates, and I double as the ex-official of the Uganda Muslim Lawyers Association. I would like to thank our brother, our senior colleague, who is the founder president of the Uganda Muslim Lawyers Association, Honorable Mr. Justice Sekana Musa. Another round of applause. Brothers and sisters, I would like to let you know that this summit is a hybrid one. We have it virtually, screened live, and our members are following virtually, and us here are following physically. And as such, in as much as this summit, for us who are gathered here, are mostly leaders from different fraternities, but there are people out there who are following us from different walks of life. Some were advocates, others are businessmen, others are judicial officers, and many others. As such, we are going to be intermixing the language, that is English and Luganda, and allow me to briefly summarize the key note address of our brother in our local dialect, that is Luganda, for the benefit of those who are following virtually. Precisely, Muganda waffe owekitiibwa omulamuzi wa kkooti ejulirwamu Honorable Mr. Justice Sekana Musa abadde ategeeza ku kinyusi ekya summit eno. Ekinyusi kya summit eno, People and Justice, abantu n'obwenkanya, nga ategeezezza basically about ku nsonga eza kkooti ne enzikiriza n'okubeera nga ffenna nga awamu tuganyulwa mu ebyo bigenda mu maaso. Naye nga mbufunze ategeeza ku Kavi Courts, kooti ezitawuluza abasiraamu, nga majorly ekisinga okuba ekiganyuzibwa mu kooti ezo okubeera nga tugezaako okubeera nga tubeera abantu abakkiririza mu ntabagana, kubanga okutabagana ki mu nsonga z'obusiraamu, era Quran, Hadith nga bajja obbagaba mu maaso eyo zibyogerako nnyo. Era ntegeeza mugenda mu maaso nti nno tuba tubeera mu makooti tetulina kulaba nti nno ani awangudde, tetulina kuba tulinga nnyo ku ani awangula, wabula tulina okulaba nti nno wetubeera mu kooti wabawo okutawuluza wakati wa enjuyi ze mu kooti, naye ng'ate ekisinga waba batawuluziganye mu mbeera y'okutegeeragana yebeera win esinga ku side zonna, kubanga tubeera mu kooti ne tubeera nga omulamuzi yasazeewo ebeera win ku side emu, ebeera nga side emu yewangudde, naye ate we tubeera eno ne tutegeeragana tubeera nga buli omu awangudde okusinziira ku nga bwe tuba tukkiriziganyizza. Nawe ekityo era agenze maaso n'abeera nga ategeeza nti ke kaseera ak'okubeera ffe ng'abasiraamu tugenda mu maaso n'okubeera nga tuyongera okuganyulwa mu Kavi Courts n'abo bonna abagezaako oziyimirizaawo, era ne yeebaza ekitongole eky'ekibuli n'ekitwalo ekikulu Old Kampala okubeera nga balinawo balinawo sekiti eyo ey'okubeera nga etabaganya, era n'agikubiriza egende mu maaso okubeera nga eyongera okufuna n'abalala abakugu bagiyambako mu kubeera nga batuukiriza okutabaganya okulungi. Era mu kumaliriza amaliriza nga ategeeza nti nno enzikiriza faith ne amateeka tebirina kubeera nga biri parallel bitambula nga wabweru wa buli kimu, wabula birina okubeera nga bikwatagana, kwe kubeera nga abalina obiganyulwamu bajja kubeera nga babifunamu bulungi nnyo. Era nga in his conclusive remarks era ategeeza natugamba nti nno teri muntu amaliriza bulungi nnyo nsonga za musango okuggyako nga wabanga ayise mu ngeri y'okutabaganya abeera agenda azimaliriza mu ngeri gy'agenda okubeera nga agiganyulwamu n'eggwanga lyonna. Era n'ategeeza nti nno akawaayiro mu mateeka 129 of the Constitution of the Republic of Uganda kateekawo kooti eza Kavi Courts, era nga zirina okukola okusingira ddala ku nsonga z'ebyobusika n'ensonga ez'obufumbo, era nga naffe nga abasiraamu tulina okugezaako okulaba nti tuzijjumbira era tuzettanira. Mpozi munzikirize nate, at this particular moment we are having another speaker who is our brother, Dr. Omar Hussein, the Secretary General of the OIC, and allow me to say little about him as we call him to give us his remarks. Dr. Omar Hosseini holds a bachelor's degree in common law and Sharia from the University of Horin, Nigeria, and also holds a master's of comparative law with distinction from the International Islamic University in Malaysia. He has a PhD from International Islamic University of Malaysia, He also holds a postdoctorate fellowship from Harvard Law School, specializing in dispute management. And he has a professional Masters of Law in Financial Laws, York University, Ontario, Canada. He also a visiting fellow, Islamic Legal Studies program, Harvard Law School. He's a Harvard certified negotiator and dispute resolution expert. He's also a member of the Nigerian Bar Association and Canadian Bar Association. He has previously served as the Executive Director, Legal and Compliance, and acting as Chief Executive Officer of the IILM. At this juncture, allow me to call upon our brother, Dr. Omar, to come and give us his package. Doctor, you're most welcome. What I didn't tell you, Doctor is going to present virtually, and you can unmute yourself and proceed, Doctor. Can you please come closer to the mic? We cannot hear you. It's still very low, Doctor. Doctor, you have to work on your audio.
My side.
Thank you.
Can you hear me now? Can you hear me? I want to be sure everybody in the room there can hear loud and clear.
Yeah, Doctor, we can hear you loud and clear.
Okay, excellent. Excellent. Yeah. Assalamu alaikum wa barakatuh, and a very good morning to you all. It's really a pleasure to join you this morning from Geneva, where I'm attending some high-level meetings. And it's really great to be part of this great event, People on Justice Summit. And it's my singular honor to deliver this special address on the role of county courts in effective dispute settlement. And before I proceed, I would like to thank the organizers, my very good sister Zubaydah, and the entire team, and of course the leadership of the Muslim societies there, the Qadi, courts, the judges, and all the participants. And thank you very much for having me today. And I'll try to keep to the time because I do have some other meetings this morning here. Now, let's actually look at this. What does true access to justice mean? And I think it's really important to kind of determine what justice or access to justice mean. Now, does it mean one size fits all? Do you just need to have courts generally in the country, in Uganda, and not actually having specialized courts that will cater to the needs of specific groups of people in the country? Or does it mean providing mechanisms that are accessible, affordable, and culturally relevant to the people they serve? So this is really important. We have to kind of understand the whole concept of legal pluralism. And Uganda's strength is its diversity, which includes religious diversity. And for the significant Muslim population, matters of personal status like marriage, divorce, inheritance are deeply intertwined with their faith, I mean Muslims, and of course their identity. And this is not just unique to Uganda. It's also the same situation you have in other countries. I can tell you of Nigeria, where I originally come from. So it's important for us to understand the whole concept of legal pluralism and access to justice when we discuss the role or potential role of county courts. And I'm going to give you a pathway forward today, inshallah. I'm not here to just talk about problems. I'm here this morning for the next 28 minutes to kind of give you a pathway. Hopefully, this will actually open more opportunities for the Muslim community to have more access to justice in line with their cultural values in Uganda. Now, the courts are not a parallel system. I've tried to understudy, the operation of courts there, and I've also looked at the Ugandan Constitution of 1995, and I'm going to kind of refer to some specific aspects. I overheard my very good brother who actually introduced me a while ago mentioning at Article 129, even though he was speaking in the Ugandan language, I could pick that up during his remarks earlier. So the courts are not just a parallel system, but they are an essential component of Uganda's justice landscape. Their effective operation is critical for fulfilling the constitutional promise of access to justice for all, but their potential is currently unrealized. So when you have this, when it was introduced in 1995 into your constitution, it was not just a mistake. Those framers of the Ugandan constitution wanted to broaden access to justice for all. And this is relevant to a country where you have a pluralistic kind of legal system. Now, we have referred to Article 129(1)(d) in particular of the 1995 Constitution of Uganda, and I'm sure you know this better than I do. It explicitly provides for the establishment of courts by the parliament, again, to handle matters of marriage, divorce, inheritance of property, and of course, guardianship under Islamic law. These are all generally kind of classified under what we call Ahwal al-Shakhsiyat, Islamic personal law. Of course, this is part of the British colonial heritage. So if you go to other countries colonized by the British, like Nigeria, you'll find the same thing in the Nigerian constitution. So it's not so different from what you have elsewhere. So I can easily relate to this as a lawyer trained in Nigeria. So that's fine. Okay. Now, as I said earlier, this wasn't an accident. The Constitution's framers recognized the unique need for a specialized forum to handle personal law matters for Muslims, respecting their right to practice their religion. And I'm sure you all know Article 37 of the Ugandan Constitution on the right to practice your religion. So this is a right. Now, what is the problem here? This is the core tension. We have a clear constitutional provision, but there's a legislative gap which has not been filled. The parliament has not yet enacted a specific law. The code. Non-Muslims in Uganda, yet they have to recognize that when there is peace and harmony through effective dispute resolution among the Muslims, then there will be peace in the country as well. Peace in the country as well. So we should be our brothers' keepers, whether you're a Muslim or a non-Muslim. Let's work together. Inheritance is a very complex thing in Islamic law. The whole inheritance is a very complex thing in Islamic law. The whole aspect of fara'id or al-mawarith, there are a lot of calculations. You have to ensure that you get it right. And these rules are actually, guided by scholars, the imams, the mashayikhs, who are the local sheikhs. So this is extremely important. It's not just that, okay, you just write a will and that's all. No, there are kind of Quranic principles, formulas that have to be respected. And you can only learn this from the mashayikh, who are the sheikhs and the imams. Now, let's look at the formal system you have, the judicial system you have in Uganda, and the kind of recognition we're talking about. Of course, the High Court rulings, as I've read, based on my readings of, some
Recording
of the
in progress.
on this. Now, the High Court rulings have cited the constitutional provision to uphold the legality and binding nature of decisions made by these informal courts, which is okay. And I think this is highly commendable. And this confirms their necessity. But also, they highlight the precociousness of their informal status. So we need to still find a solution. Whatever temporary solution you have is not still good enough. So it's either they proceed to enact the bill to formalize these courts, or we think of alternatives. Now, we don't have the time to waste, so that's why we have to start thinking of alternatives. And of course, when it comes to effective dispute resolution, this is the It Matters section of the discussion today. Accessibility is important. Cultural and religious relevance is important, because these are Sharia courts, they have to be relevant. And of course, we have to emphasize on reconciliation, sulh. Allah subhanahu wa ta'ala tells you, God Almighty tells you, وَالصُّلْحُ خَيْرٌ, that effective reconciliation, dispute resolution is the best in all situations. This is a verse in the Quran. And Muslims believe this comes from God Almighty. This is the word of God, our creator. So, unlike the often adversarial formal thing, Islamic dispute resolution heavily favors mediation, reconciliation, which is sulh. Now, the goal is not just to issue a verdict, but to repair families and community relationships, which is more holistic for us, basically, as a form of justice. And of course, this will help decongest courts, the formal courts, when you have the courts operating. So this is extremely important for the policymakers in the country, the lawmakers in the country, to identify the need to enact a bill to kind of formalize this. Now, the critical challenge remains informality. Now, let me pause here to kind of give you an idea of dispute resolution in Islamic law before we go into the path forward. Really make sure I give you the path forward, and you, the policymakers, you take it from here. Now, in Islamic law, generally, there are several methods of resolving disputes. Unfortunately, people are not aware of this. I remember back then, during my postdoctoral fellowship at Harvard Law School, when I came up with, the different processes. Of course, people know mediation, arbitration, but we identified about 8 different ways of resolving disputes in my research then. Now, the first one, which was developed based on my PhD research, was an-nasiha. An-nasiha, basically, it's counseling. You counsel parties to avoid a dispute, ultimately. So this is what you call a dispute avoidance method. It was during my PhD research I developed this and added it to the list that was existing earlier by my supervisor. So I had to take the research forward from what my supervisor did, and he was really pleased with it when he saw, oh, this is a new one. I said, yes, we have to start with preventing disputes through an-nasiha. And there's a hadith back in this where Rasulullah talks about ad-din an-nasiha, that religion is actually, counseling, is advice, to whom, the hadith continues like that. So it's extremely important. Based on that hadith, we developed this process of preventing disputes. So that's a process of dispute prevention. One will be al-qada, which is the court adjudication, like what we're talking about today. Formal court system, they see it to resolve disputes. Of course, you also have what they call at-tahkim. At-tahkim is arbitration. Of course, arbitration, I'll come back to arbitration later. I know you have a new law enacted in the year 2000 on arbitration, which is substantially based on the ancestral model law. So we'll come back to that law later, and we'll look at how we can structure something within what you have today to be able to implement, the courts kind of processes. So of course you have a sulh, which we mentioned, which is mediation, reconciliation, and you have mazalim. Mazalim are specialized courts that are meant for serious cases, or maybe for financial and economic crimes, and you don't want this to go public, basically. So mazalim, these are the kind of specialized courts. And of course, you have the med-up process, which comes from mediation and ends with arbitration. And you have the basis of all this in the Quran and in Hadith or the Sunnah, which I call prophetic precedents. That's what I call Sunnah. Now, from there you move on, you have what they call fatwa of a mufti. When a mufti gives a fatwa, that fatwa is meant to do 2 things, either to prevent a dispute or to resolve a dispute. Now, resolving could include mitigating the impact of a dispute. So the mufti is not just you give a fatwa or whatever, an advisory opinion, it goes beyond. So we've been able to structure it or restructure it into a dispute resolution process in Islamic law. So this was back then in my research in 2009 and 2011 at Harvard. We came up with all these processes. Now, going back to the path forwards, I'm conscious of the time, even though I wish to discuss more. And in terms of what do we do today? Of course, the easiest solution is to enact of course, this negotiable step. So if they can do it, fine. That will solve the whole problem. The parliament should consider fulfilling its constitutional duty. Since the provision says these courts are recognized, but the parliament needs to enact the law. Of course, we look forward to that. That's one. Now, the courts should be recognized as courts within the Ugandan judiciary, just like magistrate courts, and their decisions must be appealable, within the formal system as well. So there should be a kind of a system, and there is a kind of, precedence for this in different countries. Even in Malaysia, you have the appellate system for Sharia courts, which is separate here from the beginning to the end, to the apex courts itself. So these are things that can be considered also for Uganda. Now, let me pause here to look at what alternative path do we have. In the interim, if we do not have the courts, we do not have the law passed by the parliament, what can we do? Now, let's look at the comprehensive legislation that governs both the domestic and international commercial arbitration. That is the Arbitration and Commission Act of the year 2020 of Uganda. Now, Uganda has this comprehensive statute, and it governs both domestic and international. I mean, it's really good. So we focus on the domestic part now because we're talking about resolving disputes. Of course, we bear in mind the jurisdiction, of inheritance, marriage, and all this. Of course, that's fine. So we have to look at how we can fit into this law. And if we cannot actually have that yet, what about commercial disputes? I know Ugandans are actually commercial people, particularly the Muslim community. You've got a lot of businesses. How do you resolve these disputes? Do you just go to the normal courts? So let's look at a possibility here. Now, what we can do is when you look at I think the Arbitration and Conciliation Act, Section 29, basically, party autonomy is very important in arbitration. Now, if parties actually come together and stipulate that Islamic law is going to be their governing law of their contract, then that will prevail. Because Section 29 of the Act says parties the arbitral tribunal shall decide the dispute in accordance with the rules of law as are chosen by the parties, as applicable to the substance of the dispute. Now, if that is the case, if parties explicitly choose Islamic law as the law applicable, then that applies. So that's very important. We can bear that in mind even for commercial disputes. So our scholars, our lawyers can actually see it. You can do it under the MAMC, MAMAC, and to resolve disputes, that relate to commercial transactions. And these can be enforceable under the arbitration legislation in Uganda. So this is something very important we may consider, at least for commercial disputes. Now, for other disputes like family disputes, then we can actually consider some other processes. So it's important for the Ugandan Muslim community to look at, yes, we have current challenges. How do we kind of resolve some of these issues based on what we have today? While we push ahead for the enactment of the bill at the parliament for the courts, let's actually consider what we have in our hands today. A bird in hand, what's 1,000 birds in the bush? So we've got to look at how we can implement our kind of processes through the framework we have in our hands. So this is where I think commercial disputes actually can be resolved through arbitration. So Mama can handle this easily under our sister Zubaydah. So this is very clear. Now, for other disputes, then we can actually think of how we can, consider them within the framework we have today. But again, ultimately, I think it's important for us to ensure that ultimately we try to amend the existing legislation. Now, in conclusion, we have to recognize that we're in a pluralistic legal system, and the efforts of the team basically to try to resolve this. I think it's extremely important to resolve this puzzle. What I would call a puzzle is very important. Formalizing the Kurdic courts is not a threat to Uganda's secular identity. It is the fulfillment of its constitutional promise. This was very clear in the 1995 Constitution. Now, it is the key to unlocking an effective, accessible, and culturally relevant justice system that serves all Ugandans. I'm going to stop here and, if possible, to take some questions from the audience. And I think it's important I deliberately stop 5 minutes to the end so that I can take quick questions before I end the whole session. Thank you so much for this opportunity, and I would like to congratulate the team again, our sister, Zubaida, and the entire team over there for this wonderful conference. And I look forward to again visiting Uganda. I had a great visit during my, the last, visit a few months ago, and inshallah, I hope to be there again soon. Thank you very much.
Barakallahu fikum. Dr. Oseni, thank you so very much for that brief but very insightful breakdown and starting us on very well on our why. You did ask to have a few questions, but like we mentioned, we do have an audience that is virtual, and I would first like to break it down for them in a local language. Then we get the questions in a few minutes from the virtual audience and the ones in the house. Mwebale nnyo okusigala nga mukyalina ffe paka kati. Omwami ava waggulu awo okwogera bamuyita Dr. Oseni Omar. Omwami mu Nigeria naye ng'atuula e Bungereza ne mu nsi z'ebweru nga atuula mu kitongole kya Organization of Islamic Cooperation naye ng'atwala ekitebe ekya arbitration. Era ensonga etutuuziza wano era etulese wano leero. Omwami ayogedde n'atukakasa nti tuli ku mulamwa era n'atutegeeza nti ekintu kye tuliko ekyokufuna obwenkanya mu ngeri endala ezitali mu kooti nga bwe tuzimanyi traditional court system si kipya era kiri mu mateeka. Era n'atukakasa nti ensi endala ezimu nga Nigeria ewaabwe gy'ava kyatandika dda era kiri mu nkola. So n'atukakasa nti naffe tetuva ku mulamu ogwo. Ayongedde otukakasa nti enzikiriza n'obwenkanya tebina kontana bitambulira wamu, era bwe tuba nga tutandise nga bwe tutandise ne tutandika bulungi ne tugonjoola abakola amateeka n'abagakozesa, tebigenda kufuna buzibu kuba bigenda kuba bitambulira wamu. Dr. Oseni atukakasizza nti ssemateeka wa Uganda owa 1995 yalambika bulungi ensonga ya Kurdic courts n'obwetaavu bwayo. Era n'agamba nti abaali emabega w'ekirowoozo ekyo eky'okuteekawo Kurdic courts baali tebanyumyamu bunyumya naye baalaba nga waliwo obwetaavu okutuusa obwenkanya ku bantu abwetaaga mu ngeri gye bategeera era ebakoleranga bo. N'atubuulira history entonotono ku ngeri obwenkanya buno gye buzze nga bukolebwamu okuviira ddala mu zi hadith n'amasomo g'asomye okutandika ddala ku yunivasite ezo ze tumanyi eza waggulu nnyo nga Harvard, era n'amasomo gamu yakola nga yeekennenya engeri y'okufunamu obwenkanya n'okutabaganya abantu okuviira ddala mu Quran. N'atubuulira about anasiha obwali badde nga gye tuyita counseling. N'atubuulira okwewala obutakkaanya nga tebunabaawo, that is preventative or dispute avoidance. N'atubuulira about a tahtim, that is arbitration, gye tugenda okusoma mu bungi bwayo olwaleero mu session eziddako awo. N'atubuulira about asul, which is reconciliation, oba okutabaganya abantu. N'atukakasa mu bimpimpi nti obusiraamu n'amateeka ge tugenda okutegeera olwaleero Uganda gezaako okutongoza tebyawukana era byava dda nga bikolebwa naye era nga byetaagisa paka n'ebiseera bino bye tulimu. N'awunzika ng'atugamba nti yadde Uganda tennatuuka ku kiruubirirwa kya kufuna kadhi courts mu butongole, waliwo emiwaatwa emirala gye tusobola okukozesa. For example, lino etteeka gye tugenda okuyita ACA, okuva n'essaawa ya leero tugenda liyita ACA, Arbitration and Conciliation Act, eryakayisibwa mu Uganda, nga liyambako abantu bonna nga si basiraamu bokka okufuna obwenkanya wabweru w'amakooti nga bwe tugamanyi. Kati bwe liri ttongole, ate etteeka eryo we liba baalikola baba baatunuulira amateeka g'ensi yonna. It's a global law. Right now, liyamba amateeka nga bwe tukyalinda kadhi courts okuba nga gakola ki? Gabeera nga galina ensa nti omuntu weba asaazira ekiteeso kiba kiyitiddwa mu ACA oba Arbitration and Conciliation Act, naddala mu by'obusuubuzi kubanga tuli mu kyasa where trade is global. Nti bifo ky'okulinda kadhi courts okubeera nga ziri formalized mu Uganda, tusobola okwekwasa etteeka lino era nga bwe tugenda okusoma mu sessions eziddako ne tulitegeera bulungi ne ligira nga lituyambako. Era n'awunzika mu bumpimpi ng'agamba nti ekinyonyi ekimu ekiri mu ngalo kye tulinawo kisinga 1000 ebiri eyo ebikyali mu bbanga. So tukwate kye tulina nga bwe tukyanoonya kye tuluubirirwa tujja kutuuka. That is what Dr. Osen has said in summary, and he has requested for 1 or 2 minutes so he can get questions. We have an online team, but also we'll take in-house. I will ask my co-MC to pass out a mic for the in-house questions before he leaves us. Dr. Osen, we are so grateful. You have handheld Mom from birth. You are here in person in March. You gave us your time, you gave us your money, you gave us your wisdom, and here you are again trying to take us through our crawling stages as we aspire to justice that is restorative. The first question from the audience is, what are Dr. Osen's key recommendations to Ugandan Parliament as it drafts law that establishes kadhi courts? Dr. Osen, what are your key recommendations in a few minutes? And also part 2 is what should be avoided. Thank you very much.
Thank you very much, sister. And when it comes to drafting of a kadhi bill, I think it's important to kind of ensure that the inherent jurisdiction, and I think I need to emphasize on this, and I want everybody to carefully listen to this, because, and I'm speaking from the perspective of someone who has read most of the books relating to Adab al-Qadi. Adab al-Qadi means the code of conduct of judges. I've read these books in Arabic. I've studied them in my research for many years. I mean, since 2009, to date. Part of the inherent powers of Sharia court judges or judges in Islamic law is amicable dispute settlement. So when you sit as a judge and you see parties before you and they are kind of arguing and you feel this dispute can be resolved amicably, it's your role as a judge to encourage the parties to do that. So we've got to be careful when we draft a kadhi courts bill to just kind of formalize it like the English courts. We have to ensure we include provisions relating to court-annexed amicable settlement, where judges will immediately see, no, this is a simple dispute. Parties you can resolve, or you try to go and resolve amicably, maybe through an arbitration center or mediation center, and come back. If you're able to resolve it, then we can have a consent judgment and proceed. So this is important. So note this, part of the inherent powers, because when Allah subhanahu wa ta'ala talks about wasuluhu khair, it actually includes even judges when you are in a formal court, that sulhu actually can still be pursued. And you see this trend now globally, even in the English court in England, in Pakistan, when I went there, even at the apex court, judges are encouraging parties to go and settle if they can settle. But when I see this, I said, wow, this is something I've read in books in Islamic law in Arabic, written many centuries ago. So it's important to consider this. Okay, we won't call the cost in, they are standard costs. Ensures the whole process completely Islamic law. So this is why effective dispute settlement is key. Even when you have the court should be court where judge as consent judgment, or a situation where the disputes are referred to a private dispute resolution center and they come back. We have models for this. My entire PhD was on this topic many years ago. So I think it's something we should consider. And the parliament, again, should consider this as an urgent step to be taken to ensure and fulfill the yearnings of the Muslim community in Uganda. This will help the country stabilize more. It will help the country deepen its democracy once the yearnings of Muslims are achieved in Uganda. Thank you.
Thank you very much, Dr. Singh. There was a part 2. What should be avoided?
Oh, what should be avoided? I think I've mentioned that partly, that let's try not to be establishing English-style courts in the name of Sharia. I think this is really important.
Thank you very much.
Don't have, because you want to have Qadi court. Yeah, so let's try to avoid the situation, because we've seen this elsewhere, where the courts kind of, they are Sharia courts, but the whole process from beginning, all their procedural things are actually based on English common law.
Thank you very much, Doctor. As we wait for in-house questions, I'll summarize in Luganda. Ekibuuzo ekibuuziddwa kibadde kibuuza Dr. Hussein nti Uganda nga yeetegeka okuwandiika amateeka gano okuteekawo Qadi courts, atuwa amagezi ki biki tusobola okukola ebyo tulina okukola ne bye tutalina kukola? Bye tulina okukola, Dr. Hussein atuwadde amagezi nti abalamuzi bennyini ababeera mu kooti zino bwe baba nga bafunye omusango ne bagwekenneenya ne balaba nga tegwalisaanye genda mu nkola eri enkadde, babeere basaale mu kukumaakuma abantu okwettanira kooti zino eziri outside traditional courts. Kyatugambye kye tulina kukola nga twala Qadi courts zino mu maaso ne ADR, tetukola copy and paste, tetutwala bintu nga we byali, tuleme kubeera lezi banafu mu kulowooza ne mu kusengeka ebyaffe ebitugasa, tukole ebyaffe ebinaatuyamba nga tetukopye ebyaliwo. Are there any other questions in the house? Yes, please, go ahead.
Yes, thank you so much. I want to thank first and foremost Dr. Umar for the wonderful presentation that he has offered to us. And this is very good. We are now discussing in his presentation, we looked at the Article 37 in the Uganda Constitution of Law, which says that someone has a rule or has a freedom of practicing and executing his religion into practice. So I want to ask Dr. Umar, here we are having the Uganda Constitution, which was amended in 1995. Here we are having the Muslim Arbitration and Mediation, the Arbitration and the Conciliation Council. How are we going to make sure that these two, they don't conjugate? We have the Muslim side, we have the rules that were being amended long time ago in 1995. How are we going to be guided to see that we don't conjugate the two, so that this someone who is coming with an Islamic ruling does not compete with a constitutional rule that has been put in place? Thank you so much. Assalamu alaikum.
Wa alaikum salam. We didn't get your name. I will wait for Dr. Hussein to come back, but to give you comfort, your very question is the reason we are here. If you look at the program and you look at the speakers and the topics, I am confident that question will be answered before the day ends. Now, let's wait for what Doctor has to say. If we have technical challenges, because he said he was...
Yeah, I think if...
Go ahead, sir.
I'm here.
Yes, Doctor, please go ahead.
And that's why we have given the recommendations we made today. You've got the provision. You have the provision relating to freedom of religion, freedom to practice religion. Of course, people can say practice of religion doesn't include having courts or resolving disputes. But again, Muslims, we say it includes this. We must have this. So I think, and that's our conviction. So, and that's very important. So I don't think there will be any conflict. But again, as much as possible, and I'm sure you're going to have a discussion later today, I mean, for the whole day, and that's why we are here, as you rightly said, we have to ensure there's no conflict between the Constitution and the judgments we're going to have or the rulings we have. Yes, Muslims have the freedom to practice their religion. They have the freedom to even have private settlements. And this can be enforced voluntarily even among the Muslim community. So there are different ways to kind of do things, as how we can actually fit into or adapt our principles into the existing legislative framework of Uganda. And I think we can do that. Thank you.
Thank you very much, Dr. Oseni. Thank you very much, audience. I understand that this is the first of many questions to come. I sincerely believe that as we go along in the day, there will be questions. We want to assure you that every panelist, every speaker is part of us. Should you remember a question after, for example, Dr. Oseni has gone offline, please contact the Secretariat, share your comments, share your thoughts. They are welcome. Like we said, unlike the last time we were together, this is a serious summit. We want deliberations, we want your thoughts, we want your fears, we want to allay them. So let us make this useful and impactful and make our time here worthwhile. So thank you very much, Dr. Oseni. Let's give him a hand of applause.
Thank you. Thank you.
And going by the program, we're supposed to get onto another panel where we are going to discuss exactly where he has set us off on. That is the Kadi courts. But I just want to remind you, we are here for the whole day. We do have health breaks. We do have teas and some nourishment. And we will let you know when the time comes how we'll go about this. Looks like we have an influx of attendees as they settle in. Greet your neighbor as we prepare for the panel discussion. And again, my only request to you and to our online audience is to take this discussion very seriously. Deliberations from this will be taken into account. We have members of parliament, we have members from the judiciary, we have leadership of the Ummah. So we are not just having conversations. And our first panel today is going to discuss exactly where we have left off. That is Kadi Unwritten, turning a constitutional promise into practice. I hope the gentleman who asked the last question will have his responses from this discussion. This panel has been very delicately selected. As you are aware, this conversation is still ongoing at a national level. And whatever input we make from this conference or from this summit will feed directly into what we will see as successful or unsuccessful when it comes to implementation. So the person that's going to lead this panel is none other than Counsel Wanjui Zakia. Zakia is an advocate and a founding partner of Wanjui and Partners Advocates. She's the Secretary General for Uganda Muslim Lawyers Association. And she's very, very well suited to guide and lead this panel. I will invite her here to introduce her panelists. Then we will get this conversation going. Thank you very much, and enjoy and learn.
Assalamu alaikum wa rahmatullahi wa barakatuh. Good morning, everyone. I welcome all of you here. Karibu sana for those joining us here from Kampala and then across the world. We have participants from Kenya, Nigeria, Geneva, Boston, and UK. Thank you so much for joining this vital conversation on justice that bridges communities and constitutions. Our theme, Uncovering Gaps, Exploring Solutions. Our panel is going to dive into Kavi Court's unwritten, turning a constitutional promise into practice. I would wish to first dive into the history, briefly the history of Kavi Courts in Uganda. The journey for Kavi Courts in Uganda started way back in 1840s when the Arab traders introduced Islam in Uganda. Unlike Kenya, Tanzania, and Zanzibar, where the introduction of Islam was accompanied by the introduction of Muslim courts, and they continued to operate even during colonialism, such courts were never introduced in Uganda. But there were particular provisions that were made for the recognition of Islamic marriages and divorce as legally binding even during the protectorate government. In 1988, the Ugandan government embarked on redrafting the constitution, and it appointed the Odoki Commission, that was the Constitutional Commission, to walk all over the country and collect views that were seen as viable to be addressed in the new constitution. And the Constitution Commission was headed by Mr. Benjamin Odoki, hence the name the Constitutional Commission. The Odoki Commission, to that effect, during the collection of those views, Muslims submitted their views, and the Constitutional Commission made recommendations to that effect. One of the recommendations of that Odoki Commission, it recommended that extensive research was needed before Sharia courts were introduced in the Constitution. So the result was that the Odoki Commission did not recommend that Sharia courts. It did not recommend the Sharia courts that they would be introduced in the Constitution. It also did not recommend that the Constituent Assembly delegates should have an opportunity to deliberate or debate on the matter. However, during the Constitutional Assembly, some members, the delegates therein, for example, Mr. Nsambu, deliberated on the introduction of Kavi courts in Uganda. And one of the reasons given for the need to have the such courts in the Constitution was that the 1966 Constitution was silent on Kavi courts, and that although the 1906 Marriage and Divorce of Mohammedan Act had given power to the Minister of Justice and Constitutional Affairs, which powers would be interpreted as giving him chance to introduce constitutional court, to introduce Kavi courts. Such courts were never established in Uganda. The proposal, those in the proposal of the Kavi courts had the zeal for it, but the proposal met severe resistance from some quarters for several reasons and was defeated on 2 occasions. On the 3rd occasion, it was successful, and a provision on Kavi Court, Article 129(1)(d) was included in the Ugandan Constitution. That article goes, no, it was included there. The first attempt, let us first look at the challenge that we had during that assembly. It is that those submissions had one inherent challenge that called for the recognition of Sharia courts with the jurisdiction over almost every dispute between Muslims. This would have meant that establishment of an Islamic judiciary which interpreted and applied Islamic law, and a secular judiciary which interpreted and applied secular law. So this could explain why the Odoki Commission sought it fit to clarify the position of Islamic law in Uganda in the following terms. It stated that Islamic law is applied in Uganda at present mainly
in personal matters such as marriage, divorce, inheritance. That's what the commission stated. So we had 3 attempts. That was the first attempt. And the second attempt, we had members, delegates like Mr. Nsambu and Mr. Nsambu and Mr. Migadi. They really fought and had it that the Constitution takes it into consideration to have the Kavi courts applied in Uganda. Ever since, in 2003, the government of Uganda appointed the Constitutional Review Commission with the mandate to gather people's views on whether different aspects of Constitution could be amended. So the Constitutional Review Commission came up. The Constitutional Review Commission came up with 2 bills. So far, we have had 2 bills: the draft bill of the draft Kavi Courts bill and the draft Administration of Muslims bill. We have had those 2 bills, but they remain not operationalized. Up to now, we find that Uganda's 1995 Constitution, So up to now, the 1995 Constitution, we have the article, but the law remains unwritten, and we feel it is the right time for action. I have my panelists, which I believe are going to deliberate much on the issue today, and I now take this opportunity to introduce my panelists. The first panelist I have is Honorable Asman Chiinji. Honorable Asman Basalirwa. Right. Sorry. Honorable Asman Basalirwa is a trained lawyer by profession, and he's a partner at Sewankamba and Company Advocates. He obtained certificate in international humanitarian law from University of Pretoria and a master's degree in law from Makerere University. He has served as a university secretary of Zambia University in Uganda, and his areas a leader of opposition party of Justice Forum, JEMA, since 2010. He was elected Member of Parliament of Bugiri Municipality in 2018 and re-elected in 2021 general elections. In Parliament, he has served as Deputy Chairperson of Public Accounts Committee. He's known for his strong stance on moral and social issues, emphasizing constitutionalism, integrity, and economic reform. He has been prominent in pushing legislation such as the bill that became the Anti-Homosexuality Bill, the Anti-Homosexuality Act 2023. In his role, he has often spoken about youth empowerment, governance, and accountability. Honorable Asman Basalirwa is the man behind the draft bill of the Kavi courts in Uganda. Ladies and gentlemen, allow me to welcome Honorable Asman Basalirwa. Honorable, I welcome you to take your seat. Our second panelist is none other than Dr. Walusimbi Abdul Hafiz. Dr. Abdul Hafiz Walusimbi is an associate professor of Sharia Islamic Studies with qualifications in education, project management, Islamic banking, and finance and law. His work experience started way back as a secondary teacher and progressed as a university lecturer. He heads the Department of Sharia at the Islamic University in Uganda. He's also a director of Al-Haq Sharia Consultancy and Advisory Bureau, which deals in research, consultants, advocacy in Islamic banking. Dr. Wausimba, as an academician, has authored and published articles in areas of legal reference to DNA in paternity disputes, international humanitarian law, and human rights. Ladies and gentlemen, believe me, I cannot exhaust his bio, but due to the limitation of time, I pray to stop there. You are welcome, Dr. Wausimba. The third panelist is Haji Musana Sulaiman. He's currently a protocol officer at the Uganda Muslim Supreme Council. With experience, he's an associate with the Directorate of Sharia at the Uganda Muslim Supreme Council, an investigator and a mediator in Muslim marriages and disputes. He's also currently pursuing his degree in conflict resolution and peace building. He's a public administrator. He holds a public administration and local government diploma. He also holds a diploma in mass communication and journalism. He has authored books, and one of his books is a brief on Shuhada'u of Muslim matters in Uganda. Mr. Haji Musana Sulaiman is standing in for the Director of Sharia at the Uganda Muslim Supreme Council, Dr. Ziad Lubanga. You are welcome, Honorable Musana Sulaiman. We are going to take, I'm going to first request my panelists to have opening reflections, then dive into targeted questions. I will then open the floor for your insights, and then wrap up with actionable takeaway points. We are going to keep within 40 minutes to enable us energize the rest of our summit day. I'm going to start with Honorable Asmani Basalirwa. It's okay. Honorable.
Thank you very much, Madam Chairperson.
Before that, Honorable, let me phrase the question. Could you share just a 2-minute reflection on why Kavi courts matter to you and Uganda today?
Thank you very much, Madam Chairperson. First of all, I am happy and glad to be back home. I worked for this institution from 2006 to around 2014, Dr. Kasule, was it 2014 or 2015? And I taught here. I taught at the females campus. I also taught at the main campus with Dr. Hafiz here, Justice Sekana, Dr. Sowedi, and who else at that time. So I am really glad to be here. But more importantly, to delve into the question straight away. The issue of Kadi courts does not only matter to me, but to every Ugandan, both Muslim and non-Muslim. Because I think it's in the interest of Ugandans to see Muslims happy and comfortable. Being a secular society, we need to amicably live with each other. So as Muslims, what makes us happy and comfortable is having a legal regime that protects our interests. So having Kadi courts is not a matter of interest for only Muslims, but every Ugandan. That's why the framers of the 1995 Constitution saw it fit to include Article 129 in the Constitution to provide for Kadi courts. So my interest, and indeed the interest of many Ugandans, is that the Constitution must be operationalized. It is not enough for a Constitution to have provisions, but those provisions must be operationalized. So the idea of having Kadi courts is a constitutional imperative. It is an imperative that we must fulfill as Ugandans. And I want to say it has been a disappointment, it has been unfortunate that since 1995, Article 129 has never been operationalized. I am aware of the efforts that have been in place, but you know there have also been many obstacles. Maybe along the way we will be looking at them. So, without even delving into whether this is a piece of legislation for Muslims or not, or non-Muslims, this is a constitutional issue. And it should be in our interest, all Ugandans, to ensure that constitutional provisions are operationalized through what we call enabling laws. And that process can only be undertaken by two entities, either government bringing in Parliament a bill.
Honorable, we have 3 seconds.
Either government bringing a bill or a private member bringing a bill. And that's precisely what has happened. I thank you, Madam Chairperson.
Thank you so much, Honorable. I can see the legislative momentum feels electric. Barakallahu Fek. Dr. Abdul Hafiz Wausimbi, kindly take us through on the reflection why Kadi courts matter to you and Uganda as a whole.
Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Wa afdalu salati wa atammu taslim ala Sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Assalamu alaikum wa rahmatullahi wa barakatuh. Briefly, I could say, if my fellow panelist has looked at it from the legal constitutional perspective, I could look at it from the faith spiritual perspective. The Constitution of Uganda grants Muslims their right and freedom of faith as well as expression. I think what is missing in many people is that for us, anything to do with Muslim personal law is a form of worship. So it is from that background that my reflection could be, if the establishment of Kadi courts, it is meant to offer Muslims an opportunity to decide their matters in accordance with the dictates of Quran and Sunnah, to me, I feel that it is long overdue. Muslims really need that kind of a system whereby from marriage to divorce to other matters, they are decided in line with their faith. And that's why I'm very passionate about this. Thank you so much.
Thank you so much, Doctor. Haji Musana.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam.
First of all, I bring you apologies from our Director of Sharia, Dr. Ziad from Uganda Muslim Council, but I'm happy I am here. Why it is very important for the Kadi court to be passed and operationalized, I want to say I started as a DAI way back in 1979 when I joined the Supreme Council from the grassroots. And I've been watching what is happening. And when I joined the headquarters, that is 2000, I've been watching yesterday and today what is happening in as far as freedom of worship and the importance of this operationalization of this bill. I want also to say, to look at before Uganda became independence, our sheikhs, all the old people by that time, when you compare that time in 1906 and today, when the Islam was introduced here in 1840s, by our sheikhs, during the colonial time, they had to come up with something as a law to support the practice, especially when it comes to matters of. That's why we have 1906 Mohammedan and the Marriage and Divorce of Mohammedan Act. And of course, before we can come up with this bill which we are discussing, I think today is helping us much, because you can imagine today our daughters, when they go to court using the secular law, that if you don't have a marriage certificate, then the marriage is what? And I can tell you they are suffering. But for us, when you go to, which is universal actually, because Islam is universal, where the marriage is registered, also know, once the 5 pillars, which takes place before marriage is taken, okay, it is a valid what? Marriage, whether it is just or what. So, with all those experiences, I really say, first to thank, especially Honorable Asuman Masalirwa and the team behind, and also those behind it, today's workshop. Indeed, we need this law. I think it must have been yesterday, not tomorrow. We really need this because it is really, when you go to that article of freedom of worship, somewhere we may not be comfortable until we process this bill. I thank you.
Thank you so much, Haji Musana. We are now entering into the questions pertinent to the topic. Honorable Basarirwa, your recent success in securing leave for a private member's bill, we are seeing it as a game changer. We congratulate you for that. What inspired this push now, and what key provisions in the bill, the drafted bill, would address the constitutional gap in Article 129, 1D?
Well, thank you very much. First of all, I want to be grateful to the Muslim leadership in the country. We were greatly inspired by the Muslim leadership. I'm aware, for example, that Muslim leaders have been coming to Parliament in different committees. They've been interacting with the head of the Parliament. I recall at the last Iftar dinner, in the speech that was delivered by the Uganda Muslim Supreme Council, there was a provision in that speech. There was a call and a request from that speech where the representative of the Uganda Muslim Supreme Council enjoined the Speaker to ensure that the Kadi Courts Bill is actually tabled in Parliament. And those who attended that Iftar dinner, you recall the Speaker saying that that is a matter that we should be able to handle with the Muslim leadership in Parliament. So on the basis of that, I reached out to the Speaker, and the Speaker gave me a go-ahead. We drafted the motion. We consulted with some of you here. We had a draft bill, and we were able to get seconders from across the board in Parliament. You know, Honorable Joseph Sewungu, those of you in Parliament that day, was one of the passionate seconders of this bill, because we wanted, and we still think, that this is not a matter for Muslims alone. This is a national issue, it's a global issue. So on the basis of that, we were able to get on the order paper We moved the motion. It was unanimously seconded, and for the record, even the acting government chief whip in Parliament on that day, the Honorable David Bahati, stood in support of the motion. So we were driven by the leadership, but also the fact that we are Muslims and the fact that we realized there was a gap. You recall, Parliament about 2-3 years ago, if I may recollect, did pass the Succession Act. Now, when we were debating the Succession Act, we discovered that there were many aspects in the Succession Act that actually conflict the Muslim faith. So we agreed to have a provision in the Succession Act to exclude the application on Muslims. But that exclusion also meant that the Muslims didn't have a legal regime to cover matters related to what we call Muslim personal law. So the gap existed, and I think it is because of the existence of that gap and the drive from the Muslim leadership that compelled us to move the motion.
I request to summarize.
Okay.
And then enter into the specific articles or specific provisions in the drafted bill that you feel will address the gaps in the article.
Well, I think the most important article and overriding article is the provision that seeks to establish Qadi courts at the national, regional, and district levels. The other aspects are really details. But that is the overriding theme, if I may use that term, that we are looking at having these structures from the national level to the district level. And with those structures, we think that access to justice by Muslims will be greatly enhanced. And obviously, matters related to appeal processes within the system are well covered. Matters related to, you've been talking about arbitration and reconciliation, those are matters that have been captured in the bill. Matters related with appeals to higher courts, civil courts, to create harmony with the national pieces of legislation are also provided. The issue of appointment, qualification, the competence of officers who are going to occupy offices in these Qadi courts are also well elaborated. So, and those are the aspects that are missing. Then the issue of jurisdiction, very important. What goes to Qadi courts? As we have said, this is about Muslim personal law, marriage, divorce, and inheritance. Very important, because as we speak now, there is a gap in as far as those issues are concerned in what you call our normal or conventional judicial systems. So broadly speaking, that's what I can mention in terms of the gaps that we seek to fill by having that piece of legislation.
I'm confident those provisions will cover the gaps that we have uncovered. I now go to Dr. Abdul Hafiz Wausimbi. Doctor, as an academic and a co-founder of MAMUKA, you have seen informal Qadi courts process. What are the biggest operational gaps that undermine access to justice in the family matters today?
I want to thank you for that question. You will excuse my voice. Before I could talk about the operational gaps, I think it is important, since we are in a season of protecting and consolidating gains, to also appreciate what are some of the achievements that the Qadi courts have actually registered, despite them acting in an informal way. I have been the Director of Sharia and Legal Affairs in the Office of the Supreme Mufti since the year 2021. And part of my responsibility is actually to sit as a judge. What I can assure you is that this is a full-time engagement. And really, once Muslims get to know that we can get justice away from the hassles and challenges of the conventional courts, they will give the first chance to the Qadhi courts. That even when we are working informally, our files are full. Personally, acting as a judge there, I have handled more than 50 divorces, successfully handled, and at a very less cost, and in a swift manner. There is no much delay. Because one of the distinguishing characteristics of the Islamic judicial system is that you must stand out very clear. There is no falsification of issues. You are either right or you are wrong. And that is why usually when people come to my court, I usually give them two statements in the briefing. Number one, I am the one on trial. That's what I tell them. The two of you, one of you knows the truth. So you have just come here to try me, to see whether, how am I going to decide? But one of you is what? Knows the truth. And this is, by the way, in line with what the Prophet ﷺ was doing, because whenever people came to him, he could say, Inna ahdakum lakadhib, one of you is a liar. So in that situation, we have been in position to clear many issues related to divorce, many issues related to inheritance, and many other things, custody, guardianship, among others. So I feel that the audience, before we could even look at the gaps, should appreciate that there is some work that is going on. Now, what are some of the gaps? And I could talk about these gaps from the experience. Number one, of course, it is the lack of recognition. When people come to us and we decide, sometimes even when you issue a hearing, a summon, some of them are like, who is that calling me? I had one experience where I summoned one person. It was a divorce matter. And I said, who is that calling me? And I decided maybe not to come. But along the way, he contacted Justice Yasin Nyanzi. And Justice Yasin Nyanzi asked him, are you a Muslim? He said, yes. Have you bothered to know who has summoned you? And don't you have a case at home? He said, yes. Then Justice Yasin Nyanzi told him, find out who is behind that summon. Then he was told that it was Dr. Hafiz. Early morning, that party had already shown up. So people have that kind of contempt as a result of lack of recognition. And I see that as one of the gaps that we really need to fix. Number two, we don't have standardized, let me say, codes. What are we supposed to follow, for instance, in case of dispute? This is where I always emphasize that the many countries I have walked to where Qadhi courts are working, they have what they call state madhab, the state school of thought. Because you know in Islamic law, especially in these branches, there is a lot of opinions of people, of the scholars. This one is saying this, the other one is saying this. So part of the operational gap is that we are not having a standardized code that we can follow, whereby we know that away from the scholarly views, this is the position of Muslims in Uganda. Maybe the third, in the interest of time, it is execution. We have had these cases. We have entertained them. And we have decided, many times I share with Zubeda that I don't know whether I'm an adjudicator, I'm a mediator, I'm what, but I'm inspired by justice. Have I, at the end of the day, managed to offer justice to these people? Because to me, the procedure might not matter, as you have just heard from Hussein. Now, when we have decided certain cases, by the way, after people have appeared to us on several hearings, then, for instance, when we decided that the custody is in favor of maybe the lady, you find the man saying that, no, I cannot accept. We have even had cases whereby people hire the mafias so that they can go and take out the children and so on and so forth. Where we are deciding in matters of matrimonial property, it has also been the same issue. So that's why I think this discussion or this conversation is really long overdue, so that for us, we don't have a problem to unveil the gaps that we are passing through, because it is until when we unveil them, that is when we can get solutions. I thank you.
Thank you, Dr. Walusimbi. Honorable Asman, I think you have taken note of that. We still have chance to include whatever would be missing: the lack of recognition, execution, and the code. So we still have a chance to include that in our bill. Haj Musana. Haji Musana is standing for the Director of Sharia, Uganda Muslim Supreme Council. We believe you are at the heart of community trust. So how have informal Kavi courts served or fallen short for ordinary Ugandans in resolving disputes like inheritance, divorce? And why is formalization urgent for the Uganda Muslim Supreme Council?
Thank you very much, Council. I will talk more on the side of my experience I've been observing. It is true that we really urgently need this law operationalized, because it is also going to help us to have the ordinary way of doing things. By that I mean, today, of course, right from the Imam will do two things. Of course, they administer marriages. At the same time, they administer the divorces. But at times, it depends on the level of the Imam. He may be good at maybe at hadith, but he's not good at what? But of course, as an Imam. And then we need a system that maybe from Imam, if things have not worked well, on top of the Imam, there is a counter sheikh. From the counter sheikh, there is a district card, maybe regional, and then up to the Director of Sharia. But today you may find things just come just from any level, and then at times they decided, and maybe a poor sister or a daughter may think that since this is the Imam, yes, that is another way. Then
where have you fallen short?
Yes. Before I look at where have we fallen short, I would appreciate, I think through Honorable Asmani Basalira, our Honorable Justice, and the Uganda Muslim lawyers, I think before and today, although in the absence of the operationalization of this law, they have done a lot of sensitization, especially from the judicial system, for the justices who are not Muslims. By that, I appreciate that today they can even refer these matters to, if it is about marriage, at times even courts refer to either the sheikhs, at times to the Director of Sharia, Chibuli, or at the Odi Kampala. But then a good number of them, especially the lawyers who are not Muslims, some of them also come to get the education. So I thank them that they have done a lot of on that side. Now, the missing gap is once this law is passed, it will help us to standardize our system to help our community, because our population is growing, and also, alhamdulillah, enlightenment. Muslims are getting educated, but now we need this operationalized so that we administer our affairs in the systematic way. But I want to emphasize that at least today, although in the absence of this law, but then there is influx of these cases all over. But like the doctor and the others, the system of Sharia at every level in our country is helping a lot to reduce the backload of cases. Lastly, because at the Sharia level or the Quranic way, like a doctor has said, when parties come, the first thing is to try whether they can be reconciled. It's very important. So at Sharia Directorate, once they register a case, they are advised that the first one is to see whether you can amicably.
Thank you, Haj Musana.
Thank you.
So should the audience take it that the same problems faced by Dr. Hafiz while adjudicating on such matters, like lack of codification, execution, and recognition, they're the same the Uganda Muslim Supreme Council is also facing? Absolutely. Thank you so much. I now revert to Honorable Asmani Basalirwa. Our next question. For the time, Parliament has debated this for decades, debating Calvi courts. We try, like we said, the draft Calvi court bill, the domestic relations bill. So Parliament has debated this for decades without action. What political or institutional barriers have you encountered? We have seen in your bio, you entered the Parliament since 2018. So what political or institutional barriers have you encountered, and how might we rally cross-party support, perhaps drawing from Kenya's formalized Calvi courts to fast-track that enactment?
Yeah, thank you very much. I think the biggest challenge has been lack or absence of political will. That's the biggest challenge. Because legislation primarily is originated by the executive. Bills come from the executive. So we can safely say that there hasn't been political will in as far as bringing this piece of legislation is concerned. Now, the absence of that political will could also arise out of the fact that perhaps as a community, we've not been exerting the necessary pressure. I have on several occasions seen delegations from the Muslim community going to meet the president. How many times have they brought to the attention of the president this matter? How many times? Maybe perhaps if they were doing so, we would be having a bill. So we may not have been exerting enough pressure. Even at the level of MPs, we've had Muslim MPs. And the issue is, how many times have we, as Muslim MPs, raised this matter on the floor to put pressure on the executive to have this matter brought in Parliament? So we may also be responsible for our own fate as Muslim leaders, Muslim politicians, but also the Muslim leadership. So the biggest challenge has been, the political will. Now, the next relates to some of the institutional barriers. If, for example, the presiding officers in Parliament that processes these bills are not very, passionate about such legislation, then they will not come through. But I want to, in a special way, thank the current leadership of Parliament, led by Right Honorable Anita Mong, who, those of you who have interacted with her, she will always tell you, I am half Muslim. That's the statement she usually uses, because the husband is Muslim. So she really has soft spot for Muslim issues. I recall when the Mufti met her, and they were having discussions, she was very emphatic. And that's why when you have pieces of legislation, she played a key role in the financial amendment bill that introduced Islamic banking. And the giving us space to introduce this bill also arises out of her passion and perhaps relationship she has with the Muslim community. So in my view, then the Ministry of Justice and Constitutional Affairs is also another institutional barrier, because this is the ministry that ideally is supposed to take the lead in championing this cause. And, even as we speak now, when I moved that bill, the Speaker guided that the ministry should closely work with me. We have tried to reach out to them. They are not forthcoming. They should be taking the lead. Ideally, a private member, a private MP like me, I should not be doing work of the executive or the line ministry. So my colleague, Chairman Mao, who heads the Ministry for Justice, as of now, and the predecessors and the technical people in there, perhaps should take note that there is this concern. As a line ministry, they should really be taking the lead in having this matter through.
Thank you, Honorable. We are now seeing that it is vital to exert more pressure from your submissions, but alhamdulillah, we now have the political will from the submissions you have made. I'm seeing now a political will, since we have a strong arm of the government, that is the legislature led by the Honorable Speaker. She has the political will for it. I think we have now moved a step. We should applaud the Speaker for that. Thank you so much. I now turn to Dr. Abdul Hafiz Wausimbi. Doctor, your work in arbitration and mediation bridges faith and law beautifully. How could formal Kavi courts incorporate alternative dispute resolution models to make them more efficient and community-rooted, perhaps inspired by international examples like Malaysia, Syria, and the Nigeria tribunals?
Thank you for the question. Of course, the formalization of Qadi courts and the incorporation of the alternative dispute resolution shall go a long way. First of all, to improve on the way we have been doing business. When you look at the ADR tools or models or approaches, the mediation, the arbitration, adjudication, expert evaluation, among others, I could say that we have been doing them either deliberately or not, with or without skills. I remember a case that I personally handled as a team leader. It was an inheritance matter. And the estate was up to the tune of 45 billion. One of the tycoons passed away here, and he entrusted our office through the will that we should distribute his estate in accordance to Islamic law. As a lead consultant in that, or a team leader, I could see myself in different capacities according to different stages. At one moment, I could be a mediator because they have to sign some forms in order to consent on mediation. Then at another moment, you can find them having disputes, and therefore I come in as an arbitrator. There are certain matters that really need expert evaluation from the Sharia perspective, and I could determine them. But the good thing is that at the end of the entire process, we registered 100% consent of all the beneficiaries, 45 billion. And that kind of achievement, someone could say that maybe it was one family. You know the families of Muslims. This was a family whereby the children were coming from 4 wives, and all of them were still alive. But alhamdulillah, we managed to handle this matter through different ADR mechanisms, which I can, personally, I could not even recognize whether I'm doing this or that. But at the end of it, as I had always said, I am driven by justice. I am driven by need. At one moment, somebody challenged me in my own court. A lawyer came and asked me that, where do you get the mandate to do this? I told him, don't play around with me. I get a mandate, my mandate is divine. Allah subhanahu wa ta'ala has appointed me in order to help people access justice. Surah Swad, verse 26, Ya Dawood, inna ja'alnaka khalifatan fil ard, litahkuma bayna an-nasi bil haqq. O Dawood, we have established you in this world so that you can help people arrive at justice, so that you can follow the truth. From any person who has some knowledge about Islamic law, al-ulama warathatul anbiya. The scholars are the heirs of the prophets. So I told him, I am divinely appointed. After all, even the parties have accepted that I should be in between them. So I could conclude when I'm appealing to that question by saying that, how can really the Qadi courts incorporate this ADR mechanism? I think that is what we have to do. Number one, we need specialized trainings. We are doing this here and even at Supreme Council, but really we don't have all that what? Training. And I think this is where MAMAC should come in, that a project should be written to see that people who are engaged in day-to-day dispensation of justice are trained. The second last is build synergies. I acknowledge my weakness. I come from the Sharia perspective, even though I hold a diploma in law and I have had several engagements in the law, but I cannot speak from the position of authority legal matters. So where I have a deficit, why should I call Council Zubeda to come in so that we can build synergies, and at the end of the day, we give the parties the best? Maybe the last one is benchmarking, as you have just said. In Malaysia, it is there. In our neighboring here, Tanzania, specifically where? Zanzibar, it is working, among others. I think we can do better by having such benchmark visits, and then at the end of the day, once the Qadi courts come on board, we can be in position to offer better service. Thank you.
Thank you, Doctor. I've liked the discussion because we have, it beats Bayanako. We have the registrar, High Court, mediation and arbitration. We also have the justice of recent. We are seeing the government, through the Attorney General, defending the governments about the delays in implementing that Article 129(1)(d), formalization of Qadi courts. citing complexities, and so many other things. So from the community's perspective, what practical solutions could turn this unwritten promise into reality without alienating non-Muslims? Over to you, Haji Musanda.
Thank you. I am only happy that whatever is discussed here, especially when it comes to at our national leadership, say doctor, and at the headquarters, because this one is universal and it is Quranic. You may find all the experiences we find are the same. I can also say that as pilot and whatever, I think this is an additional appeal to our government, especially through the parliament. The issue of the government's will or political will, I pray that will be a real from the heart, because as we talk now, since this sensitization or coming up with these drafts, whatever we need, I must say, it may not be 100%, we have it. It is there at the parliament and wherever you do so service and everywhere. Secondly, about lack of maybe trained personnel, I am also happy, and it's just additional appeal, especially our Islamic University, of course, where we are, those who are training our future leaders in all aspects, and also another university at the Health Kampala. In fact, right now, I already have a program from the Director of Sharia under Islamic University. All the program is on cadetship training program, and I'm sure even at our great university, IU. So when it comes to implementers, people, Muslim community, they are not seated. But I think the government will, or the political will, is very important. It's high time we pray that, especially at this point, inshallah, even maybe before you go for the next legislators, through Honorable Asman, since we are still there up to maybe June or May next year, we pray that the voice of this workshop today, and in addition of all the efforts, whatever it needs for this law to take place, alhamdulillah, it has been presented. Now, implementation, the pilot areas. Now that, since we have the establishment, before doctor, we have establishment at the headquarters, and with the headquarters at Uganda Muslim Council, we are all aware the structure is right from the headquarters up to the over 15,000 mosques at the down level. We have regions. Maybe we can only say we can start at every mosque or every district. Supposing we begin with the 10 regions of our establishment, and then the system works on. Otherwise, lastly, to add on what the doctor has said, the importance of this law, was it last year? There was a family, like the doctor has said, came before the Director of Sharia. The value of the deceased property was 4 billion Uganda shilling. It's not small. But within 3 months, because of the mediation, the deceased had more than 2 wives, but arbitration, counseling, guidance, the sheikhs, and also making them, because this one is an act of worship. You put those in the distribution that please, it is not about talking to win. This is today, and even tomorrow in your kaburi you are going to meet. So you find that people come down in the fear of Allah, and the thing is, amicably, within the shortest time, it is solved. Alhamdulillah.
Thank you, Haj. We are remaining with 3 questions, 1 each. I request the last one question to use only 2 minutes. The last question is for Honorable Asman Basalirwa. Looking ahead, how do you envision Qadhi courts integrating with Uganda's secular system without overlap, ensuring they are complement, not a conflict? Let's have 2 minutes on that submission.
Qadhi courts as you have mentioned, are not coming to compete with your conventional judicial system. Kadhi courts are complementary in nature. That's one. Number two, Uganda will not be the first country to have Kadhi courts operating alongside what you call the traditional court systems. And the fact that the jurisdiction is very clear, it's known, and two, there is the Constitution. So whatever we do must be in line with the Constitution. There is no provision in the Kadhi courts that will definitely run counter to the mother law, which is the Constitution, and that's a constitutional dictate. There's nothing we can do about it. So we have to comfort each other that in matters that are comprised in the bill, if it eventually becomes an act of parliament, there will be no contradiction, there will be no conflict. And I want in a special way to thank the Uganda Muslim Supreme Council, the Sharia scholars, the Uganda Muslim Lawyers Association, and many of the Ugandans that have made contributions towards this bill. Ever since we moved it, we've gotten a lot of input, even from across the world. So I'm very sure that the final product will be in tandem with the Constitution, and what we are trying to do is not rocket science, it's not from the mass, it is something that is happening even from our neighbors here in Kenya. So I don't think there is any cause for alarm.
Thank you, Honorable. Dr. Abdul Hafiz, from a scholarly point of view, how might gender equity be embedded in these Kadhi courts? We have seen recent baseline surveys highlight women's voices sidelined. So what curriculum or training reforms would ensure inclusivity of women?
Thank you for the question. A quick response is in a verse, فَاسْأَلُوا أَهْلَ الذِّكْرِ إِن كُنْتُمْ لَا تَعْلَمُونَ. Ask those who know in case you don't know. As far as Islamic law is concerned, there is no any gender problem. Islamic law, especially when it comes to these matters of judiciary, and I'm lucky to speak in the presence of my mentor, Dr. Sowed, Associate Professor Sowed. You can correct me if I go wrong. There are three major scholarly views about especially women involvement in judiciary. Of course, the majority say it is not okay for women to get involved in judicial matters or as judicial officers. But we find Imam Abu Hanifa, who is actually one of the great imams, saying that it is okay, it is only in so she can operate in non-criminal matters. Then we find another school of thought, the Zahiriya. They say there is no problem. A woman can participate, can act as a judicial officer at any level in all aspects, whether they are criminal or they are what? Civil. Now, the point that the audience should know in Islamic law, whenever there is dispute among scholars, you are free to choose the path that works for you. That is our principle. That is why the late Professor Karubawi said that this matter is decided by public interest. Even where countries you see that there are certain restrictions of women involvement, that is their public interest. And it's not necessarily our public interest. Aren't I going to be ashamed to rule out women involvement when Justice Celia Nagawa is here? You know? So this means that it is the public interest that should dictate how we should go about this matter. Now, what can we do in issues of training or not? The training is also not discriminative, as a matter of fact. And I can report to the audience that I speak now, we have several graduates of Sharia who are ladies, and some of them are already even in this house. Meaning that there is no problem. We don't even have to adjust the curriculum. Our curriculum speaks to the needs of our community, and that's why we have had those enrollments, and therefore, the only point I could say is that more women should come and join the Department of Sharia so that they actually qualify as judges or as magistrates in the Qadhi courts. Thank you so much.
Doctor, I can't wait. Thank you for that. Because I'm seeing myself being the first chief of Qadhi since now women. Honorable Basaliro, on that point, I know you are going to face a lot of hurdles. We have already gotten the answers to those who would be suggesting that it shouldn't be operationalized because ladies are not considered. You already have the answer. Haji Musana, the last question. How do you see the formalized Qadhi courts positioning Uganda as a model for pluralistic justice in Africa?
Thank you so much. That's a very good question. Before I can summarize that question, let me first talk as a Ugandan and who has moved some African and beyond. Uganda today, I thank Allah that when you look at how things are going on, apart from the challenges, we are looked at examples within the African continent, especially when it comes to issues of what? Islamic organization. Although when you come down into our service, we may be looking at some challenges, but of course those one, they are always there. So, by that, as we are all aware, we have the second biggest mosque in Africa. As I talk now, as Supreme Council was celebrating 50 years of existence, we had a big scholarly conference for all the African muftis. And they have resolved the headquarters of all Muslim councils in Africa, they are at Old Kampala. Even the secretariat is there. The secretary general is Dr. Salim, Ibrahim Salim, of course, and the office, as I talk now, is being furnished. Every year, we have training sessions for some of our brothers from other Muslim countries within Africa to copy a leaf of how we do, now that we have the Umrahs, we have the man, we have just Brother Munganda.
We have a will up.
And then the women and the others, the Uganda Muslim Council Constitution has provided 3 directors of Sharia, and it is a mandate of the Constitution. One of them is a lady. And for your information, the lady one is not yet filled. Maybe that is for information. So I think passing this bill in Uganda is again going to help and be an example to all the African in addition to those who are already practicing, like our immediate neighbors, the Tanzania and the Kenya.
Thank you, Haji.
Thank you so much.
Time is up. I now turn to the audience for some few questions. Let me first start with the one online. Okay. So due to the time, the organizers are requesting that we stop here. We shall go into the question and answer after this. To my panelists, thank you so much. Thank you for the well-thought insights. I can assure you that your discussion has led this occasion at a different level. Thank you so much. Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam wa rahmatullahi wa barakatuh. A very burning one from me is to pass a vote of thanks to the judiciary. There has been situations whereby judgments come from our courts, and the judiciary has actually agreed with our judgments. We thank you so much for that. And also the second goes to the Office of the Administrator General, that when they file the inventory, especially when we are managing estates, they welcome them and they actually take acknowledgement of them. Thank you so much.
I thank Hajjati Zakia for moderating this session. I also equally thank the panelists. Allow me to let members know that we are time bound. We are almost 25 minutes behind schedule. To our online viewers, we have to summarize all what has been going on. But however, I assure you that all these presentations are recorded, and you can always visit our website as MAMC to review them. We're also taking note of the questions which are being which are being tabled online. We are going to answer them later. But at this particular time, allow me to invite all members gathered here physically for breakfast. It's going to be a working breakfast. And to our own viewers, allow me to invite you to join our breakfast in spirit. I'm giving only 10 minutes to get your, 7 minutes actually, to get your tea and accompaniments. And at exactly 5 past midday, we are going to get another presenter. We're going to call upon another presenter to give us her presentation. So you can always join the queue. Self-service. I'm giving only 10 minutes to get your teas and accompaniments.
رمضان كريم وخير كثير يضيء القلوب كما ينشر النور نرفع أكفنا ندعو الإله رضاه نريد ونحيا بكم يسكننا الحب في كل وامحو الذنوب بنور السماء لك المنتهى وإليك المصير فأنت الرحيم وأنت الغفور رمضان جاء ونوره عم ففيه الحياة هل الشاطر والنور أضاء فانشرح القلب وزال اللعنة رمضان جاء بروح السلام يهدي ويمحي الظلام نور رمضان في كل دار يملأ بنياننا خيرا ونور فيه الهدى وفيه الرجاء نحيا بحب وندعو الإله يهدي الصائم درب النجاة ويرفع الدعاء في كل صلاة تزكو القلوب وتسمو الروح ونسأل الله غفران الجروح نور رمضان في كل دار يملأ بنياننا خيرا ونور فيه الهدى وفيه الرجاء نحيا بحب وندعو الإله يا ربي بارك لنا في اليقين واجعل صيامنا في الصالحين زدنا هدى وأعنا عليك فرضاك غايتنا في الحياة نور رمضان يسكن القلب يمحو الذنوب ويرفع الحب في كل نبض ندعوك ربي فارحم نداك واغفر لنا رفعت يدي ودمعي يسيل أدعو إليك إله الجليل في كل لحظة وفي كل حين أرجو الرحمن وقلبي حنين دعاء يرتفع نحو السماء يحمل أملا ويمحي العنانا يا رب الحب لي نور الطريق واجعل حياتي دربا أنيق جئت بالرحمة والخير حنان في ظلك نستبشر بالإيمان ونمضي بنورك بلا أحزان. مرحبا يا رمضان شهر البركات في صومنا رحمة وفيك النفحات يا نور دربنا ومصباح اليقين فيك الهدى وبركات السنين. في ليلك ناجينا ربا كريم وبالصبر نحظى بأجر عظيم. نرتل آيات بكل خشوع ونملأ أيامك بالخير يطول. مرحبا يا رمضان شهر البركات في صومنا رحمة وفيك النفحات يا نور دربنا ومصباح اليقين فيك الهدى وبركات السنين. يا رب فيك قلوبنا تهتدي فبرحمتك كل دعانا يبقى يهتدى. رمضان شهر النور والإحسان نبقى على عهدك في كل زمان. مرحبا
Hello, members.
يا رمضان.
Those attending physically and virtually, you can keep getting your teas and accompaniments. And those who are already settled, we are resuming our session. And I want to remind you that the session today is about people and justice. And you can hardly separate justice from time management. So we have to keep time. It's one of the Islamic dictates. So members, those who are lucky enough to have our schedule today, our program, you will realize that we have our presentation today at this time by we have a presentation between midday and 12:30, but however, in the interest of time, we've agreed to merge it with another presentation, which is going to be moderated by our sister Mariam Iga, and it's going to be a discussion that is harmonizing Sharia and state ADR framework in Uganda. So the person who was supposed to present, that is our sister. Okay. The person who was supposed to present is going to partake in the moderation, which is going to be moderated by our sister Mariam. So, as we comfortably take our teas, you should also borrow us one of your ears to listen in to what is going to be discussed, because from what we've heard from our online members, these presentations are like honey. They're enjoying them, they're learning a lot. And amidst us, we have very many dignitaries who are with us. We have the justices of the justice of the Court of Appeal, High Court. We have registrars of the High Court. We have the registrars, mediation, commercial court. We have very many dignitaries from the Uganda Muslim Law Association. We have our CEO, Haji Katantazi, Siraj. We have members from, I also want to thank our media team DK Sounds. They are doing a great job. At least we've got compliments from the online viewers. Physically, we also have our fellow colleagues from the Uganda Police Force. Because as we told you earlier, that people and justice, you can hardly separate justice from police, because police is part of justice. In our hall, we have our brother, Bogere Robert Ali. He's an encyclopedia of succession laws. They are all on his fingertips. In case you need anything, starting from the decided cases, laws, regarding succession and other laws, it's just a phone call away. He gives you an answer there and then. He's going to be one of our panelists. Okay. At this juncture, allow me to call upon, because we are having barely a minute to start our program, our presentation. Allow me to call my co-MC, Hajat Mariam Iga, to take us through this session.
Assalamu alaikum wa rahmatullahi wa barakatuh. I'm excited for this. Like we promised earlier in the morning, that we are touching very sensitive matters, but being the professionals that we are, we will not expect any sensationalization. We will not sensationalize the topics. The goal here, as presented in our NIA, is to add a cornerstone to our Islamic justice system and the national justice system at large. We are going to have a discussion around arbitration. We are going to have a side-by-side comparison with what the state ADR framework provides for, alongside what the Muslims. I reiterate the importance of understanding above debate, so that when we make recommendations at the end of this discussion, we are carrying forward
Recording in
thoughts
progress.
that unify us as Muslims. The other request is that we avoid distractions. It's going to be a two-in-one. We are going to have a lot of teaching, because we said arbitration in its form is a bit complex and different from the traditional legal knowledge that we have, even as lawyers, even as practitioners in Deen. So my request to the people in the room and those online, avoid distractions, pay attention, and most importantly, let's not create alarmist situations as the discussions go along. The mode of this one is going to be different than the other panel. One, we are going to start with a short lecture, for lack of a better word, so that we understand. Our fear was that if we go into the debate or the panel discussion as it was with the Qadi courts that have been here since 1995, arbitration is relatively new. We need to understand it from first principles. I'll invite Madame Dulbeda to come and give us a presentation. We will do our best to break it down in the local language. We have a panelist from Nigeria once again who has been at this 2 decades. She'll give us an international context, and we will have a representative from the Muslim Supreme Council to help us understand what the thought behind the Article 28 was, so that it doesn't look like we are bashing or contradicting. So we, for particular panel, we request for wisdom, we pray for hikmah, we pray for maturity, we pray for understanding, and that we will leave home with a better understanding of arbitration. So without further ado, I will introduce my panelists. I will start with the person who has been with us since morning, but you have not seen her. Drake, please give me my guest panelist all the way from Nigeria. We'll call this the East to West panel. Drake, please. While we get the visuals coming on, Assalamu alaikum wa rahmatullahi wa barakatuh, Council Hawa. We want to test a microphone. We want to hear your voice. Can you hear us? Assalamu alaikum wa rahmatullahi wa barakatuh. Please unmute your mic. We would like to hear your nice Nigerian accent. Assalamu alaikum wa rahmatullahi wa barakatuh. While her technology...
Alaikum wa rahmatullahi wa barakatuh. Can you hear me?
Yes, we can hear you very well. Welcome to Kampala, virtually a bit. Council Hawa Uthman is a lawyer and an alternative dispute resolution practitioner, and she was called to the Nigerian bar in 2009. She is currently the Registrar General for Nigeria Chamber of Commerce, that is like the National Chamber of Commerce for Uganda, and the General Counsel for Abuja Chamber of Commerce and Industry. Hawa is a certified Islamic arbitrator, an expert, and a registered neutral with Abuja Multi-Door Courthouse and the Regional Center for International Commercial Arbitration. As you can tell, she has a lot of experience in ADR, that is Alternative Dispute Resolution, and she's going to help us bring the international context to our discussion here, because as guided from speaker after speaker, but while we wait for our CADI courts to familiarize and operationalize the ADR space, we do have other laws in place that can help us to keep things going. So welcome to the panel, and we're happy to have you here. Next on is our... Yes, please.
Thank you for having me.
You're welcome, ma'am. Next on this panel, we have none other than Dr. Adam Rajab Mahmoud Kibwanga. Dr. Adam Mahmoud is the chairman of the Muslim Arbitration and Conciliation Council, that is the MAC. You've been hearing about the MAC, that council, the Supreme Council, Council that is helping us with alternative dispute resolution. He's very qualified. He has qualifications in LLB, a bachelor's in laws. He has gone to LDC. He has a master's in peace and development and international conflict transformation from Australia. He has a PhD in laws from Bradford University. He's a senior advocate of the High Court in Uganda with 20 years experience in managing, as a managing partner for Mahmoud Kibwanga and Company Advocates. He has taught a lot of our senior counsel in Uganda, and he's here in his capacity as chair of the MAC Council. Welcome, Dr. Mahmoud Rajab Adam. Next on the panel is our very own Zubeda Namgenyi, who is an advocate of the High Court of Uganda, a certified mediator, and the CEO of this very institution that is hosting us here, that is the Muslim Arbitration and Mediation Center. She's very passionate, and she's the voice for alternative dispute resolution and a firm believer that justice should be accessible, it should be humane, and centered on people and not processes. Anyone who has seen Zubeda's writing, has heard her speak, knows that this is exactly what she stands for. Her qualifications are many, but her most recent one has been obtained in foreign policy, an executive program for the American Center in Kampala. Zubeda has a decade and more of advocacy, and as an advocate, she bridges worlds of litigation and ADR with rare balance, resolving conflict with empathy while upholding integrity of the law. She's also an editor of the Legal Forte, and this is of great importance because part of our discussion today, if you check in the hampers you've been given, the folders, we do have a 2-page document, an expert of her latest article, but is going to guide. But before we go into this debate and the guide, because in this very article, she is talking about critiquing, to be very precise, the article that Muslim Supreme Council has on ADR. But like I said, we are not going to dive into a discussion where most of us are not well informed. We will just be misled. So we are going to grant her 3 to 5 minutes to take us through the principles of ADR. And for purposes of our online audience yet again, tubaniriza nnyo mu kanyomero kano akaddako ak'enkizo mu biteeso byaffe n'okubaganya ebirowoozo ku ngeri gye tusobola okufunamu obwenkanya wabweru w'amakooti nga bwe tugamanyi nga tukozesa emiwaatwa emirala gye tugenda okuyigako. Olw'okubanga ensonga n'obukwakulizo bw'okufuna obwenkanya mu mateeka nga gano si byangu muntu wa wansi kutegeera, tugenda kusooka okufuna okulungaanyizibwa n'okuyigirizibwa eri omukyala Zubeda Namugenyi, era eyawandiika mu katabo akamu ak'amateeka akasomeddwa abantu abangi ng'annyonnyola lwaki alina ensonga ze ng'omuntu era ng'omuyivu akawaayiro ako ke twateeka mu Supreme Council Constitution ate tekamalaayo mu kulambika ensonga z'okufuna obwenkanya wabweru w'ekkooti nga bwe twali kyagadde. Kati agenda kujja atuliremu, atubuulire, atuyigirize, then bw'avaawo mu dakiika 5 tuwuliziganye okuva ku sayidi zombi, ate wakati awo tufuneko ne experience ey'omuntu ali ebweru we Uganda abamaze ebbanga nga bakozesa etteeka lino n'okulaba obulungi obulimu n'obubi n'obuzibu we buli ffe nnyini abatandika tusobole obwewala. That is why the theme is exploring gaps and uncovering gaps and exploring solutions. Tugenda kuba ebituli, tugenda kuba torch ewali ekituli, ate tugattewo n'amagezi amapya n'okumanya okupya tusobole okugenda mu maaso, tusobole okutaasa etteeka lino nga tetuliye mu bulungi bwabyo. Zubeda Namugenyi, you're welcome. And the floor is yours with the presentation.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam wa rahmatullahi wa barakatuh.
Yes, as introduced, my name is Zubeda Namugenyi, and I stand here in many capacities, but today, right now, I'm standing in the capacity of a teacher. I have some of my students here. Those Afandes you see in uniform were my students in mediation class. Thank you very much for being here. I went to a bank on Saturday. When I went to the bank, I wanted to conduct a transaction. And instead, I went to the inquiries desk. So the lady, I made my inquiry, and the lady explained to me. But she was speaking banking language. So I told her, explain to me like you would to a 6-year-old. When she looked at me, I think she thought I was illiterate. That's why I was asking her to explain to me in a language of a 6-year-old. She got my form, filled it for me, and told me, sign here. So I got my form and walked out of the bank. The point I'm trying to drive at is that we professionals and technical people speak languages that most of our audiences don't understand. If I come here and dive into this discussion, we would easily leave you behind. For us, we'll be enjoying the discussion, but we would have left you behind, and that is not the intent. We are promoting people-centered justice. And our name is Muslim Arbitration and Mediation Center, Uganda, and I think we all know Muslim. So I will try to explain what mediation means. The definition of mediation in the law is basically having a neutral third party help parties who have agreed to resolve a dispute. When I explain mediation, I usually refer to a football match, soccer, where you have a referee. If you have team A dressed in red and team B dressed in blue, the referee cannot be dressed in red or blue. The referee is always putting on maybe black or yellow, and that represents the referee doesn't play for any team. He doesn't decide the outcome, but he creates an environment that allows the players to play and self-determine the result of the match. So that is the role of a mediator. She is a referee and just creates an environment favorable for the parties to determine their dispute, because we believe that parties know their disputes better than the neutral third parties. I think that is clear. Now I would like to explain arbitration, and I would like to spend a little longer time here because we are going to be dissecting the Article 28 of the Uganda Muslim Supreme Council Constitution, and I would like to have all of you in 3 minutes become experts of arbitration so that you can follow the discussion. Now, under the Arbitration and Conciliation Act, stay with me, I'm not going to be too technical, I'm going to break it down. An arbitration agreement means an agreement by parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined relationship, whether contractual or not. Now, when you have arbitration, we have in the Constitution, we have Article 28, which provides a national system where parties who are disputing can go. In that system, they will choose for you a judge. The language is predetermined. So that's why you need a lawyer for most of these proceedings, because most of the lay people don't understand what court proceedings are about. And the forms are also predetermined. They will tell you, you bring this by plaint, you bring this by chamber summons, you bring this. If you don't come within this time, it is basically restricted. Now, in arbitration, the beauty about it is that you are allowed as a party to determine what your resolution process is going to look like. And in this, it's called party autonomy. Basically, the party is the boss. So you can determine, I want a Muslim to sit in my dispute. So that if they bring a non-Muslim, you're like, no, me, I want a Muslim. You can even say, I want someone who is tall, someone who is short. I want to speak in Luganda. I want to speak in Arabic. I want to speak in Lunyankole. I want the process to be done within 60 days. I want to I want to sit under a tree. We will sit at Serena. So the differences between these are basically the party has a lot of freedom to determine what they want. And the rider here is, after determining whatever you have decided, the court is saying, stay there. We have the court system here, but you chose to go and say, for me, I want a Muslim, for me, I want a Christian. I want someone who has a PhD, I want someone who is a P7 graduate. I want this to be our process. So after that, the court is saying, the law is saying, if you have decided to go with this person, you are bound by the decision that they make. So it gives you freedom, but in a way it says, be bound by it. We are not going to entertain a situation where you don't like the outcome and say, no, you shouldn't have had my case, but you chose the process. Do I have all of you? Is it basic enough? Yes. So when I try to, I like teaching with analogies. It's like you going to a restaurant and saying there's a buffet there and you say, me, I don't, whatever is sold on the, or is put on the table, I don't want. Me, I want eggs, chicken, matoke, this, put onions, don't put whatever. At that point, when they serve you, you should not say, this is not what I want. Because you chose it, party autonomy. And I will leave it at that because I feel like you are following. We are going to be, every time every clause we are going to discuss, I want you to reflect on party autonomy. Each one of you has an extract from an article I wrote about the Article 28, which is the arbitration clause of the Uganda Muslim Supreme Council Constitution. And I would like for you to follow the discussion. In fact, at the end of it, I hope you can be able to guide on your own as to the legalities, the critiques, the areas where they got it right, the areas where they got it wrong, so that we can push for a better access to justice. I yield back, Madam Moderator.
Thank you very much, Zubeda. Please take your seat, and I hope we are all ready to start for purposes of the online audience and those who are following in a second language. Omukyala Zubeda abadde atubuulira endowooza ye era yamusindikiriza okuwandiika nga yeemulugunya ku nsengeka ya Article 28 ya Supreme Council. Bonna boogera ku kintu kyekimu ekya arbitration ky'annyonnyodde. Okufunzafunza abatandika okutegeera mediation, arbitration mu ngeri etazibuwaza bintu. Atuwadde example y'akapiira n'atugamba nti bw'ogenda mu kapiira wabeerayo refu, wabeerayo ttiimu, wabeerayo abawagizi, naye referee tasobola kufaanana na ttiimu zonna, kitandikira na mu nnyambala, naye nga kiraga nti ye ng'omuntu alina okuba nga teyeekubiridde. Era mu kutambuza ekirowoozo ekyo ne tugamba nti bwe tudda mu paati ya arbitration osobola okubaawo ng'olina ensonga yo ng'ogyeko enkola y'ekkooti gye tumanyi eya bulijjo n'ogenda ne bagamba mulamuzi gundi yatudde mu musango gwo bajja bawulira ku lunaku bwe luti tugenda kugoberera amateeka bwe gati. Wano mu nkola eno gye tugezaako okuyigiriza n'okubangulamu abantu eri wabweru w'ekkooti nga bwe tugimanyi, nga tukozesa example eyo gy'akozesezza. Osobola okulonda line up nga mumanya nti ttiimu zinaasamba, ne mwerondera line up, ne mwerondera riifu, ne mwerondera ekisaawe, ne mwerondera essaawa z'omupiira, ne mwerondera amateeka ge munaagoberera, kye bayita arbitration oba ADR. Kati okutandika okutegeera ensonga lwaki tuli wano, ekinyusi kya discussion ya panel eno kigenda kubanga tukwata akawaayiro aka Uganda Muslim Supreme Council ku nsonga z'okutabagana wabweru w'ekkooti. Article 2, akawaayiro 28, kuba already bakayisa dda ne bakateeka mu nkola nga tukageraageranya ne akaffe aka Uganda ng'ensi. Bwe mujjukirako katono okuva waggulu awo, aboogezi bonna abaze bagamba nti okola etteeka erinaayamba lirina okuba ekisooka nga liyamba abantu culturally sensitive abalyetaaga mu ngeri gye balyetaagamu, naye ate nga terikontana n'amateeka agali badde gatwala eggwanga. So panel egenda gezaako okukola side by side comparison okulaba akawaayiro kano aka Uganda Supreme Council nga tukatadde mu kulabisibwa n'akeggwanga eryaffe nga Uganda. We do have the write-up that you have, those who are able to read it. We will focus to make it easy to understand. The table starts from page 44 of the article. You have page numbers. But Zubeda has given us her thoughts. It is only fair that we start with the authors of the Article 28. Dr. Rajab Mahmoud, please share with this audience the spirit, the thought process, and the intention behind Article 28. You have all the time, as much as Zubeda has taken, so that we get the audience and ourselves on equal footing. Over to you.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم السلام عليكم ورحمة الله وبركاته. My name, as already mentioned, is Dr. Adam Mahmoud Kibwanga. Among many things, also a member of UMLA's founding member, together with Justice Sekana, and Asuman Basera, who has just left. That should also appear on my portfolio, because it's very important in a dispensation like this to mention that I was among the first members who subscribed to the Uganda Muslim Lawyers Association. I'm currently the chairperson of the Muslim Arbitration and Conciliation Council. It's not an easy thing. It's a big way to carry because it's still a new organization. But briefly, I want to say something about it. One, we got feedback from the public regarding the MAC, if I may abbreviate it as such. That is Muslim Arbitration and Conciliation Council, the MAC, MSC. And those are all beautiful feedbacks, especially the article that has been mentioned from my sister over here, that identified loopholes and where we could improve. And I think we welcome those views. But before we go there, we need to understand that historically, Islam has always practiced arbitration. And all the values that we find in our major sources of faith, such as the Quran, the Sunnah, etc., enhances the fact that arbitration is the way to go. To Islam, justice is not just until it's peaceful. And that formed the basis of the Uganda Muslim Supreme Council having this incorporated in its constitution. I also want to say that in 2014, there was a report made by Professor Tassis Kabojere, who was commissioned by the government of Uganda to see issues of factionalism in Islam in Uganda. And among the recommendations, the key recommendations that Professor Kabojere came up with was the formation of a Muslim arbitration center, such as this, and plus other recommendations that he gave. And therefore, the formation of the Muslim Arbitration and Conciliation Council was as a result of the cry. It was driven by demand, and we made it possible by incorporating in our constitution. We also want to thank President Museveni for funding the making of this constitution, which is an upgrade of the 1972 constitution of the Uganda Muslim Supreme Council, and eventually also the promise that they would support this arbitration center that we have created. We are very grateful to the government of Uganda for that, and we always move together. Now, basically, we want to say that the MAC in the constitution of UMSC at Article 28 was established, but the actualization and the procedural aspects of the MAC is in the regulations, which unfortunately my sister did not look at when I was handling the critique to what the UMSC came with as an arbitration center. But if we were to look at that and our procedural, all our regulations, you'll be able to appreciate that we have factored in many things. First of all, we know that we're a faith-based arbitration center. This is a bit different from the ordinary formal arbitration center. Faith-based arbitration center is an arbitration center whereby people from different, from the same faith people agree rather, to do the arbitration within the principles and values of a particular faith. And for our case, is Islam or being a Muslim. Therefore, you might not be able to appreciate it as a formal arbitration center like our MCU is, because we are handling arbitration from a religious perspective. This happens everywhere, not only in Islam. The Jewish have the same, the Christians have the same, and it's unique. It's not the same like this, because a number of things come up across all religions, not only in Islam. The issue of parties' power, whether or not they have powers, the issue of acceptability of the results of arbitration, the issue of at parity with the legal system of the country, too many issues come up. And when you do a research on it, you realize that the Muslim Arbitration and Conciliation Council is a good attempt at bringing an arbitration center in Uganda. And we don't have any regrets that we have created it, and we don't have any apologies for that. We know that we have created a space for interaction with other arbitration centers, formal arbitration centers, and we are happy that MAM has come in as an arbitration center. We are also cooperative with the government of Uganda to have our center be able to appoint arbitrators, and we're working on that. We are working on setting up arbitrators, what they call arbitrators bank, where you can draw arbitrators to come and arbitrate. We are working at doing everything possible to make sure that we have a mediation center, we have a negotiation center, we follow the rules of conciliation, and we are trying to adapt the local legal system or the municipal law, that is the Arbitration and Conciliation Act, into the system. So it's still a work under progress. It's not something that you can easily and readily criticize at this moment. So we believe that with that background, we can have a fruitful discussion and see where I come from as the chairperson of the MAC.
Thank you very much, Doctor.
Other ADR intervention. And lastly, the
recording in progress.
The center in the regulation seeks to maintain, or rather adopt, some of the all or informal systems that are being practiced already in Uganda or in the Muslim community in Uganda. By the way, we have approximately 12 million Muslims in Uganda. Although the Uganda Bureau of Statistics indicates that 6 million, we have issues with that. Because there are some, as Honorable Asuman stated earlier here, that there are people who call them half Muslim, but as within the Muslim circle, we consider them Muslim, because you are married under Sharia law, for example. Therefore, we are approximately 12 million. And we cannot reach all these 12 million people with one center. So we are ready to incorporate, rather, to adopt some of the old systems that have been used before. In 15,000 mosques that we run in the country. Appreciate that ADR system.
Thank you very much. I do hear you, and I do know that the audience appreciates all the administrative work that has gone into creating this center thus far. But like we say, and for purposes of us who are learning, a mediation and arbitration center, it doesn't matter how glamorous the seats are, it doesn't matter how beautiful the buildings are, is as good as its procedure rules. People want an outcome. So I would like to go to Zubeda and ask her, in true spirit of humaneness, by the time you wrote this Article 1, were you aware of these regulations, even in their draft form, and did you put them into consideration? The ones that Doctor is talking about.
My beginning point is going to be still arbitration. What is arbitration? The state has provided a court system. You, as parties who are disputing, have a right under the Arbitration and Conciliation Act to say, for us, we don't want to go under the court system. And therefore, we are going to put it in writing and say that we are going to resolve our dispute outside court. That is the position of the law. If I call myself Duzobeda and I dressed like this, and you find me carrying a bottle of beer, you are going to question me because I call myself a Muslim. However, if you find John holding the same bottle of beer, you are not going to question John. If you call a clause an arbitration clause, you have brought yourself under the operation of a law. Yes? You voluntarily bring yourself under the operation of a law. It is the other side, and you don't have to touch it. But the instant you, as you say, I am an arbitration center, or this is an arbitration clause, the first thing is going to be, what about arbitration looks like your clause? Those are valid questions. That is number one. Number two, in the hierarchy of laws, the Constitution is not substituted by rules. We have the Constitution of Uganda. It is not as elaborate about everything, but it will tell you, you have a right to practice your religion. The details can be covered in the Acts of Parliament and the rules, but you cannot use rules to water away what the Act says. And I would like to look at the provision of the Article 28, the clauses. The first says...
Please guide the audience, those who have the write-up, so that we can follow.
I am looking at page 53, the first page, where you see Article 28, Muslim Arbitration and Conciliation Council. Are you with me? The law says, clause 1 says, there shall be a Uganda Muslim Supreme Council, Arbitration and Conciliation Council, which my land brother here heads, which shall have jurisdiction to hear all disputes among Muslims, between Muslims and non-Muslims, filed by such non-Muslims relating to any issue, including the running of the affairs and management, interest, and rights under the Uganda Muslim Supreme Council, except electoral matters. So that provision creates the council. Provision number 2, clause 2 says, all members of the Muslim Supreme Council, of the Uganda Muslim Supreme Council, save those who will have expressed disclaimer, in writing within 30 days of adoption of this amended constitution by the General Assembly, shall, for all intents and purposes, be deemed to have submitted to the jurisdiction of MAC. I would like to first discuss that. This law says it was passed in 2022, the amendment. And it is saying you have 30 days to express your dissatisfaction with this provision. If you do not express it within 30 days, you have waived your right. In law, there is something called waiver, where you have a right, but you decide not to take it, to basically use it. I can sue you, but I decide I won't sue you. So I am a lawyer, and I did not know about the existence of this clause. So I'm assuming my mother, a market vendor, if a lawyer does not know, then of course most people did not know about it. That is number one. Number two, this same provision, he said it is peculiar to the Muslim community. But this same provision has been used by the courts to dismiss cases that have been filed against the Uganda Muslim Supreme Council. Because, like I told you, a decision, once you submit to the jurisdiction under an arbitration clause of any tribunal, you have kicked out court. Now, when Muslims go to when Muslims go to court to challenge whatever disputes they have with the Muslim Supreme Council, the court says, our hands are tied because you have an arbitration clause. But this is an arbitration clause that you did not know about. That is breaching the first principle of arbitration. I am supposed to know that I am entering into an arbitration agreement. Yes? You cannot take it upon yourself to agree for me. And in fact, when you go to court, the instrument that gives you jurisdiction is the arbitration clause, and they will tell you what does the arbitration clause say.
Zubeda, I'm going to cut you short because, like we agreed, if the audience can hear me very well, we are going to be a bit slow so that we don't pile up issue upon issue. Then once we have a response and we have a general understanding, we'll go ahead. So on the issues that you have stated, especially one, if I hear you very well, party autonomy in deciding if they even want arbitration. Dr. Mahmoud, I hope you can hear me on this. The clause seems to suggest that by default, members of the Supreme Council are signing up, Muslim community, except if they expressly say within 30 days that they don't want to be part. Can we address party autonomy? We are going to go very slowly. What was the spirit behind this clause and the 30 days limitation? Thank you very much.
Thank you, Mariam. Like I said earlier, the Constitution is a framework, a legal vehicle that we hope to, or that we are using.
I don't know if your mic is not well placed. Please speak
The
up.
Constitution
We have
is-
a recording for the online audience.
The Constitution of Uganda Muslim Supreme Council, at Article 28, is a framework. It's a legal frame. It's a part of the legal. Basic of the legal. It's the basic legal framework that creates the MAC, or the Arbitration and Conciliation Center, or Council, if you like. And this Constitution, as I mentioned earlier, does not cover everything that needs to be covered. Like I said earlier, I think the critique is too early. Because one, the center has not been fully made operational because we are waiting the approval of the General Assembly and the rolling out of the regulations, and all the procedural aspects will come out in the regulations. But one question specifically about the 30 days
Party autonomy.
about the 30 days adoption of the amended constitution, about being brought within the paradigm of the constitution. We need to understand that Uganda Muslim Supreme Council is a body that has a free entry and free exit. It's a kind of company which is unlimited by nature, if you call it a company. It is a peculiar kind of entity that addresses the kind of religious bodies, meaning that a member who qualifies to be one is free to come in and get out as they wish. So when we were making this clause, or putting this into perspective, we understood that a member can choose not to be, if he doesn't want to be part of the UMSC or part of the Sunni Muslim movement in Uganda. And because of that, we thought that this would be adequate. Now, we didn't want to have a situation where someone comes up and says, I'm not bound by the Constitution. If you want to sue or you want to arbitrate the Constitution, then you must first be bound by it. And therefore, a timeline had to be created. It's just logical and common sense. And that explains...
May I?
Yes, please go ahead.
I think about suing, that is at the tail end. We are talking about even owning the process, the pathway to justice. What the clause seems to suggest is that a party in a dispute, except if they expressly say they cannot choose out, as long as they are members of the Supreme Council.
Well, you see...
Basically, what this clause seems to say, if I can break it down in lay terms, that it is mandatory for members to be bound by the rules of that center.
I agree with you. And you see, one of the major tenets of the basic principle of constitutionalism is that you need to understand, read the Constitution as a whole to be able to appreciate. In paragraph, or rather at Article 28 of the UMSC Constitution, we have broken down situations. Remember this paragraph, not only this with arbitration, this with things like conciliation, mediation, and other things, if you read carefully through the article. So let's not limit this article to arbitration only. Then two, whether or not a party can choose an arbitrator, it's broken down in the regulations, which unfortunately you don't have access to now. And we also invited the national laws here. When you look at this article, I think paragraph 5 of the article, it says that the MAC shall be at liberty to adopt the rules of procedures under the Arbitration and Conciliation Act of Uganda and any other enactments applicable to the authority. Now, this paragraph clearly brings in the local laws of arbitration in Uganda. And once the local laws of arbitration become functional, then there are no exceptions. You follow the procedure under them. It's just normal that you have to do that.
Thank you very much. I hear you, Doctor, and I hope the audience can agree that I think Doctor has a point in saying that if we had been privy to the regulations and the procedures, including Zubeda, the author of this article, would have better insight. But can you let us know, one, if the draft can be accessed, two, when the actual guidelines will be, and then maybe we can have a bit of hope. But also, as we pause on that, I would like us to agree. This is a very, very important discussion. As you can hear, the adhan is going on. So I would like to suggest a way forward, that we give this another 45 minutes. We can't miss prayers at lunchtime. Then we will have extended lunch, but we do not cut this conversation short. So we give it another 45 minutes, go pray, then have lunch, as opposed to have lunch, then pray. Do we agree to that? So that we don't break this. Thank you very much. And our online audience, we appreciate your patience on this. So back to you. What might help today in this discussion is an assurance of whether the draft rules can be shared, knowing that they are draft, or when the fully approved ones will be, so that we can have the comfort and assurances of bare principles of ADR, like party autonomy, that will be upheld. So are the rules there? Are they going to be still? But also, should they be there and in draft form? Does Supreme Council have it in them to take, for example, if we have any suggestions from these compositions? Because like we said, this is not, it's not mere talk. If we have any recommendations, are you amenable, agreeable to taking them forward? Thank you.
Thank you, Sister Mariam. One of the reasons why I came for this summit is to seek for views as the chairperson of the MAC and see how I can incorporate these views into our running. We don't have any tension relationship between ourselves as MAC and private or government facilitated arbitration centers. We work together, we are complementary. We are faith-based, but we will rely more on the other arbitration centers like the particular one that have organized this summit. So we are willing to take into consideration all the good recommendations that we get from this engagement.
Thank you very much. That's the woman spirit. I guess we will all agree with that. So back to you, Zubeda. I would like us to talk about, because this thing is deep, but I am going to take the liberty to pick out the sticky issues that I know, if well discussed in this forum, will help us have a final and better clause if agreed to and amended. So let us go to the finality. Dr. Mahmoud kept referring to the structures, the administrative structures, all the way down, I think replicating the Supreme Council. I sense that it's going to be a replica of the CADI and then just copy and paste back to ADR. Talk to us without sentiments. One, the importance of finality. Yes, Zubeda, without sentiments. The importance of finality. Because when these centers are established and every single award they make, what we are calling fatwa, but an award is set aside, then buy-in will be little. So we might have to put this aside and hear from your heart. Speak to us and the audience about finality and how we can say, what is it, can we say, have the end in mind? Start with the end, begin with the end in mind. So we will put this aside and speak to us about finality, of arbitration clause, of arbitration and awards and enforcement. And then we shall see if Doctor has something to say in their regulations. Zubeda.
Thank you very much. My starting point is going to be this, because he keeps referring to rules. And I like speaking in analogies because I like breaking down technical language into the simplest. If I say, if you have a non-Muslim who says, I would like to convert to Islam, then you say, Start praying, we'll do the Shahada later. Which comes first? Is it the Shahada or the prayers? Is it the fasting or the prayers?
To bring a bit of light to this very tense conversation, I think we know situations in Uganda where people have done the thing and say, yeah, you'll pick the interest and then you take Shahada. We all know what happened to Chameleon, and we know why he's not Muslim.
Yes, so basically, for me, my point is, if we are going to push the initiative for us to have different sects, different villages, different parishes have arbitration centers, is beautiful. That is actually what we are advocating for. Because at the end of the day, when you're seated in Kampala, you're not going to be available to hear a case in Soroti immediately. And yet, if there is a well-organized arbitration center there, they are going to deliver access to justice. The threshold here is you bring yourself into the operation of a law. And the law is saying, once you go arbitration, don't come back unless rules of natural justice have been breached. Now you agree for me. Then he referred to article, to clause
5.
Clause 5?
Paragraph 5.
Yes. He refers to clause 5, which reads, the MAC shall be at liberty to adopt the rules of procedure under the Arbitration and Conciliation Act of Uganda and enactment applicable to the alternative. It is like you saying you will be at liberty because it is the Arbitration Act that births in Uganda muzadde wa clause yamwe yonna gye mugenda okukola nga MAC oba Muslim Arbitration and Mediation Center oba mwe mu ntegeraganya zammwe mu business eva mu mateeka ge bayita Arbitration and Conciliation Act. So we mugamba nti muli tuli baddembe okukozesa etteeka eryo kitegeeza you are saying no to the parent and you're existing before the parent. The threshold is very clear under the Constitution and under the law. The guiding principle of arbitration in Uganda, which is even, by the way, on the international level, because we adopted a model law. The reason as why we can have a conversation about arbitration in Uganda, have Dr. Hosseini speak, have Ms. Hawa from Nigeria speak, is because we have a model law. The expectations regarding arbitration are the same.
Zubeda, right there is where we are going to put a pin, because Dr. Hawa, if she can be brought on, Drake, I wanted her to first get a feel of the temperature of what's happening in Uganda. It was on purpose that I kept her out of this conversation for the first few minutes. And now that Zubeda has mentioned, and I believe Dr. Mahmoud agrees, that this arbitration conversation, if we are to get it right, we cannot afford to be myopic. If we are going to do and have arbitrations that happen here and are enforceable, because the most common example in commercial disputes, you don't know if the next dispute is going to be between Uganda and Tanzania, and a South Sudanese or a Congolese. We need to get it right. So Dr. Hawa, welcome to this very interesting conversation. And because you've gone ahead of us as a country, please share your experience in regard to model law to give us comfort that if we get this thing right, arbitration, even under Qadi courts, will be applicable. We will get awards that are enforceable, even international courts. Thank you very much and welcome. Please unmute your mic.
Can you hear me now?
Just a little bit.
A little louder. Yes. A little louder. A little louder.
Okay.
Please go ahead.
All right. Can you hear me now?
Yes, we can.
Okay. So I was saying thank you very much for inviting me to this very interesting conversation. And I have carefully been hearing the conversation between my sisters Vida and Dr. Mahmoud. It's actually very interesting for this timely discussion, especially because the whole theme of this summit is people and justice, right? it's important that we bring justice closer to the people, for people to understand what it means for them to have options in accessing justice, whether from litigation, arbitration, or mediation, or any of the dispute resolution mechanism that the states have made available or have given opportunity to exist. And from the conversation we're having, it's interesting, and I think I should share our own perspective in Nigeria. What is the legal regulation regarding freedom of association? Because from what I understand, the Ugandan Muslim Supreme Council is an association. And just like the Nigerian Constitution, I'm sure that the Ugandan Constitution has also given people, individuals, the right to join any association. The right to freedom of association is a fundamental right that have been given to people. And if people as Muslims want to join the Supreme Council or want to associate themselves with a particular association, then the right has been given to them. The freedom to join that association has been given to them. So in terms of what the provision of the Article 28 is talking about, and in relation to juxtaposing it to what we have in Nigeria, both as provided for under the Constitution of Nigeria and also our Arbitration and Mediation Act 2023, which is modeled after the ancestral model law. So for us, and there has been so many judicial...
like we said, Dr. Mahmoud
Recording in progress.
Is she back? Seems to share the view that we are discussing prematurely and picking and choosing, cherry-picking aspects of the clause without understanding the depth. Zubeda seems to share the view. Please go ahead if you're back online. Please go ahead.
In so many plethora of cases, so many cases that the court have recognized the absolute powers of parties to determine, like Zubeda have kept saying, party autonomy, party autonomy, party autonomy. The courts have also given those powers to people. You have decided that this is how you want your disputes to be resolved. So you'll be guided by how the association or the organization have provided the rule of that. And unless the court that's probably the arbitration, it is possible to
discussion here, then we'll have you back, please. Please stay on the call.
Okay.
We are going to change the internet provider, but we have to continue with this conversation. Dr. Mahmoud, to come back to you based on Hawa's discussion. She seems to be very emphatic on the issue of party autonomy, even in the dispensation of special interest groups and all that. Please confirm that the guidelines that we've not been privy to and the spirit behind this act, and where necessary, share with us where party autonomy is at the center of the thought process regarding this clause.
Thank you, Sister Mariam. Well, I've stated earlier that the MAC has 4 major areas, and arbitration is just one of them. And arbitration, if we are to go for arbitration, then we are going to follow the Arbitration Act.
Just to be clear,
yes,
that the critique is about the article on arbitration, unless you're saying that the article was meant to be an ADR article, not arbitration.
Precisely, that's what I was saying.
Do we need to rename it?
No, what I was saying is that the critique seemed to suggest that the whole Article 28 is all on arbitration. So some aspects of other things like mediation.
Sorry to interrupt.
Yes.
For purposes of the audience,
yes,
the mark is what? In full, because it says it's the what?
Muslim Arbitration.
Not the Muslim Alternative Dispute Council.
No, the Muslim Arbitration and Conciliation Council.
So is it wrong to assume that this discussion includes arbitration? Because from the very name and the purpose and the case law that we have so far, based on that clause, is about arbitration.
Well, it's all encompassing. What we are saying as UMSC is that Article 28 tackles not only arbitration but other aspects of ADR. But arbitration is there. Now we are saying, if you are to understand Article 28 well, you need to look at the regulations that break down where arbitration is, where conciliation is, where mediation is, where negotiation is, etc. Now, to answer your question directly, arbitration is in the Article 28 of the UMSC. It's a very important part of that article. But we are saying that we cannot do arbitration on our own. We are going to actualize or bring into play or import the Arbitration and Conciliation Act of Uganda to come and help us. And once we do that, when we cross that line, we are going to bring into play all the aspects of arbitration, including part autonomy.
Maybe that begs the question. For purposes of understanding, we cut Zubeda's presentation short, but we do have other forms of alternative dispute resolution. We have evaluation, neutral evaluation, conciliation, adjudication, especially for construction. May we then ask if that one nomenclature or the spirit behind the MAMC, does it cover negotiations, adjudication, so that if there is need to even change the name at this point, maybe we need to consider it. So please guide this audience on the other forms of ADR so that we don't have a misrepresentation of sorts.
Well, as noted earlier, we created a holistic center in this constitution, which will tackle most of those things, all of them, depending on the needs at the time. But what I can say is that we are following Islamic principle of using ADR to resolve disputes within the community. Not only among us Muslims, but even Muslim and other willing non-Muslims who want to come into play. Therefore, it brings very many arrays of ADR
Precisely.
system.
That is why this forum would like to understand that in merging the many forms of ADR, each comes with a set of obligations and procedures. Is the Supreme Council aware? Are they putting this into consideration? And maybe Dr. Hafiz can help us with this because he says he's practicing arbitration, arbitrary? Or he's merging conciliation and he's doing a bit of a katogo of ADR. So maybe it's time to even have a proper nomenclature for this council for avoidance of doubt. What do you think?
Well, the name for me doesn't really matter. What matters is what it's doing. For us to change the name, that means that we have to go back to the General Assembly of the Ugandan Muslim Supreme Court and do it. Their wisdom, they found that that is the most appropriate.
Would that be such a big ask if it is going to clarify? Because if people in this room are confused, what about that? How many do we have on call? Maybe 200 who are hearing arbitration and ADR for the first time and are not very sure what the difference is.
For me, I don't think that is a point that we can disagree on. It's a point that we can take for consideration and present it to the...
Thank you very much. In the interest of time, I think that is food for thought. Azubeda, back to you on the issue of finality. As we confirm if Hawa's internet has been switched. If it has signal, please, technical team, give me a sign. Let's have Hawa back, please. Hawa, please continue your trail of thought. Apologies for the interruption. Please go ahead with the international scene setting.
Okay. Okay, so thank you very much. And all that I was trying to say is what the positions that we have taken in Nigeria regarding arbitration as provided under rules of associations or constitutions of associations. That generally the court will uphold it, of course, unless the court finds that there is unfairness or there is involuntariness in the process that has been taken. But, while Dr. Mahmoud was talking, and I was thinking, and in relation to what Dr. Hosseini had said earlier in the morning, we need to understand that before the formal, and this I'm taking from my own personal perspective and not even from what we have. Before the formal arbitration or before arbitration was formalized in Nigeria or in our country, we have to have a process, education that's actually known as arbitration. And I will give you an example. What we have in Nigeria, for instance, in a particular part of our country, is that disputes are submitted before an arbitrator for adjudication, which we know as our own customary arbitration system. So I'm trying to expand the definition of arbitration in this instance so that we, and what it needs to be before we have it formalized as the Arbitration and Conciliation Act in Nigeria, before it is now, before it was repealed into Arbitration and Mediation Act. So what we used to have as customary arbitration is a situation where parties submit their dispute to a third party to adjudicate over that dispute, and it is still known as arbitration. So, but in today's climate, and what we have seen some judges, a lot of the cases in Nigerian courts have taken the position is that such adjudication are still valid before the court. So, irrespective of the nomenclature, whether it is referred to as arbitration or mediation, but provided that it requires it requires parties submitting their disputes to a third party, which means that parties have consented. So the issue of consent is still there. The issue of voluntary is still there. So in that circumstance, the court will uphold the adjudication, provided it is done within the boundaries of law. But to give you an example of a case law, and I think the case of Agu versus Ikewidi, which is a 1991 case in Nigeria, and this particular case is a leading authority to customary or traditional arbitration in Nigeria. And the Supreme Court has held in that case that a customary arbitration, which I'm trying to liken to the situation of Article 28, because, arbitration under the Islamic law in Sharia, which is passive, means submitting your dispute to a third party. So, in the situation, in the case of this customary arbitration in Nigeria, the courts have held that a customary arbitration clause can be binding and enforceable if, one, that both parties have voluntarily submitted their disputes to the arbitrators, which is the elders within the community as it were, or the customary law of that community. And the parties agreed to be bound by the decision of the elders or the customary law of that particular community. And then the arbitration was done in accordance with customary law, and the decision was in fact reached. So the significance of this case is that it validates traditional arbitration, including whether they are formed or found in an association or within communities, provided that these conditions that I have mentioned are met. So it's established that such awards can bar further litigation, entrenching the principle or the principle of res judicata. So the whole essence of this is that for us in Nigeria, and I see that if this particular article is brought before the court, for instance, in Nigeria, there is a likelihood that the court will actually uphold that particular arbitration clause and using this yardstick as the basis for either upholding the arbitration clause or refusal to uphold the arbitration clause. So then this brings me to the issue of whether, my sister Zubeda said earlier, whether or not a particular citizen who has associated themselves with the Supreme Council of Uganda is aware that a particular provision is there in the Constitution at that point. Since there is an opt-out situation, the section has given, or the article has provided that if the event that you do not wish to be guided by that particular provision or the mark, then you have 30 days within which to opt out. So this particular situation will now is now the delicate situation in this circumstance. So the court might want to know whether there is voluntariness, whether there is consent, whether the consent whether the consent can be implied like that. So for me, this is how I see it. I actually see that that particular article can be likened to what we have as either traditional, customary arbitration, which our courts in Nigeria have actually uphold, irrespective of the definition of arbitration that the Arbitration and Mediation Act 2053 has provided. And you know, it means that the definition that arbitration has been given within the purview of the law or the interpretation of the court is actually broadened to include such circumstances or relationships that are not only commercial, but are also contractual, right? And in that circumstance, these are some of those issues that will come up. And I'm glad that Dr. Mahmoud has talked about the fact that part of the reason why he is in this forum is to actually understand and welcome suggestions as to whether or not the scope of that provision can be amended or changed to suit what is available on ground.
Thank you very much, Hawa. We appreciate the Nigerian perspective, and given your level of expertise, we know you're representing on a global scale what has worked. In summary, for those who are having trouble listening to her because of technical issues, she seems to suggest that while we do have the limitation in the Supreme Council clause, the principles remain of consent and consensus. Whichever way we slice the pie, whichever way we shake these parties in an ADR, be it mediation, adjudication, arbitration, have to agree to the process at the bare minimum. There are lots of other issues here around neutrality, around impartiality, because we've had speaker after speaker, even outside this panel, where they said the qualifications of the tribunal, all those will be put on hold, because I will use the discretion to understand that. Again, the most critical of any dispute is for it to have a finality, but also to be enforceable. So in the remaining few minutes we have before we go for prayer is to come back to this panel to give us assurances, to allay our fears that this very clause, at the bare minimum, will guarantee the finality that Dr. Hafiz, Dr. Hosseini, that Honorable Basalirwa have all been saying, that if we are to do this right, at the bare minimum, the one deliverable should be finality. So I'll start with Dr. Mahmoud. Speak to us about the finality in this clause, especially where it is said that if people are dissatisfied, there is no recourse, there is no appeal. I hope the audience is following.
Well, Thank you, Sister Mariam. Well, as I said before, it's very difficult to judge the attributes of the mark using the provision of Article 28 only, without looking at the procedural aspect of it. But as it is, we can confirm that at the end of it all, there will be aspect of finality when we roll out the arbitration function of the Article 28. I just want to also inform you that the membership or the chairmanship and the membership of the MAC is not the arbitration body that will be arbitrating. Our work as the membership is to ensure that we create those arbitration bodies that will help us do the arbitration. So maybe that is the confusion that is there. People think that, as Dr. Mahmoud will sit and say, let us arbitrate. No, it's not like that. We are just a trusteeship body helping organize and create a secretariat that will put an enabling environment for arbitration to take place. But we shall be having independent arbitrators to come and do the arbitration. So the question of finality will be addressed.
Thank you very much. What we hear from the Muslim Supreme Council is a promise to address these issues, which is good enough. Thank you very much. Zubeda, finality.
I have difficulty discussing finality because we already have the MAC arbitration clause has actually been tested. We have cases. We have Swaib Bunsimbe. These members have gone to court challenging some of the works of the Uganda Muslim Supreme Council, and they've been thrown out because of this arbitration clause, which he says is not working yet. So I don't get it. This is in access to justice. As a body that is supposed to be a unifying body for Muslims, we should be able to challenge the acts of those who are holding office in the Uganda Muslim Supreme Council. And if that doesn't happen, then we are going to have a problem. Ideally, I think on the brighter side of things, the threshold has been provided by the law. Section, I haven't had him refer to any provision of the Arbitration and Conciliation Act, but Section 2, Section 3, all those talk about what an arbitration clause looks like. And the point that has been reiterated all along is party autonomy. Parties should agree. They should agree on the rules. They should agree on the process. They should agree on who deliberates, all those things. I think this is a call to action. If the Muslim Supreme Council is going to have inclusive justice, that arbitration clause has to be amended to cater, to align it with the Arbitration and Conciliation Act. And I yield.
Thank you very much for yielding. We've come a long way to this point. I know there's a lot to be said, but in all fairness, we need to hear from the audience. Luckily, everything is documented. Luckily, Dr. Mahmoud has confirmed that everything is still in the kitchen, bacha afumba. So this is our chance to choose what we want, Royco, kachumbari, whatever we add in. We do have only 10 minutes for the Q&A. For the online audience, please keep sending through your questions and comments throughout the lunch break. We have a secretary taking notes. What we can assure you, if we do finish on time, which we want to do, we are going to have an hour and a half for town hall. We'll address all these things. The ones we can address here, we shall address here. If they are addressed to a particular panelist, you state the name, we shall call them back. But we will do our best to leave no stone unturned. So let's give a chance. Yes, Co-MC, please pass around the mic. So we have at least latest quarter to 2, we should go and pray and then have an extended lunch.
Thank you.
Thank you very much. My name is Mukasa Siraji Katantazi. I am the Chief Executive Officer of Uganda Muslim Lawyers Association. I must also add that UMLAS did participate in the process of amending the Uganda Muslim Supreme Council Constitution.
UMLAS did or did not?
Did.
Thank you.
When Zubeda was starting her submission, she used an analogy of her experience in the bank. You could feel the tension among the panelists. It was very palpable, which meant that there are clear issues that need to be addressed. I want to start by saying that it is the spirit under which the MAC was established that should be overriding. Just like you have the Muslim Arbitration and Mediation Center, it does not, in the name, spell out the different ADR mechanisms. But it, by necessary implication, means that it can adopt them. I would want to also assume that the same can be applied to the MAC. That said, my concern is, actually when I read Zubeda's article, I wanted to critique the critique. And my critique is on the decisions that court has made. This is a highly technical issue. I want to give it a perspective from Zubeda's experience in the bank, that you explain it as if you're explaining it to a 6-year-old. My disagreement with the decision that was made by Dr. Singiza lies in the clause, in the article itself. The article says that the MAC will have jurisdiction to hear matters including mismanagement. But the body that appoints the MAC is the joint session. So if the joint session appoints the MAC, and then you have to go to the MAC to have your dispute on mismanagement arbitrated by a body appointed by the Supreme Council, main body, it creates an issue. Now, as the reason I said I participated, I wanted to put a clear marker down that the process itself was hurried. And this was one of the concerns of Uganda Muslim Lawyers Association. Secondly, we did not have technical people to look at some of the other enabling laws to align them. The ACA was passed in 2000. I think the amendment in 2000. The amendment in the Constitution was done in 2022. I do take issue with Dr. Kibwanga to say that it has taken them 3 years to sit and establish an organ of the Uganda Muslim Supreme Council. In between there were administrative and leadership issues that would have been, I think, ordinarily expected to arise. So, whereas there is hope, but as I said, I wanted to critique the critique. And in a critique, you do not only look at the negatives, as Zubeda did, like the things that are not working out, but you also you give recommendations. And I think it is the part of recommendation that I wanted to address my mind to. I have just two. There are many, but I want to address two. The first one, it excludes issues on electoral disputes. The question then would be, where are these addressed? We should therefore come up with a better clause where issues of elections, which are basically going to be the main sticking issues when it comes to administrative issues in our societies. Secondly, as I think Zubeda tried to give justice to this, we should go back and try to align the MAC, this clause, with the SCA. In regard to compliancy with Section 3, Section 4, Section 5, for example,
your 2 minutes are running out.
Yes, I'm done. The requirement for written agreements for arbitrators, documented awards, options for civil court enforcement where it has been escalated. Thank you very much.
Thank you very much. Kindly do write out those for our, if you're on the Zoom link, we really need them just in case we miss them in the town hall. The next one, please. 3 minutes.
Assalamu alaikum wa rahmatullahi wa barakatuh. I'm Nagadia Hamida, a lecturer at Islamic University in Uganda. My concern is that, one, we should all agree that this Article 28 has... Okay, I was saying that we must all agree that Article 28 has issues. And my recommendation in respect to that, as I was hearing the presenters saying, is that, one, let us, those rules or guidelines that you're saying that the institution is coming up with, can we have them before they are published, before they come into force, so that we look at all these issues plus others that we may have overlooked, and then we have inclusivity when it comes to justice, and we do not have any kind of impediments. Because if at all...
I've been in this thing since 1979. I thank Allah. I have attended all the disputes, the Kasamala agreement from Makkah, from late Kasimu, from others. Kabwejere, I was part of the team drafting this constitution. I was part. This is my suggestion. Alhamdulillah, the Muslim community, we are getting people like this organization here. I feel so happy, having seen what has been happening. Two, the elite in our community, they are not coming up to support our future. I am requesting, now that some of our land, the lawyers, the others, come to Supreme Council and share in a more days, same thing. This constitution, not only that article, but alhamdulillah, there is somewhere we can begin from. But if we are going to get an article in such a very big gathering where we want to get the Qadi's court, and then we start pinning ourselves inside from here, it will mean, may I understand, but another person will say, oh, this gathering was all about Supreme Council and the case. Get me right. What I'm requesting, some of these issues, they touch us today and even after us. And they are good. Let us go to the right forum. You, the blind people, come to our elders so that we can look at some of these things in a good time. But at this forum, we may look as if we are polling. It is not only that article. Another thing, it is premature to discuss it here. There are so many other things there in that constitution. But what I'm saying is summarily, the elite people within the Muslim community, as if others are saying what is there. Previously, you would send Supreme Council, but I can tell you, at least things are getting better. Okay? But the people, the elite people to guide, they are shying away. Please come. Thank you.
Thank you so much for that invitation. One last comment. Online people, please send through your thoughts. We'll come back to them in the town hall. One last one.
Thank you very much. It has been a very insightful session. Myself and some of the beneficiaries of the ADR. Thank you very much. I think I'm asking for myself and for the beneficiaries of the ADR. On the panel, it has come up the difference between ADR and arbitration, adjudication, negotiation. While you have tabled that question to him, I request that you please clarify for us as well. Because according to me and some other people out there, ADR may be just the same as arbitration. So if it's a cause of question on the section 28 or article 28, then we need clarity.
Okay. Thank you very much. In 1 minute, I will summarize and respond so that we don't waste time. ADR is an acronym for Alternative Dispute Resolution, which many are now calling appropriate, the most appropriate, because we know the challenges with the traditional court system. It has mediation, conciliation, mutual evaluation, as we go along, all the way up to arbitration. I would call arbitration the highest in ranking, one, because it is almost as good as a court. It gives you a binding decision once. That's why it is contentious, because all the others, it is about consent. Until you agree, then it cannot be binding. Nobody makes the decision for you. In all the others, It is the parties. Even when you agree today and then tomorrow you change your mind, nobody's going to hold you at gunpoint. Why arbitration is contentious is because the minute a party addresses themselves to resolve a dispute under arbitration, that means they are bound. Teri kuda mabega. Teri koti, teri kuda mabega. And that is why that one is very sticky. We are going to give you the Luganda versions in a second, and I anticipated that question, but please let me read so that I don't butcher them. Yes, I do. Okay, quickly, reconciliation is kutabaganya. Mwemuli mediation, conciliation, then neutral evaluation, let's leave it aside because it is like coming to see, will it be a yes, will it be a no? You come to Omumanyi, like you come to one of these judges and say, I have this guy, he stole my goat, never mtwala mkoti, is it worth it? Nagamba tota wana, seteze koti, wachiri mutese. It is not a binding decision, but is guiding from experience. Then arbitration is okusalo musango, the way it is done in court, meaning the decision is binding. But also another thing to note about arbitration, you subject yourself to it at the time of contracting. Chetugambe chonti tosobola chibukamu oba wachiyingiramu. It's like marriage, where they say I do and then you cannot say I don't. Negotiation ebyabulijo entesaganya. I beg to be excused on the marriage thing. You say I don't under special conditions. Okay, negotiation is enteseganya. We see this a lot in conflict resolution where Dr. Mahmoud is a pro-nations people. You negotiate with your hubby, with your child, with the shopkeeper, and it's really neither here nor there. Then dispute resolution generally is okukanya. So why arbitration is very sticky is because it is as good as a court decision, meaning who you choose, how you choose, where you choose, you are bound by that. We really, really appreciate your interest in the subject matter. Now we know there is a need and a gap. We are going to do our best. At least I'm going to force the debate that we have a webinar. That one doesn't limit numbers before the year ends. Instead of an end-of-year party, we are going to have a webinar in Luganda and English to break down these things. Thank you very much. We would love to continue, but let's go and honor our maker. And then when we come back and we are as good as we have been, I know we will finish in an hour, then we have the rest of the afternoon for a town hall where we shall address all these things. Assalamu alaikum wa rahmatullahi wa barakatuh. Going back to the lunch preparations, we have prayer points, we have a masjid, we have ablution points on each floor. But for lunch, we do have a set of VIPs who can stay in the room. We'll take them to where they eat. The rest of us are going right below. There's a hall where we'll have general lunch. Kindly, can we be back at exactly 2:30? Okay, 2:45. The food is good, but don't eat too much so that we can continue. Assalamu alaikum.
Sepanjang hidupku, oh Ramadan. Ramadan, Ramadan, di أجرا جئت بعد العسر يسرا ربنا أعلاك قدرا يا إمام الأنبياء أنت في الوجدان حي أنت للعينين ضي أنت عند الحب ري أنت هاد وصفي يا حبيبي يا محمد يا نبي سلام عليك يا رسول سلام عليك يا حبيب سلام عليك صلوات الله عليك يا نبي سلام عليك يا رسول سلام عليك يا حبيب سلام عليك صلوات الله عليك يرتوي بالحب قلبي حبي خير رسل ربي من به أبصرت دربي يا شفيعي يا رسول الله أيها المختار فينا زادنا الحب حنينا جئتنا بالخير دينا يا ختام المرسلين يا حبيبي يا محمد يا نبي سلام عليك يا رسول سلام عليك يا حبيب سلام عليك صلوات الله عليك يا نبي سلام عليك يا رسول سلام عليك يا حبيب سلام عليك صلوات الله عليك يا نبي سلام عليك يا رسول سلام عليك يا حبيب سلام عليك صلوات الله عليك يا نبي سلام عليك يا رسول سلام عليك يا حبيب سلام عليك صلوات الله عليك يا نبي سلام عليك يا رسول سلام عليك يا حبيب سلام عليك صلوات الله عليك يا نبي سلام عليك يا رسول سلام عليك يا حبيب سلام عليك صلوات الله عليك I praise Allah for sending me you, my love. You found your home and here with me, and I'm here with you. Now let me let you know, you've opened my heart. I was was always thinking that love was wrong, but everything was changed when you came along. Oh, and there's a couple words I wanna say. For the rest of my life, I'll be with you. I'll stay by your side, honest and true, till the end of my time. I'll be loving you for the rest of my life. Through days and nights, I'll thank Allah for opening my eyes. Now and forever, I'll be there for you. I know it deep in my heart. I feel so blessed when I think of you, and I ask Allah to bless all we do. You're my wife and my friend and my strength, and I pray we're together in Jannah. And now I found myself, I feel so strong. Yes, everything was changed when you came along. Oh, and there's a couple words I wanna say. For the rest of my life, I'll be with you. I'll stay by your side, honest and true, to the end of my time. I'll be loving you for the rest of my life. Through days and nights, I'll thank Allah for opening my eyes. Now and forever, I'll be there for you. I know it deep in my heart. Now that you're here in front of me, I strongly feel love, and I have no doubt, and I sing it loud, that I will love you eternally. For the rest of my life, I'll be with you. I'll stay by your side, honest and true, to the end of my time. I'll be loving you for the rest of my life. Through days and nights, I'll thank Allah for opening my eyes. Now and forever, I'll be there for you. I know it deep in my heart. I'm about to lose the battle and cross the line. I'm about to make another mistake, and even though I try to stay away, everything around me keeps dragging me in. I can't help thinking to myself, what if my time would end today, today? Can I guarantee that I will get another chance before it's too late, too late, too late? Forgive me. My heart is so full of regret. Forgive me. Now is the right time for me to repent, repent, repent. Am I out of my mind? What did I do? Oh, I feel so bad. And every time I try to start all over again, my shame comes back to haunt me. I'm trying hard to walk away. Temptation is surrounding me, surrounding me. I wish that I could find the strength to change my life before it's too late, too late, too late. Forgive me. My heart is so full of regret. Forgive me. Now is the right time for me to repent, repent, repent. Every time you feel like you cannot go on, you feel so lost and that you're so alone. All you see is night and darkness all around. You feel so helpless, you can't see which way to go. Don't despair and never lose hope, 'cause Allah is always by your side. Inshallah, 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 you'll find your way. Inshallah, 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 you'll find your way. Every time you commit one more mistake, you feel you can't repent and that it's way too late. You're so confused, wrong decisions you have made haunt your mind and your heart is full of shame. But don't despair and never lose hope, 'cause Allah is always by your side. Inshallah, 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 you'll find your way. Inshallah, 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 you'll find your way. Turn to Allah, He's never far away. Put your trust in Him, raise your hands and pray. Ooh, yeah, Allah, guide my steps, don't let me go astray. You're the only one who can show me the way. Show me the way. Show me the way. Show me the way. Inshallah, 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 we'll find our way. Inshallah, inshallah, البدر كطلعته وجه جميل والشمس كبسمته ظل ظليل هو عبد الله سيد الخلق ومصطفى وحبيب الله خير مبعوث بوحي الله مولاي صل وسلم دائما ابدا على حبيبك خير الخلق كلهم مولاي صل وسلم دائما ابدا على حبيبك خير الخلق كلهم يا رب صل عليه يا رب صل عليه يا رب صل عليه صلوات الله عليه هو خير عباد الله خير البرايا حي فينا بهداه حلو الوصايا نسألك الله أن تجمعنا يوما برسول الله من كوثره يروينا فتقبل يا ربنا مولاي صل وسلم دائما أبدا على حبيبك خير الخلق كلهم مولاي صل وسلم دائما أبدا على حبيبك خير الخلق كلهم يا رب صل عليه يا رب صل عليه يا رب صل عليه صلوات الله عليه طاهر القلب نقي ذاكر لله المصطفى الصفي صلى عليه الله أخلاقه وصفاته سبحان من سواه هو قدوتي وحبيبي ودعوة النجاة يا رسول الله يا حبيب الله اكتب لنا نلقاه ندعوك يا رباه مولاي صل وسلم دائما أبدا على حبيبك خير الخلق كلهم مولاي صل وسلم دائما أبدا على حبيبك خير الخلق كلهم يا رب صل عليه يا رب صل عليه يا رب صل عليه صلوات الله عليه مولاي صل وسلم دائما أبدا على حبيبك خير الخلق كلهم مولاي صل وسلم دائما أبدا على حبيبك خير الخلق كلهم يا رب صل عليه يا رب صل عليه يا رب صل عليه صلوات الله عليه Allah किया करो दुगना किसी को दिया करो जो दुनिया का मालिक है खामोशी का लिया करो अल्लाह ही अल्लाह अल्लाह ही अल्लाह अल्लाह ही अल्लाह किया करो दुगना किसी को दिया करो जो दुनिया का मालिक है खामोशी का लिया करो अल्लाह ही अल्लाह अल्लाह ही अल्लाह just like a sunrise can't be denied. No, just like the river will find the sea. Oh Allah, you're here, you're always near, and I know without a doubt that you always hear my prayer. सच की राह पे चला करो, दुगना किसी को दिया करो, जो दुनिया का मालिक है खामोशी का लिया करो. अल्लाह ही अल्लाह, अल्लाह ही अल्लाह, अल्लाह ही अल्लाह किया करो, दुगना किसी को दिया करो, जो दुनिया का मालिक है खामोशी का लिया करो. अल्लाह ही अल्लाह, अल्लाह ही अल्लाह. So many bright stars like diamonds in the sky. Oh, it makes me wonder, anyone can be blind to all the signs. So clear, just open your eyes, and I know without a doubt you will surely see the light. तेरी ही दुनिया, तेरी ज़मीन, ये कहकशां है, तू है करीम मेरे मौला. सुन ले दुआ, हम बेबस है तेरे बिना, रोशन कर जामा. ऐसा जुल्म न किया करो, दुख न किसी को दिया करो, जो दुनिया का मालिक है खामोशी का लिया करो. अल्लाह ही अल्लाह, अल्लाह ही अल्लाह, अल्लाह ही अल्लाह किया करो, दुख न किसी को दिया करो, जो दुनिया का मालिक है खामोशी का लिया करो. अल्लाह ही अल्लाह, अल्लाह ही अल्लाह. अल्लाह ही अल्लाह किया करो, दुख न किसी को दिया करो, जो दुनिया का मालिक है खामोशी का लिया करो. अल्लाह ही अल्लाह, अल्लाह ही अल्लाह, अल्लाह ही अल्लाह किया करो, दुख न किसी को दिया करो, जो दुनिया का मालिक है खामोशी का लिया करो. अल्लाह ही अल्लाह, Allah hi Allah, Allah hi Allah, Allah hi Allah. this special day. Our hearts are full of pleasure. A day that brings the two of you close together. We're gathered here to celebrate a moment you'll always treasure. We ask Allah to make your love last forever. Let's raise our hands and make dua like the Prophet taught us. And with one voice, let's all say, 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 Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu Inshallah, you'll share all your joys through hardships, support each other. Together, worshiping Allah, seeking His pleasure. We pray that He will fill your life with happiness and blessings, and grant you kids who make your home filled with laughter. Let's raise our hands and make dua like the Prophet taught us, and with one voice, let's all say, Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallah, 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 Barakallahu lakum wa lana. Barakallahu lakum wa lana. Allah barik lahuma, Allah adim hubbahuma. Allah salli wa sallim ala rasulillah. Allah tub alayna, Allah irda anna, Allah ihdi khutana ala sunnat nabina. Let's raise our hands and make dua like the Prophet taught us, and with one voice let's all say, Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. Barakallahu lakuma wa baraka alaykuma wa jama'a baynakuma fi khair. رقت عيناي شوقا ولطيبة ذرفت عشقا، فأتيت إلى حبيبي فاهدأ يا قلب ورفقا. صلي على محمد. السلام عليك يا رسول الله. السلام عليك يا حبيبي يا نبي الله. السلام عليك يا رسول الله. السلام عليك يا حبيبي يا نبي الله. محمد يا طيبة جئتك صبا لرسول الله محبا بالروضة سكنت روحي وجوار الهادي محمد السلام عليك يا رسول الله السلام عليك يا حبيبي يا نبي الله السلام عليك يا رسول الله السلام عليك يا حبيبي يا نبي الله يا رسول الله. أجمل فرحة هي يوم فرحكوا ده شيء أكيد ذكريات الليلة دي حضرة مش ممكن تغيب إحساس اليوم ده مين فيكم ينسى على طول تجمعكوا أحلى حياة أجمل فرحة في حياة كل ليلة حلوين والله ما شاء الله يا سلام يا سلام من باب يا الله حلوين والله ما شاء الله يا سلام يا سلام من باب يا الله انتوا على سنة نبينا جيتوا وكتبتوا الكتاب واحنا طايرة الفرحة بينا والليلة دي القلب داب إحساس اليوم ده مين فيكم ينسى على طول تجمعكوا أحلى حياة أجمل فرحة في حياة كل ليلة حلوين والله ما شاء الله يا سلام يا سلام من باب يا الله حلوين والله ما شاء الله يا سلام يا سلام من باب يا الله. قولوا ما شاء الله يا رب تعيشوا أحلى سنين قولوا ما شاء الله يا محلى زوجين صالحين ربنا يجمعكم ويا بعض في الجنة ربنا يجعلكم طول العمر متفاهمين قولوا ما شاء الله يا رب تعيشوا أحلى سنين قولوا ما شاء الله يا محلى زوجين صالحين ربنا يجمعكم ويا بعض في الجنة ربنا يجعل طول العمر متفاهمين أجمل فرحة في حياة
رمضان كريم وخير كثير يضيء القلوب كما نرفع أكفنا ندعو الإله رضاه نريد ونحيا بكم يسكننا الحب في كل داعي ونملأ دنيانا بدر النهار تحلق أحلامنا في السماء ونسأل ربي سلاما يدوم رمضان كريم وخير كثير يضيء القلوب كما ينشر النور نرفع أكفنا ندعو الإله رضاه نريد ونحيا بثوح يا رب زدنا هدى ونقاء وامحو الذنوب بنور السماء لك المنتهى وإليك المصير فأنت الرحيم وأنت الغفور رمضان جاء ونوره عم ففيه الحياة وفيه النعم هل الهلال وفاض الضياء وعم السلام وزال العناء نبدأ شهرا بنور القرآن ونحيا بحب وروح الإيمان رمضان كريم وخير كثير يضيء القلوب كما ينشر النور نرفع أكفنا ندعو الإله رضاه نريد ونحيا بكم يسكننا الحب في كل داعي ونملأ دنيانا بدر النهار تحلق أحلامنا في السماء ونسأل ربي سلاما يدوم رمضان كريم وخير كثير يضيء القلوب كما ينشر النور نرفع أكفنا ندعو الإله رضاه نريد ونحيا بثوح يا رب زدنا هدى ونقاء وامحو الذنوب بنور السماء لك المنتهى وإليك المصير فأنت الرحيم وأنت الغفور رمضان جاء ونوره عم ففيه الحياة وفيه النعم نحمد ربي ونسعى لخير ونبقى على الحب درب النسير هل الشاغر والنور أضاء فانشرح القلب وزال اللنا رمضان جاء بروح السلام يهدي القلوب ويمحي الظلام نور رمضان في كل دار يملأ أنياننا خيرا ونور فيه الهدى وفيه الرجاء نحيا بحب وندعو الإله يهدي الصائم درب النجاة ويرفع الدعاء في كل صلاة تزكو القلوب وتسمو الروح ونسأل الله غفران الجروح نور رمضان في كل دار يملأ أنياننا خيرا ونور فيه الهدى وفيه الرجاء نحيا بحب وندعو الإله يا ربي بارك لنا اليقين واجعل صيامنا في الصالحين زدنا هدى وأعنا عليك فرضاك غايتنا في الحياة نور رمضان يسكن القلب يمحو الذنوب ويرفع الحب في كل نبض ندعوك ربي فارحم نداك واغفر لنا رفعت يدي ودمعي يسيل أدعو إليك إله الجليل في كل لحظة وفي كل حين أرجو الرحمة وقلبي حنين دعاء يرتفع نحو السماء يحمل أملا ويمحي العنانا يا رب الحب لي نور الطريق واجعل حياتي دربا منير إذا ضاق جئت بالرحمة والخير الحنان في ظلك نستبشر بالإيمان ونمضي بنورك بلا أحزان. مرحبا يا رمضان شهر البركات في صومنا رحمة وفيك النفحات يا نور دربنا ومصباح اليقين فيك الهدى وبركات السنين. في ليلك ناجينا ربا كريم وبالصبر نحظى بأجر عظيم. نرتل آيات بكل خشوع ونملأ أيامك بالخير يطول. مرحبا يا رمضان شهر البركات في صومنا رحمة وفيك النفحات يا نور دربنا ومصباح اليقين فيك الهدى وبركات السنين. يا رب فيك قلوبنا تهتدي فبرحمتك كل دعانا يبقى يهتدى. رمضان شهر النور والإحسان نبقى على عهدك في كل زمان. مرحبا يا رمضان يا شهر السلام جئت بالخير وزدت الوئام فيك الأمان وفيك الهدى وبركاتك تبقى أبدا. صوت الأذان ينادي بحانا يسكن قلبي ويضيء معانا يهدينا للنور في كل حين فيه الهدى وارضى مؤمنين. يا رمضان نورك في الأكوان بالصوم نرجو رضا الرحمن. صوت الأذان يملأ الدنيا يحمل الحب ويجلو الأسان. يأتي الميصاه بأجمل نور يحمل بشرى لكل الصدور يروي قلوبا بذكر الإله ويمسح عنا عناء الحياة. يا رمضان نورك في الأكوان بالصوم نرجو ارزقنا فيه السكينة تدوم ندعوك بالحب ولا الاشتياق ونرجو جناتك في الآفاق صوت الأذان في رمضان يحمل نورا بكل زمان يحكي حكايات صوم نقي ويبقى دليلا لقلب وفي ليل القدر نور يهدينا فيها الرحمة تحيا فينا تنزل فيها بركات السماء ويسمو الدعاء للمصطفى يا ليلة فيها السكينة رحمة الرحمن تملأ المدينة فيها القرآن نور الحياة ونجد فيها أعلى النجاة سلام تنزل حتى الفجر بذكر الله يسبح الدار أبواب رحمته قد فتحت والقلب ناجى والدمع ساح يا ليلة فيها السكينة رحمة الرحمن تملأ المدينة فيها القرآن نور الحياة ونجد فيها أعلى النجاة يا رب فيها قبل دعانا وامحو الذنوب سامح خطانا نسألك العتق والمغفرة وباب جناتك المنير ليلة القدر فضل كبير خير من الدهر نور منير نجد فيها الروح والأبد ونحن بين الدعاء والقناة رمضان في قلبي نور يستمر يحمل خير ويزداد العطر فيه الرحمة تزهر كالورود ويملأ الدنيا ضياء وسجود يا رمضان يا نور الزمان فيك السعادة هو الإيمان
Assalamu alaikum wa rahmatullahi wa barakatuh. May we please take our seats? I wish to welcome you back from the lunch break and the salah break. Our online audience, thank you so much for sticking with us up to this point. I understand that the session before lunch was a great one, and we did not leave empty-handed. One of the things we resolved is that we shall have a webinar to break down ADR from first principles for the benefit of the Ummah. We've also agreed that there will be outside continuation of this conversation between the Uganda Muslim Supreme Council and MAMC to make sure that we bring this to a logical conclusion, and where need be, before any further steps are taken, the clause is brought up to standard with the international arbitration clauses. Every other issue in between we are going to try and address in the town hall so that we don't leave things hanging. But should we not complete in the stipulated time, please do engage. MAMC has social media handles on Twitter, LinkedIn. Please come, share your thoughts post this event, share your thoughts anytime you watch, because these recordings are going to be left on YouTube specifically. We shall visit them from time to time to get an updated version of your thought process, your suggestion, and we keep the conversation going. I think it's a timely, important conversation. We thank our special invited guests for sticking with us through that day. It's a jam-packed day, but I want to confirm that we are not laboring in vain. All this is going to lead to the betterment of the Ummah. Without wasting much more time, I would like to introduce the topic alongside the panel for the third and last discussion for the day. This one, I think we are going to enjoy it. Unlike the other one where we were all on bunkenks, this one we are going to enjoy it. Let's learn, let's enjoy, let's share information accurately, and then call it a fruitful, productive day by the grace of Allah. That discussion is going to center around what the Succession Act means for Muslim estates. This one I'm not even going to try my little Uganda because the moderator, the panelists are more senior than me. So I'll just invite Faizo, His Worship, Faizo Mularira, to come and introduce his panel, and then we'll have the conversation. While he comes, I'll share a little bit about him so that we know that we are in the capable hands. Just a second. I do not want to butcher this very heavy CV. Otherwise, I'll be sued. I don't know what, it will be defamation or something or misrepresentation. So I want to get all the T's crossed and the I's dotted. So His Worship Faizo Mularira is a seasoned legal professional and an academic. He is currently serving as a deputy registrar at the Wakiso High Court. He has contributed to legal education in many forms, and he has written papers, but he is currently pursuing a doctorate of laws at Makerere University School of Law. And we look forward to hearing his views as he guides this panel in a topic that concerns us all. Welcome to the panel, and please, the floor is yours.
Thank you, MC. Assalamu alaikum wa rahmatullahi wa barakatuh. Yes, it gives me great pleasure and honor to welcome you for this session. I want to welcome the people in person, attendance in person, those that are with us. I also want to thank those that are virtually joining us from wherever you are. Thank you so much for taking off time to be with us. I feel honored and privileged to be here. This is my second time here. I come to chair a panel on what the Succession Act means for Muslim estates. I have a panel of 3 eminent speakers this afternoon, and I will be inviting them, then I will introduce them while they are at the podium. Colleagues, join me to welcome the Honorable Lady Justice Syria Nagawa. My Lord, you're warmly welcome. And Hajat, yes. The Honorable Hajat Justice Syria Nagawa. I also want to warmly welcome Mr. Robert Ali Bogele, a senior state attorney in the chambers of the Administrator General, heading the Arua office of the Administrator General's office. Ali, you're warmly welcome. We also have Dr. Sowed Mayanja, our distinguished academic, and as I will introduce him. Doctor, you're warmly welcome to take your seat. Our colleagues, our speakers, as I've mentioned them, we have the Honorable Lady Justice Hajat Syria Nagawa, who is currently serving as the judge of the High Court at the Family Division since 2022. She's a focal judge in Uganda on adoption, but she also serves at the International Crimes Division as a visiting judge, which mirrors the International Court of Justice. So we are very privileged to have the Honorable Lady Justice Hajat Syria Nagawa. She has a number of qualifications to her name, a master's degree from University of Sussex, and a bachelor's from Makerere University, and of course, a postgraduate diploma in legal practice. She's known in the commercial sector as being an insurance practitioner across various countries, particularly Australia and New Zealand. She has been a member of the judiciary since 2022 and previously served as a secretary at the NGO board. As I said, she's a focal judge on matters relating to children, and she serves in the Family Division. She also worked as a National Risk Assessment Officer under the Anti-Money Laundering and Counterterrorism Financing with the Financial Intelligence Authority of Uganda. And she worked tirelessly until when Uganda was removed under grey risk. She has been spearheading implementation and designing so many projects, particularly USAID, InterAid, New York, the TIA Fund of UK, where she traversed the globe, serving in war-torn and ravaged areas of Afghanistan, Pakistan, India, and other voluntary organizations in the UK and in the USA. Honorable Lady Justice Syria is inspired by serving humanity, justice, and being a champion for others that can't help themselves. Justice Syria will today be giving us an insight into the implementation at the judiciary's level of the Succession Act as amended. Let's put our hands together and welcome Lady Justice Syria. The other speaker with me is Mr. Bogele Ali Robert, who is a senior state attorney in Attorney General's Chambers in the Ministry of Justice and Constitutional Affairs. He has had a career track, uninterrupted, of more than 10 years, serving in the Administrator General's office, and he has been behind the revisiting of the law to look at the design of succession from the 1900 Buganda Agreement throughout the succession registers and all that history until the amendment of 2022. He was pivotal in the task force that reviewed the Succession Act, and he also served as a consultant on the task force that was instituted by the Attorney General, the Judiciary, and the Administrator General's office to revisit the closed succession registers under the then succession regime in Buganda. He's been known to appear on various TV, radio stations, and other universities, giving open lectures about succession, administration of estates, designing of estates, both tested and intestate. He's an external examiner at the Lord Bowman Center, particularly focusing on that back course where he teaches matters related or examines exams relating to family law practice. Let's welcome Robert Ali Bogele. The other speaker, in whose pot of knowledge we are always privileged to tap in, is Professor Sowed Juma Mayanja. Professor Sowed Juma Mayanja is an associate professor of Sharia at the Islamic University in Uganda, and currently takes the singular honor to serve, by God's grace, as the university imam at Makerere University. He has also been behind so many innovations, particularly bringing the unbanked Islamic community into the banked gap that responds to the teachings and the dictates of Sharia law, where he started designing courses in Islamic banking. Until now, he was appointed as one of the members of the board of directors of the Onre Islamic Bank in Uganda, Salam Bank. Prof, you're welcome, and we are delighted that you're leading us into the realm of acceptable Islamic financing. We shall delve straight into the conversation. Let's welcome Prof, please. So we shall start with Honorable Lady Justice Hajat. I feel the term doctor is missing. I hope it was coming soon. Honorable Lady Justice Hajat Dr. Syria Nagawa. Yes, my Lord, you have been at the center for the last 5 years, focusing on administration of justice in the realm of succession and inheritance. But also as a former practitioner, you did a lot of work in arrangement of estates, family law generally, and ensuring that even when we are faced with misfortune of death, the family still remains as the basic component of the society. To our listeners, both here and those online, can you help us break down the concept of succession generally, and tilt the interplay of Islamic succession, or how the Ugandan law can be recasted to bridge the gap between inheritance as understood by Muslims and inheritance as understood in Uganda?
Thank you. Assalamu alaikum wa rahmatullahi wa barakatuh. The area is quite broad, but like he has said, I'll try to bring the segments of succession law to what exactly he wants me to respond to. First of all, with succession law, it comes into play. I'm talking about the amendment, not that because we haven't had one before. Definitely we had the Succession Act before until the amendment of 2022. But succession law only comes into force upon death. And one dies either testate or intestate. And what does that mean? Testate, there is a will. Intestate, there is no will. And however, when somebody dies testate, and this person is a Muslim, they might have left a will and specifically stated how they want their estate to be administered. And that is where we get into our arena here to speak about. Because if one dies testate, they've left a will, they could have said, I want my estate to be distributed into the Sharia law. Yes? And then it carves out, but eventually comes back. And what do I mean carves out of the law and then comes in? Because Sharia, then we go to the sheikhs. We go to the Islamic side. But there is a comeback. into that Succession Act. And what do I mean there is a comeback? The testator could have stated, I bequeath you land. It was in the testator's names. But now this land will never come into your names through the sheikh. You have to come back this side of the law so that the administrators or the executors have the land transferred into their names and then into your name. So somewhat, you'll have to find yourself back. There is a will, but you have to find yourself back. And when you find yourself back, then the process begins. I don't know how much time I have on this, 2 or 3. So then you petition for grant of probate if there is a will, or letters of administration if there is no will, and the qualifications of it. But lately, now, I'll go very fast, the letters, you know, they have 2 years. They expire, meaning that you have to do everything within that time before the letters expire. So that letters of administration that the executors have will help you have the estate transferred into your names. So they have bequeathed to you, Sharia, and then you come back. Now, what happens if there is no will? When there is no will, at times we sit in our homes, we distribute the estates, the sheikhs come home, we distribute. But when we disagree, we walk. We go to my brother Ali in disagreement. He has those initial meetings. You disagree. He notes out everything, and then you come to court through a petition for letters of administration. Or at times, the deceased has left a will, but amongst the families, our Muslim families are so huge, you disagree. You say, no, this is not the deceased will. We are not abiding by it. And then you go and you come back. So either way, you have to find yourself under the operation of the Succession Act and its operations. That is, you file the inventory, you account for the estate, you distribute the estate, you reserve the residential home or principal holding. If they're young children, then you have to go into guardianship, which many people don't want to talk about. Or before you even come for the letters, you would have intermeddled with the estate, which is an offense, and so on and so forth.
Now, there's been a problem with the delayed implementation of the Qadhi's courts as dictated by the Constitution. And many times these estates might not be big to come to the High Court that is vested with unlimited original jurisdiction. And the sheikhs are also an integral part now that we are recasting our focus on use of alternative dispute resolution. What would be the role or the reception of the courts in terms of the Sharia-based decisions when the disputes arise therefrom and spill over to courts? What is the uptake like?
Thank you. That is a gap that we face with our civil courts. And why am I saying it's a gap? You'll find a judicial officer who will tell you, you went that way, finish that way. By that way, I mean you went Sharia, complete Sharia, or continue with your mediation. And I'm glad here we are talking about ADR and alternative dispute resolutions. So at times you'll be thrown out and say, no, you've already, for example, distributed the estate and there is nothing to talk about, or the estate was too small to come. However, even a small estate can still go before the magistrate's court. So the courts will always find a remedy for you, but it's how you approach it and what you're going to talk before that judicial officer. Not that they should throw your matter out, but they should be able to resolve. So if the threshold is so large for the lower court, for the lower court, you come to the higher court. If it's too small for the higher court, then you'll be going to the lower court. But in this state where we don't have the Qadhi courts operational, and they have tried to do the mediation, at times you look at the matter and it's almost to conclusion. And it's just a small thing remaining. So we try as much as possible to encourage the beneficiaries, the parties of the estate, to try to settle these matters outside court.
Thank you so much, my lord. I'll go straight to Professor. Professor, there seems to be an emerging tension between the divine allocation and the secular law allocations when it comes to inheritance. And Uganda's succession legal framework seems to have a tension that is always not closed. Even when people tend to agree, when the sheikhs are speaking to them, one or two will quickly jump ship and now want to upset it. Focusing from an Islamic perspective, can you try to help us to bridge this tension in distribution of estates in Uganda?
بسم الله الرحمن الرحيم الحمد لله رب العالمين وأصلي وأسلم على الحبيب المصطفى صلوات ربي وسلام عليه والآله وصحبه وسلم وأباد. السلام عليكم ورحمة الله وبركاته. I'm glad to be part of this session. Thank you for the question. How can we bridge the gap between
the secular distribution? Section 25 gives us how to distribute. Then the Sharia people also come and tell us how to distribute. And our families, because of Ubuntu, they usually jump out of this distribution and then disputes spill over to the courts, which tend to usually upset the entire distribution. How do we bridge the gap between the divine allocations and the secular allocation, and where a tension arises, how should it be handled?
First and foremost, people don't know the distribution and the logic behind the distributions in Islamic law. That is the fundamental issue. First and foremost, before the distribution, people need to be taught. This one gets this one gets this, the logic behind this is this, and so on. That was the first issue. Before you start the distribution, you don't just come and start distributing. But first of all, let the parties understand, what does Allah say? Okay? What is this? Who is supposed to get this? Who is supposed to get this? And why? Sorry? Oh, okay. Yes, so I feel that first and foremost, teaching the people that distribution is very paramount before we go to the distribution. Then we go to the logic. Because actually, the verses of succession are only three. Only three. Chapter 4, verse 11. Chapter 4, verse 12. Chapter 4, verse 176. These are the verses which need actually for people to understand. And actually, when you go deep in the Quran, there is nowhere in the Quran where Allah goes so much in details as in these three verses. There is nowhere. When it comes to fasting, he says fast, then the rest is left to the prophet to explain. When it comes to prayer, he says you pray, then the prophet comes in. But the distribution of the property was done by Allah himself. And all these verses, he says that Allah is all knower, all wise. That means the distribution was made basing on knowledge and his wisdom. So first and foremost, we have to teach the people. People say that my property should be distributed according to Sharia, but he doesn't know what the Sharia says. Now, let me talk on the issue of, which is really very contentious, about the male taking twice the share of the female. And this one has raised a lot of dust. Okay? Yes. But I want to give just a simple example. This is a man who has died and left a daughter and a son. A daughter and a son. And both of them, what they inherit is going to be their beginning, entandikwa. I don't know if you call it like that. It is going to be their what? Entandikwa. Okay, let's look at the boy. This boy, what he inherits, he has to prepare a home. He has to, when I say preparing a home, building a house, preparing the home, furnishing it, each and everything. Then on top of that, he has to look for a wife and is her mahar. Her mahar. Okay? Then on top of that, he has to feed her. Okay? Now, that is the son. Come to the daughter. The daughter, she's not expecting to build a house to dwell in with the husband, no. But when she thinks of building a house, rentals. And this is most of the ladies, yes, they think about rentals. Not a house to stay in with the husband. Okay? Secondly, she's expecting mahar. She can even request for a vehicle. She can request for, because here Sharia did not actually put a limit. How much should what? Should she be given in mahar? No. But she has every right. So, she's not required to build a house to dwell in with her husband. On top of, she's expecting to be given mahar. And on top of that, she's going to be fed by the husband. I'm talking under normal circumstances. Abnormal circumstances are dealt with abnormally. Okay? But I'm talking about normal circumstances. Okay? So, now look at these. The son and the daughter. Okay? And what they inherit is the entandikwa. Okay? Assume they don't have anything. They are starting with that. Who is benefiting more financially, actually? Now, this actually...
Prof, you make an assumption that people would inherit as a mode of starting life.
This, I brought it as an example and under ideal situations.
Yeah, but people inherit even in the evening of their lives.
Sorry?
People can inherit even in the evening of their lives. We've also seen women-led families. How do we balance that intersection from your perspective?
But I think I want you to get me right, because I was giving it as an analogy, whereby people are complaining that why does the son take twice the share of the daughter? This is why I brought that example. Otherwise, if people fail to understand, because we are not going to force people that you must take Sharia, because people now, you are free. You go to Sharia or you go to the civil law. You are free. There is no binding whatever that a Muslim, you must be bound by this. You are right, you are free. But then, when it comes to succession, there is that spiritual whatever. So it depends upon the spirituality of that person. Okay? But we don't force anybody that you must use Sharia. But basing on the spirituality of that person, then you are free. When you feel you are comfortable with this, okay. If you are not comfortable, well and good.
Prof, I think you leave us at crossroads. You leave us with options to take if we so wish. The legal scholars here are now talking about repugnance, discrimination against the girl child. We are seeing people who are installing their girl children for, in the past they trusted the boy child. The boy child sold everything. Now they trust the girl child to keep their legacy. Mr. Ali, you're always confronted with these families. They come to you when they are hot, when the airs are still, and the annoyance is still there in the skies. Now that they have a choice to choose either to go Sharia or to go secular, what are some of the deep-seated roots of inheritance disputes within the Muslim community that you've interfaced with from your experience at the Administrator General's office?
Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh. I'm privileged to be It's my first time to meet her ladyship, and it's an honor to be with the Imam. That was the mosque where I took my Shahada. I became a Muslim at Makerere University. I was passing by, then I said, but why am I not entering there? So then I entered. And I became a...
And you entered for good.
Alhamdulillah. The biggest problem we have in Islam is lack of knowledge, if I could say that. I've heard of estates where sons were objecting to Sharia distribution. Sons saying we don't want Sharia. And the daughters were saying we want. And it was a benefit to the sons. And they were saying it had to be money. Then I've heard of the estates of sheikhs, Muslim sheikhs, who have died. The microphone is shorter than me. I will lift it. Sheikhs who have died and left wills without witnesses. Muslim sheikh leaves the will, no witnesses. Very beautifully written in Arabic. Says my estate should be disputed according to Sharia. Parts of the family in that family are not Muslim. In that family there are issues of, was there divorce, was there separation? We have Islam interfacing with secular law. In Islam, we have no concepts like separation. You have divorce. So you have a family which wants to pick what benefits it and to throw away what doesn't benefit it. They will say that wife was separated under the Succession Act, therefore she has no share. But we want to distribute according to Sharia. Sharia doesn't recognize. So they want to have one leg in the Succession Act and the other leg in. So if we start from the point of view that as Muslims, we must teach ourselves this. I have told some of my seniors here in the faith that there's nothing, when I had the Sheikh starting his duas, I was like, wow. I wish I could do those things. I've been very thorough in Arabic, but I'm not. If we could start teaching our children these things at a young, such that they know the beauty of our faith. For me, I became a Muslim by just reading the Quran by Abdullah Yusuf Ali, the English version. And because I was a fanatic of literature, I loved the way he wrote his Quran like poetry, if I could say it that way. Very heavy Shakespearean English. And I became what they would call, they used to call me Hafidh English. Because I was thoroughly ingrained in the Quran. I knew if you could tell me that open for us where Musa does X, Y, I would open. But one time, sorry to digress, I went to the mosque and the Imam said, open for me Surah Rum. And I even had no idea even how to say Alif. It was like 2 weeks after my conversion. But Allah works in mysterious ways. I was opening on matter of faith, and then he said, Iyo jihitako. That you are passing it. Then I went back, I was like, I gave him the... If we could know our faith, many of these things would go away. We would know, like the Sheikh has said, something I always, the example you gave, I always give out. I say, if Adam and Eve started out as the title holders of the earth, Adam and Eve took 20% of the estate, and Adam took, the sons took 20% of Adam's estate, because women don't die, they just fade away. They usually say, "Gulayo poloti bonofo no ndekawa." So Adam would automatically, my Lord, you are. I will not excuse you, my lord, because
Ali, just to help you refocus.
Yes.
You're confronted with these mothers that come are torn down by
Yes.
anxiety. They are tearful. They are what? Can you list some of the issues? Knowledge, the knowledge gap has come
there's
out
lack
here.
of knowledge. There is the Muslim families have what we call United Nations families. You have a Muslim man with 4 wives and 3 girlfriends. You have, I had an estate of a Muslim man with 7 wives, a Hajj. And I asked Hajjati that they would cover themselves up to the ears. And I said, you seem to be very faithful people. Why did you marry 7 of them? Then she told me, Hajj yali ayogera bulungi nnyo. That Hajj used to be a very good talker. He was a sweet talker. Now, which of those people are you going to say you are not a widow? Are you going to say we stop at 4? The rest are not widows? You may find that he has a wife married in church when he was not a Muslim. Then he converts and he wants to add other wives. So we have that in Islamic perspective. Then we have children who leave Islam. They leave Islam and say, me, I am now for Jesus. The father leaves the will and says, my estate should be distributed according to. How do you treat those children? We have adoption. Adopted children, by law, they are no longer entitled to a share in the estates of their biological parents. They are in this Muslim man's family. People in Sharia, I want to say, he will not take a what? A share, because he's not the child of the lady. Then, unfortunately for us Muslims, most of our sheikhs are poor, not the ones in this room. You want to entrust those sheikhs with distributing estates. We have had imams. I told the story on Umlas group. We've had imams who refuse to swear on the Quran. The imam, you put him to, you say, my Lord, you swear on this Quran that you are the one who conducted the marriage between the deceased and this woman. Then he says, auchigenze wala. That's the imam you want to be in charge of distributing the estate. Finally, still goes back to the other picking and choosing. Muslims leave wills giving all their property to the Muslim community. And the Muslim community, the real eaters are the imams. I'm sorry to say these things. The people who are going to benefit from that property are they? They will come and swear to you how it is allowed in Islam for the deceased who has children or even nephews to give all her property to the Muslim community at Najana Kumbi. When you tell them that this is not allowed in Islam, they say, Robert. We want to be able to pick and choose and mix and do that. So, if we are serious, and I will say this, I'm the one who removed the provision that Muslim estates should be exempted from the Succession Act. And I did it deliberately, and I would do it even today. Because we were leaving Muslims without anything. We had pleaded with the Muslim NGOs that please leave alone all these fights we are having. Let us focus on the administration of our personal law. Bring the groups from Chibuli, from everywhere. Let us have focus. But everyone was. Now, they were telling us, remove that provision. And we leave Muslims now where? So,
okay, you bring the conversation to where I just wanted to drive it.
Yes.
In 2007,
yes,
I was part of the research team,
yes,
where Mr. Sewaya was managing the drafting of the Muslim personal law. This is a law that we have had at the shelf It has never even come up for first reading. It's still at FPC level. And we now see the amendment of 2022 that completely left us out. As a person, I know that you were part of the team from Administrator General's office at the time. And we had this conversation where Mr. Sewaya was leading the group. What are some of the gains and the losses we have left out as Muslims in the delay in enactment of that law, unlike in Kenya where it is operating?
First of all, we saw recently, I think, a Muslim gentleman taking another Muslim or a lady to the, I think, Court of Appeal, wanting to say that Sharia law should not be used in the distribution of an estate. It's a Hajj who had two lawyers, both of them were not Muslims. But this is a Muslim man fighting against Allah, if we can say it that. For us as entities, we say leaving Muslims to legal recourse. Courts have been kind to us by allowing us to practice our faith. But indeed, if a judge said, where does Uganda Muslim Supreme Council get its authority to handle these matters? If a judge made that decision, where would you go? We usually say jurisdiction is a matter of statute. Where does UMSC get jurisdiction from to handle a Muslim man's estate who has died? In truth, it's judges being kind to us. So by not having our own law, the question I always put to people is that if we have already marriage in the Quran, why did we have the marriage and divorce of Muhammadan's act? It's the same way we should have a law operationalizing the distribution of succession, so that we can know if a man has left children. There are things we also, in practice, the Succession Act, for instance, now says 20% is reserved to take care of minors and children who are going to school. Could we, for instance, import those things into the 1/3 which a Muslim is allowed to? What about children born out of wedlock? If Bogere has a child out of wedlock and that child is 2 years old, in Uganda's legal context, can you tell that child that your daddy said, Sharia, go and die? Why don't we have, for instance, enforcement of that 1/3 and say, in Kenya, for instance, they do it, that if you leave children born out of wedlock, there will be a compulsory 1/3 reserved, because you are allowed, you as a Muslim man, to distribute your estate up to 1/3. So by leaving ourselves naked, as it were, we have left. One time I distributed an estate of a Muslim, and the children said, the girls were saying we want Sharia, the boys were saying we don't want. Two of the boys were saying we want. One boy said, Nzete Mumpa, I'm born of zina. Now, we told the girls, okay, we are going to give you, because we can't force, right now, that's the biggest problem, we can't force a Sharia distribution. We told the girls, we are going to give all of you equal shares. The girls who love Sharia so much, give half to the boys who love. After giving them, they said, Sha, nganya bibawa. That's where we are. Thank you very much.
Thank you so much, Ali. My Lord, you hear the dilemma we find ourselves in. To accept or not to accept. I know that Section 14 of the Judicature Act allows you as a judge to reinvent the wheel of justice for so long as it serves justice. Uganda, as Ali now says, and the professor, is a mix of law, culture, religion, and perception. How are you navigating this terrain to ensure equity and justice in terms of administration of family and succession justice? as a division.
Thank you very much. What I can speak to is when these matters come before court, they are not going to distribute them to say, take them to Nagawa because she's a Muslim. No. These matters can be given to any judicial officer. And just to tell you, I'm the only Muslim judge at the family division. A court where there are about 7 judges. That's at the family. But remember, other courts also handle the circuit courts. And the file comes straight. In all, and the file comes straight. In all, the deceased was a Muslim, yes, but did not say that the estate should be distributed according to Sharia. We have those cases also, where the person left a will, it's an authentic one, valid, but there is nothing like Sharia, and they were Muslims, and the estate is administered as is. To talk about culture, to talk about the law, and what's the third one?
And religion.
And religion. It depends on who is handling, because we are of different backgrounds in terms of culture. We cannot say, it could be an estate from Arua, but they were based in Kampala. And there they are before you. I don't know their culture. I just follow the law. What does the law say? I just go 23. This is it. So on one hand, you risk us who are still living to do the right thing when we should do it. If you are to leave a will, leave it. Let it be valid. And if you wish your estate to be distributed, the Sharia law, please state it. Because where your file is going to end, you're in the hands of that person who might have a different culture from you, who might have a different faith from yours, and so on and so forth, and what exactly you have and what the family is like. So it's very difficult to address at the moment, because it depends on the person, basically. But all of them who handle, equity comes before. The law is supposed to guide them. Nothing is done outside the law, regardless culture, regardless religion, regardless background. Everybody deserves justice, and that is what should prevail when the matters are before the courts of law.
Thank you, my Lord. Prof, I'll be coming to you shortly, and Bogeda, I want to leave you pondering on these questions. For Prof, you'll be talking to us. There's been a castigation on the imams. The imam of Makerere University, spearheading, keeping hold and thought of religion, both to the students, community, and the workers in the university. But you're also a public figure. The imams, they are saying you're not doing your work. Sometimes you're not able to understand these things, and also the ability to stay clear above personal interest. We shall be coming to you shortly to answer that. Then for Bogere, I'll be coming to ask you about, now with all these reforms that we are having, have we tried to tie in these gaps? Are we dotting the T's, and are we dotting the I's and crossing the T's? But I want to quickly cross over to the gallery. I don't know if the online gallery will be able to speak, but those of you who are here, what are some of the concerns, and what do you make of this conversation? Yes, we have the CEO Uganda Muslim Lawyers Association. Sheikh Suraj Katanta is there. Yes, please.
Bismillah ar-Rahman ar-Rahim. This is really a very practical discussion, and I want to commend the organizers that we need more discussions of this kind, because it touches on the issue affecting our society. My practice is in commercial, but my training was in commercial, but my practice has turned out to be in family-related issues. I I want to reference the scenario I'm going to share to what was discussed when Dr. Abdul Hafiz was at the podium. Where you have gone to a Sharia court, the deceased clearly willed that the distribution should follow Sharia principles. The Sharia distribution team follows the distribution according to the Fara'id principles, according to the Quran, the 4th chapter, verses 11 and 12. And then the executor refuses, neglects to put into effect the decisions that have been made. It's a question that I even raised because the family he was referring to, I had matters come to me to intervene. But when I read the distribution, I said, but the Sharia team has already distribution, and the report was out, but the executor was refusing to implement. You realize that that is where the conflict and the tension arises. Now, my experience, the things that Mr. Bogere is talking about are very practical. And I want to give another perspective quickly before I close. When a Muslim man refuses to pray or to fast, can the imams force him to pray? When a Muslim man refuses to be to do the distribution according to the Sharia principles, should the imams enforce it? You see, these are things that we need to address. And to me, the final issue I want to bring out is what Dr. Imam Mayanja was saying. It goes to teaching. We cannot claim to want to apply the principles of Sharia and Islam when we have done a poor job in educating our children, our family on these principles. So it should not be a matter of simply, I want Sharia to apply in the distribution of my estate. Go a step further as a family to help your people understand that these are the principles, you believe in them, and they also believe in them because of the education. Thank you very much.
Thank you so much. Dr. Hafiz Walusimbi.
Thank you so much, moderator and the panelists. I want to join the previous speaker to say that really this is a practical discussion, and I want to submit briefly on 3 areas. Number 1, the issue of ignorance. Just to add my voice to the voice of Associate Professor and the voice of Council Katantas. Now, in the event that the deceased didn't do his work in order to educate his successors on issues of Islamic law, this takes us to the procedure we the Sharia distributors follow. And I want to share my simple experience. First of all, you need to come and open your file with my directorate. Immediately after opening that, I will call for a Sharia briefing. And I really take my good time to ensure that all the beneficiaries are there. And I teach them from the beginning up to the end, including all the categories that are there, and then I give them a chance to ask questions. So by the end of that session, they know what they have applied for. Now, after that, I inspect the entire property that has been brought to me. I always say that I act as a prison officer. I'm not responsible for anything that you did not declare to me. What you declare to me is what I will inspect. And I don't distribute what I have not inspected. Then 3, I issue a draft report and I share it with the executors so that they can share it with other beneficiaries in case of feedback. Then once they give me the feedback, then I will issue the final report. And this is, by the way, how I have succeeded to ensure 100% consent.
Now, just before you cede the microphone, the concept of sectors within the Muslim community in Uganda, as you understand it, some are able to have a directorate, some do not have. We have not yet operationalized the Qadhi's Court. From your perspective, what is the missing link between answering the constitutional dictate and what impact has the intervention so far yielded from the directorate in terms of ensuring understanding and appreciation of Sharia law, particularly in administration and management of estates?
If I have got you right, when it comes to issues of the constitutional dictates versus the Sharia, we also have ways of going around that. Let me share just something simple. What has been coming from the panel is the issue of some of the members or some of the beneficiaries who are not provided for under Sharia. For instance, the apostates. Here is a person who is a Muslim and one of the children or the wives changed to another faith. Then you also have issues of children born outside the wedlock. Under Sharia, and this actually emphasizes the point of knowledge, we shall always find ways of handling that. Quran chapter 4 verse 8 tells us, وَإِذَا حَضَرَ الْقِسْمَةَ أُولِي الْقُرْبَى وَالْيَتَامَى وَالْمَسَاكِينَ. When time comes for distribution, such people who might have not been catered for under Sharia, and really the necessity requires that we give them, and if we don't give them, by the way, they can go to civil courts and challenge, then we can find ways how we can bridge that gap. That is how we have been handling it. Thank you.
Thank you so much. I want to draw in the sisters in the room, their voices. I'll start with her from behind there.
Assalamu alaikum wa rahmatullahi wa barakatuh. I'm Shabahe Wasmaya Abdul Best, a student at Bilal Islamic Secondary School, YEC. So I would like to make a point that Islam never left anything unknown, would not have anything in Islam that is impossible. Even these people that are not accounted for according to the Sharia law in the Fara'id, we still have what we call akhafu dhararain, saddan lidhariya. If at all we find out that this person is going to bring in a lot of confusion in the inheritance, there is a way that Islam caters. Take a case in time. It is a lady who has lost her husband, and her husband was a Muslim, but this lady was not a Muslim. This lady has been left with young kids, and these young kids here are not going to survive without this lady. If at all we start and say that there is nothing in Fara'id that gives this lady anything because she's not a Muslim, it is going to be affecting these kids. How do we handle that? That is how Islam does not leave us without a choice. It allows us to give this lady because she is in care of these kids. If at all we didn't give her, and she goes into the law of the country of which they will give her, she's going to take a 20% according to the law. And yet she would have gotten an eighth, which is about 12.5 in the Islamic law. So giving her the 12.5 would be better than for her taking more that is going to affect the kids, the offsprings of the deceased. Just to make it clear, Islam never left us without choices. Islam leaves us with choices, and we are never left without a thing to do.
Thank you so much, and we thank you for that voice. My sister Wanjiru, I know that you've been hearing some of these matters at the Uganda Muslim Supreme Council and sitting as an arbiter in some of these disputes. Now that the two speakers from the Ghana are telling us, the two previous speakers, Islam left nothing unanswered. We can find a way to work around everything. we can give them 12%, which would, instead of 20%, which would be an eighth or something like that. Why are these issues spilling over to the formal courts? You start with that one, then you tell us your voice.
As I start with what you have asked, still it dives into my other discussion as I was supplementing on what Dr. Sowet has been saying. It still goes to lack of knowledge or appreciating what Allah subhanahu wa ta'ala ordained to us. I'm of a view that we should receive Islam or the teachings of Islam with open heart, without bias, and appreciate it. When you look at the saying that a lady takes half, that a female takes half of the boy, every circumstance is dealt with on its own way. Like what doctor has said, that abnormal circumstances are dealt with abnormally. There are instances where still a lady takes the same share with a man. There are also instances where the lady takes more than the male. Still another instance where the existence of a lady bars a man from inheriting. So, rounding my point, Islam is fair, and you'll never find another religion that is more fair than Islam.
There's been a decry of knowledge gap, and yet the Uganda Muslim Council are managing this function with my brother Mahmoud here. What are you doing to close in on the knowledge gap? Do you have a user manual? Have you designed some disseminatable information? How do we close the knowledge gap?
I request you, Honorable, to allow Haj Musana to give a brief on that.
Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you. This is the real life we are going through. One, our imams, we really have a lot of work. There was a time I was a secretary to the National Mosque, in addition to my other department of work. I tried, and alhamdulillah it's trying, but it's not yet. The way marriage is conducted, it creates a room for going into marriage without the proper knowledge. There's already Bad al-Asri, or Bad al-Maghrib, 30 minutes in the case is made and they go away. There is no darasa. What do I say?
Share your information. The question referred to you was, how would we close the knowledge gap? These people know how to read.
Yes.
Do we have a user manual? Do we have a website where they can download it from? The imam in Chamusi, the imam in Chanamukaka, the imam in, because these are the contact people before the disputes spill over to us. Even when they come to us in the formal courts, we want a diversion route. We say, okay, you go to the district Qadi and be able to sit through this and furnish me with a report. But these people, we've identified that there is a knowledge gap. This all information we are sharing here is so beautifully scripted in your hearts. Where do I find it?
Thank you. Okay, what is happening here, I mean, at the headquarters, there are some attempt to make some bit of order, how the marriage is conducted before, and also the knowledge about before you give out what? Distribution. But I must say, it is at a very low knowledge. That's why I'm saying, now that, because in the past people were not able, I mean, even the knowledge, but now that, alhamdulillah, our daughters and sons, and with the universities, the one we are in and another one, it is our duty to come together. But it's a big problem, even on our website, there is no that guidance. But at the headquarters, it is there, but it's not yet well shared, going down. That is what I can say.
Okay, thank you. I think the ED, the convener, that's one of the resolutions to see how we can design a friendly user manual that cuts across. My sister there will be the last speaker from the gallery, then I'll get back to the panel. She's seated right here. I'm the moderator.
Thank you so much, Your Worship. While it is all said that it is because of lack of knowledge that we have all these issues ongoing in the succession and the Muslims, on the other hand, I believe that is basic knowledge for Muslims. That contentious knowledge is actually the knowledge that people are always most interested in. We have tried to mediate families, and the first thing that the ladies will tell you in those mediations or in those attempts to distribute property of their late fathers, and the first thing they will tell you is, as long as you're not telling us to take half of what our brothers will take. It is what they tell you immediately from the onset. So I do not believe that they do not have this basic knowledge. They have it, they're just not willing to submit to the will of God. And it's the same thing. Sometimes a deceased can leave a will, and the will has, and they have dissolved their property with a lot of injustice. With a lot of injustice. There is children they hate so much, they have not given them anything. There is children they love so much, they've given them almost 80% of their properties and all that. So there is sometimes we face injustice issues in the will. And then also we should appreciate the fact that Islam is not by force. If a person is not willing to have their property distributed according to Islam, it means you are not willing to practice Islam when you are alive. So our laws are not going to do it for you by force when you're dead. Okay, this is something that you're supposed to make clear in your will. We cannot force the Islamic law or the rules to work on you. And then also, laws are there to provide guidance. For example, if the Qadhi's courts were in here and we said maybe there is a binding force, maybe we would say they are binding on Muslims and Muslims who profess the Muslim faith, and maybe they are willing to submit to the jurisdiction of the court. So unless there is a law and it is very clear on who should be bound by what, we shall always have these issues. People come to the mainstream courts without going to the informal Qadhi's courts as we have them now. We would say firaran, they're just escaping from the fact. They don't want to follow the rules of Islam, and that is why they go there. So if we had this law that would force them or compel them to actually come and be governed by their Islamic principles that they ascribe to, maybe that would be better. Otherwise, they have a lot of options. That's why they are coming to you, but they're not coming to you because of ignorance. They know, but they're running away from it, and we can't force them.
Thank you so much. Let me draw her in, but just as she comes on board, I and Suraj were last financial year I was asked and I had to seek consultation. I sought Suraj and we wrote a concept paper on operationalizing the Qadhi's courts, and we submitted to the Administration of Justice Program Secretariat. It is work in progress. I think the conversation has started on how to operationalize them, but the big issue is the charge it would have on the consolidated fund. But they are doing the numericals, but we did submit that, and I did go and defend it.
Okay, assalamu alaikum wa rahmatullahi wa barakatuh. I think about the gap we have in the Sharia courts and the laws. I think even lawyers per se have no knowledge or skill about the distribution of assets and the estate itself. You will find a will drafted by a lawyer that has hiccups here and there about a Hajj who says I'm not happy with son so and so he cannot take anything from my assets. Then also there is a person who will say that these two will not get my property unless their mother ascertains that they are mine. but they are talking of a man who is 45 years and above. Your elder brother in the will is not mentioned as a son or a sister. And then also their assets, when Islam, when they are distributing assets, they're like, you take these things that are going to get destroyed, like shoes and clothes, we do away with them. But then they leave assets that are supposed to be distributed. Past 2 years, you have houses, you have land, you're even scared of talking about it because they say, you're lawyer, or you are gezi, but you're scared, you're in there scared. Your elder people, your brothers, they are gaining, but you're even scared of saying a word about the estate itself. And these are people already by imamu, bamanyi, and they are just there. So thank you so much.
Thank you so much, Garali. I'm coming back to the panel, but before we go to the panel, I want to give you some feedback from our online audience. One of the attendees online is saying sometimes it is not the deceased failing on his part or to do his part. Greed overrides family members. Even when we teach them and we've not tamed greed, they will still keep streaming out of the Sharia law when they don't feel comfortable and stream back when they feel that it is on their side. And one other attendee online is saying Muslim personal law should have a clause once enacted disentitling a Muslim to opt out for so long as you contract a Muslim marriage or you marry in Islam, then you will be bound by Islam. And then the court should be able to channel out through diversion these disputes, such that as we await for operationalization of the Qadhi's courts, we generate some jurisprudence around these disputes. And somebody is saying that both the Director of Sharia at Chivuli and Uganda Muslim Supreme Council should come together and write a manual to be disseminated widely for the readers to see it. But you can also code the cases you've handled to protect the identity of the victims, but release them through a monthly bulletin on UMLA such that we're able to see the emerging jurisprudence. Then one attendee here has written to me this note. Do the problems faced by distributors have anything to do with wills as written, or we should ask Uganda Muslim Supreme Council to guide people on will writing? That people are writing wills, introducing them as Sharia-based wills, but they are literally secular wills. Let's go back to the panel. Prof, we left when I had posed a question to you. Do you have a recount of it?
Can you come again, please? There is a lot which has been mentioned. So.
Yes.
Yes.
I want you to listen to the voices of the people.
Mm.
These are the people we strive to serve. And the sampling here was intended for us to get their voices into this conversation. Do you believe that there is a possibility of harmonizing Sharia law with state law? And if we are to do that, how do we as Muslims increase the uptake, recognition, and enforcement of Sharia law in administration of estates?
Thank you so much. Yes, I think there shouldn't be contradiction between Sharia and civil law. In that, actually, where we are dealing with Sharia law and people are contented, that's fine. But where there is a problem, we're allowed to forego his right. So if that is some people could be convinced to forego some of their rights, then I think we shall be actually, where there is contradiction, then people we tell them to forego some of their rights such that we don't have contradictions.
The possibility of
and also,
that coming easy?
If I could add on, please. Where we find we are locked up, where there is actually serious contradiction, then in Islam we have ad-darurat tubihul mahdhurat. Yes, necessity, because necessity knows no law. So necessity here now can allow us to, okay, yes, to, what terminology can I use? Yes, Yeah, yes, because now this is darura, and actually what the essence of the law is to leave people when they are peaceful after the death, I mean after the deceased has gone, to leave them peaceful such that they continue living peacefully. So we try as much as possible, when you are distributing the property, you try as much as possible, also using that darurat bil mahdurat, that you leave these people at peace. That is the major essence of the distribution of the property, such that people don't stay after the man has gone or the lady has gone, that you leave them fighting each other. It is better to leave them at peace, even if it requires to forego some of the what? Some of the rules because of the darura.
Thank you, Prof. Just go back to Ali. Ali, Prof says we can forego. I know that your office is reopening at estates of 1920, 1939, you know. So, what are some of the misconceptions that Ugandans have or still hold in terms of Sharia and management of estates, and what parts can we take to see that but we also ensure that Muslims estates survive and the legacies are maintained without this? Because here the conversation is take. I haven't heard any of the panelists and the gallery talking about preserving, keeping, adding on. Everybody is fighting to take. Does death mean dismantling?
Thank you very much. I will go back to the audience, the people who are here. We've been blaming those who are not here that they don't know. When I was invited to Makerere to speak to my former lecturers, I asked them, how many of you have wills? The same question which is to the people who are here. Many of you are pretending that for you, you know a lot, and that those who are outside there don't know. But I can assure you, because in Islam there is no insha'Allah about death. When you die, if we were to die here today, 90% of you here have no wills. And yet you are the knowledgeable ones. And your estates, because some of you, even the women, you have your women's money, your money is going to be crawled over by your father's clan. Because they say, this is our daughter. You have not left a will. So the basic we can say is, first of all, let us encourage Muslims to make. I really felt bad. I went to Old Kampala one time to pray from there. And I went and offered to go and talk about will writing on the radio there for free. I don't charge anything. I said, don't pay me, I will not. They said, will it be like I don't know whether it's fun or interesting to our listeners. This is knowledge. So, her Lordship said that for her she's not allocated files of Muslims because she's a what?
No.
In the Administrator General's office.
That's not what she said. She said at the time of allocation,
yes,
they will not give her because
that's what I meant.
Random.
In the Administrator General's office, they would deliberately say, you Muslims get your things. Because Muslim estates are problematic estates. So how do we encourage Muslims to make wills? Because that's the basic. If you make a will, you will actually, if you are a Muslim and you make a one-line will, all my estates should be distributed according to Sharia. You are better off than these ordinary Muslims we see. Most of the Muslims who make wills, we say those are the better ones than most of you here. But they make wills of 6, 7 pages when 3 of the pages are quarreling. He's quarreling with everyone. He's saying those very things you are saying. Whoever sells my property will see me. In Luganda, Alitunda, Alindaba. How do we encourage estate legacies? As Muslims, it's a question I've actually also been pained over, that in Islam we distribute even spoons. And I was asking myself, if there are children who are going to school, I don't pretend to know a lot about Islam. How are those children going to study if we have distributed everything? We tried to incorporate that aspect of 20% to encourage. The law gives Justice Sekana the same share as his one-day-old brother. Previously, that's what the law would do. And in the past, when Justice Sekana would come, and we tell him, but Justice, your brother is 1 year. He says, that one has no problems. Me give me my full share. He just needs breast milk. Me, I have problems. I have school fees. So we said, let us put it in the law that these children should also be able to study. Now, if you are a Muslim and you want your estate to be saved from the vagaries of distribution, buy property in a trust. Buy property not in your names. Establish a trust, Umlas Trust Limited, and buy property directly in that trust. If you already have property, transfer it there. It means that then you have controlled. I don't know what Sharia thinks of that. I will not lie, but I believe you would have controlled your estate such that your assets are not going to be subject to 1/8 and all that stuff, and you will leave a legacy. Thank you very much.
Thank you so much, Ali. My Lord, I now want to come to you to pick. Just on this one. Just 1 minute, if you don't mind. Actually, this is what we call waqf. Waqf, actually, you can decide that my property, I've left it in waqf. And this is actually what we meant. In Islam, that is the waqf. Okay? That now this one is waqf. It is not going to be distributed. It's not going to be sold. Okay? But whatever comes out of it can benefit the heirs. This is the waqf. And people don't know it, actually. Yes, so, thank you, Prof, that you enrich the manual. You enrich the manual there. My Lord, just to pick your parting shots, we've heard the voices of the panel, we've heard the voices of the gallery, as the division that is setting the practice space and for in administration of estates in Uganda. What are some of the innovations that you're enforcing to address the issue of expiring grants? And also, the sheikhs are sitting 4 days or 4 months after burial, distributing the estates. And then we have this concept, the elephant in the room, intermeddling with the states. We are sorry we are taking a little more time, but let's allow Her Lordship to voice out on that.
Thank you very much, Your Worship. I will talk about the intermeddling and then the expiring letters of administration. But before I get there, I want to address some of the issues that you have been talking about here. I have heard Islam has every remedy, and if you're a believer, then you should try to practice what the religion says. But I want to put it to you, and very frankly, without shame and fear. The most disputed estates are for Muslims. So I wonder, with all these remedies, with all the faith, with everything at hand, why are you the most hard estates, us as Muslims, to deal with? First of all, the numbers are so huge. It's not a problem that the families are huge. But a disputed estate for a Muslim is really, really hard to deal with. And that begins with whether there is a will or no will, because the deceased could have left a will. They have been everywhere, and they come to the courts of law. And this is what I want to put to you. The moment you enter the court and you have a number, civil suit number 100 of 2025, no one wants to know, will you follow the Succession Act? What did you say when you went to the Administrator General? We start from there. And it's these siblings, these families with their mothers, that want to cut each other's throat. So we are wondering why? Why? I'm going to answer his question now. He's talked about intermeddling. Intermeddling under the law is section 267 of the Succession Act. And what does intermeddling mean? Intermeddling means that on the passing of the deceased, do not touch. Who has the powers? Administrator General. Don't touch. Leave it as it is. But then you start sharing. This building is taken by X. This one is taken by Y. By the time you come to court, everything is done. And you want us to recollect. Probably you've even sold. How do you want us to recollect these things that you have already sold? So it is don't touch. And there are penalties to that. So if you haven't gone Sharia way, and you've decided to handle these things your way in your father's compound, and after you've distributed these things amongst yourselves, you have even sold to third parties, then some other beneficiaries come to court and say, my brother X intermeddled, for us we did not get anything. Probably they were even in the meetings. So that's intermeddling. You're not supposed to do anything with a deceased estate until the letters of administration are granted. That is the law. And when you come to the civil courts, that is what it is. Letters of administration expiring, if I were to get there. Someone would ask, then what are these letters that you're talking about when you have been talking about Sharia? I said earlier that you find that Sharia, the estate has been distributed, probably there are assets that need to be transferred, and then you come to court to be granted letters of probate or letters of administration. And when you come and you're given this document, you're under the law. Strict compliance of the law. We want you to file the inventory. We want you to account for the estate after 1 year, and strictly, because there is a penalty to it when you fail to adhere. We want you to distribute the estate according to the law. That is section 22, 23, and 24. No shortcut. But remember, in this same room, we are talking about another format of distribution. But when you come to the civil courts, that is what you're required of. So we have to educate ourselves to know where we're heading, what we want to be done, because when you're before this judicial officer, they will not know. And the letters expiring.
My Lord, before you leave that point, you've been saying they go to Administrator Generals, they come with the minutes.
Yes, they come with the minutes.
So if they came with the minutes from Dr. Hafizu's office attached to Administrator General as their proposed distribution list,
that's perfect.
Would the court sanction it?
That's very perfect. That is very perfect. But this is what happens practically. They will pluck out the minutes of Dr. Hafiz. They will not bring them. They will put, and they will not even mention that they've ever been there. Hidden. It's like they are just beginning at Administrator General, Mr. Ali's. And the pages are few. We read them. And they're the ones we base on. But no one talks about that I have been there. And these are staunch Muslim families. Those are hidden. It is during cross-examination that you start hearing, and this is when the matter has gone far. Sharia gave you, you took. Also you took. When we went there, you took. But this is where we are at. And at that time, they have caveated probably the letters, because there is also that part of you have been to Administrator General, you have finished distributing the estate. But like my sister said, they have given them shoes, cups, and plates. The other things have been kept. That is when she comes in to caveat this estate. And after 6 months, within 6 months, we expect you to have filed a suit. When the suit begins, either party the caveator and the people who are getting the estate. When the suit begins, maybe after 2, 3, 4 years, remember this estate, it had buildings, people are collecting money from it, they are not sharing. Somebody is benefiting somewhere at the expense of others. And those ones that are benefiting are the ones that want to drag this case on. They are still enjoying. So they have kept that hidden. They have kept that hidden, that they've even ever distributed this estate Sharia way. It's all silent. And the judge will decide otherwise. So, in case we don't have a suit, let's imagine everything has gone smoothly and the Administrator General has the minutes from Dr. Hafizi. Beautiful. Distribute the estate according to what you agreed. It's all right. We want to know that we agreed this, but because we couldn't transfer, that is why we are here. Judicial officers, courts are understanding. They will adopt that because that is what you agreed upon. That distribution, Section 23, will be applied that, but maybe 1% of the Muslim community will come up and say, we distributed the estate according to Dr. Hafiz, and these are the minutes. Impossible. They are not there. They are quarreling and scrambling for this estate. And if I may answer the expiry of letters, and that is where another mix comes in and you get into another movie, another arena. So with a grant of letters of administration, the previous ones expired by 31st May 2025. The old ones, if you had a new one, it has a validity of 2 years. So after 2 years, your siblings have been seated down looking at you, and you're going to make this application for extension of letters. You need consent from all your siblings, all the beneficiaries. If the mothers are alive, they are also going to. Now, when you were coming for letters, you were 60 children. When you're coming for renewal, you're 16 children. We are asking, where are they? They died. You have no death certificate. Now they start pronouncing you dead when you're actually alive. You have no death certificate. You have nothing to prove that they are dead. Eventually, a letter comes through where some have consented to say, don't give them an extension because they did not abide by the law. X and Y have been enjoying the estate. So, letters expired or revoke the letters under 230, the estate is in space. The estate is in space. You have beautiful buildings, you have hotels, and you're stuck. So, I've heard you. Let's educate each other. Let's have wills, like my brother has said. But more so, let's educate each other on Islamic laws and what we want in future. So, I think that is it. I've talked about the expiry as well.
Thank you so much, my Lord. And thank you also for having given us those views. We are now going to collect our parting shots. We shall start with Prof. Prof, what are your parting shots from this conversation? What are your parting shots? What do you think, what should be the direction we should take as Muslims?
Thank you so much, but still I emphasize on teaching each other as Lordship said, and also we really need to know that the essence of distribution of the property is to leave the family in harmony, in peace and tranquility. And that is the major issue, actually. And that's why Allah did not leave it to human beings, but He did it, the distribution Himself, because He knows us better. So the essence is that the family should be left in harmony, in peace and tranquility. Thank you so much.
Thank you, Prof. Thank you, Prof. My brother Ali, we've been talking about making wills, making wills. In your parting shots, can you break down to our listeners and the online attendees, what are the salient features of a will?
Thank you very much. I wish
Of a valid will.
I wish we had like a sleepover and and we could all make wills tonight. All of us who are here, and see those who will die, because people fear making wills, think that they are going to die tomorrow. A will, first of all, is a document you make intending it to come into force when you are dead. It is not the same as an agreement, because the agreement takes effect when you make it. Now, you have to have a date on your will. It's very important because if you marry after making a will, the will is revoked. So dates are important for so many other reasons. It could even place you, people who say, omugenzi yagenda okukola ekiraamo nga takyategeera. The deceased made that will when he was not in his right state of mind. So if we have a date on the will, it will place us on the day you made the will. I've had wills revoked through family division basing on just the date when the deceased made it. That's a very key issue. Secondly, you tell us your names, you the maker. Then I will speak about men, as I said, your wives and your wife and husbands. Your husband, a brave woman. If you're a brave woman and you're going to make a will, your husband or your spouse. Okay. The reason, my Lord, I avoid the word spouse. When we put it in the act, parliamentarians quarreled with us that they are not the spouses of their wives. Those were MPs. So your spouse is a husband or your wife. Then your children, your property, and how you want it distributed. Conditions, if any. You can give a condition which is beneficial. You can say, I've given my property to X. He will have to pay school fees for his brother Y. But these people, Ugandans, you find the most funny conditions in wills. My wife should never leave. Should never remarry. As if you are the last born man on earth. Then the other famous one, whoever sells my property will see me. I'll give no one should sell. So you can give conditions which are beneficial to people. Second, thirdly, if you have, I'm giving a will under the Succession Act. If you have a person whom you don't want to give a share, say it. Don't simply ignore that person and that we will think for you. I handled a will in Arua where, I don't know whether they are minors. Anyway, they are minors, I've seen them. A husband woke up to find himself being bobbited. Some of you know what bobbiting means. You can Google it. He found the wife with a razor blade. So he made a will saying that wife should never, that woman, that's a valid reason according to the Succession Act. It's because she wanted to murder him. So don't give us reasons which are like one will that whichever of my sons joins the army should never get a share. You are now like almost fighting government. Where will government get soldiers from? It's in a real will. So give conditions which are legal. Then appoint executors. Don't appoint close friends alone. Unfortunately, for most of us, the people who love our wives are our close friends. The people who love our husbands are our. So you will appoint your friend. No, your friend, like a man, when he is in a relationship with your spouse. And you will make a will say, disclosing other children whom your spouse doesn't know. And this one will tell you, he's honey, your husband has other children. I've seen such a scenario where the man was killed by the spouse. Finally, sign your will on each page. Have two witnesses also sign and give us their details. That's a gray area. The law says the witnesses must sign and give their identification details on each page of the will, but it risks them reading the will. We didn't want it, but that's what Parliament put there. So that is your will. After you make it, you die, we will distribute your estate.
Thank you. Thank you so much. Thank you so much. Let's give him a thunderous hand clap. Yes, my Lord, Honorable Lady Justice Sirius. what is the position of ADR as your closing remarks in terms of estates management? Where is the place?
Thank you very much. As courts, we encourage ADR. I think we encourage ADR more than anything because the law is very adversarial. It tears you apart by the time you finish litigation. But in most cases, because you are siblings or your relatives, kinship, you know each other more than the judicial officer handling the matter, we encourage you to go for ADR. And we have mediators. But I'm happy to be here today and learning that even where I am seated, this has been organized by an arbitration center. So for me, one thing I'm going back with is now I have added to my list of diversion channels, like he has said, and I know I've got to learn that they themselves can actually mediate better. So going forward, if I have any Muslim Islamic related matter before me, be sure if you're in this room that I'll send you to them. Because I feel they understand better than one who is not of the religion, and they would arbitrate the matters faster or even simpler for our sisters and brothers. So I advocate for ADR all the time, and what I've picked from here is I have a referral going forward.
Thank you so much, my Lord. What a very nice pan I've had to crack the nut. It was a hard nut. Let's give them a thunder sun clap. We want to thank Allah that has brought in our lives and that has placed those words of wisdom on your tongues. To our online audience and the audience here, I think the conversation starts and we can improve for the better. We thank you so much.
It's going to involve you. We thank the moderator, His Worship, and the panelists, Lady Justice Naga Wasilia, my brother, big brother Al Robert Wogere, and Professor Dr. Sowed Mayanja. Another round of applause, please. Their session propelled us through another session which we had to start by 4. And from the comments of the online viewers and many seated here, it was fantastic. We're left with about 20 minutes to wind up this summit. And at this juncture, allow me to inject in a few Luganda words from what they've been sharing with us for the benefit of our online viewers. Abebitiibwa batudde maaso wano tulina owekitiibwa omulamuzi w'ekkooti eya famire, ne tuba n'omulamuzi omuwandiisi w'ekkooti ey'e Wakiso, ne tubeera ne Senior State Attorney, omuweereza wa gavumenti mu ofiisi ekwasaganya emaali y'abagenzi, era ne tubeera ne omukugu mu sharia era nga ye Imam w'e Makerere University, Dr. Sowed. Basically babadde bawumbawumba ku nsonga y'amateeka g'okusikira mu busiraamu era nga bagageraageranya n'etteeka ery'obusika ery'ensi, era nga batubuulidde ebintu bingi nnyo, naye nga mbufunze batukubiriza bonna okubeera nti obeera ng'oli musiraamu osobola okukosa obusiraamu bwo n'obeera ng'obukozesa ate mu tteeka lino ery'ensi secular law, wadde osobola okukola ekiraamu kyo mu busiraamu era n'osaba kibe nga kiyimirizaawo mu busiraamu era etteeka ly'ensi lisobola okukiyimirizaawo. Era batukubiriza okuba ntuwandika ebiraamo era natuchallenge nga ffenna ba online viewers n'abali physically wano nti abasinga mu ffe tutya okuwandika ebiraamo naye okufa tetunakutiisa kuwandika biraamo. Era batukubiriza okubeera nga tugezaako nnyo ba implementers oba abakulembeze ab'enjawulo okubeera nga bayamba abantu ba bulijjo naddala nga batuse mu nsonga y'okugabana emaali y'omugenzi okuva ddala ku ba imams. Era batukubiriza okubeera nga ffenna abakulembeze naffe be bakulembera okubeera nga tugezaako okubeera nga tuyiga nga tumanya obusiraamu kyeboogera ku nsonga ez'enjawulo naddala ku nsonga ne tuliko ey'amateeka n'ensi n'ey'okusikala ebyobusika by'abagenzi. Era ne batukubiriza okubeera nga twettanira nnyo okukozesa obusika bw'obusiraamu kubanga bulina ebirungi bingi nnyo. Era ne batukubiriza okubeera nga tugezaako nnyo okulaba nga ffe abantu nti family zaffe zetutandikirako okubeera nga tutraininga okuba nga ziganyulwa mu mateeka g'ensikano ag'obusiraamu. Essaawa eno munzikirize tugende ne session eddako ya town hall session era nga it's going to be moderated by our sister Sanya. We have about 15 minutes to 20 and so far we have some questions which have been posed and the panelists here with us together with the audience and the other members who discussed earlier are going to be answering those questions. So far we've received more than 5-6 questions and I call upon my sister to come and take the floor. Sister Sanya. Or we can start with a few questions which we have. Some are going to be addressed to Honorable Mr. Justice Sekana, others to the panelists here, and others to those we discussed earlier. As she comes in, let's have let's start with our brother. He hasn't chipped in.
Assalamu alaikum wa rahmatullahi wa
You can also
barakatuh.
let us know who you want to answer your questions.
Mohoz Abdul Salam is my name, a student of law and Shariatul Islamiyya. Well, it's more of a comment.
Can you put your mic closer to your mouth?
It's more of a comment on what has been discussed today. Because we've talked about disseminating knowledge so that we get some things right. But I am of a view that one of the factors that we're shining here is that the public or the masses have actually lost trust in the sheikhs within. And that is the biggest challenge as to why it's not moving the way it should. Because you will find a sheikh comes today to distribute, and then before you know it, he's getting married to the widow. And these are stories that the people are really spreading. So these people have not lost belief in Allah, that Allah ordained this, but they have lost trust in the sheikhs, that is it really true that what he's saying was that Allah ordained? The last is a prayer. As we're pushing Kadhi courts to come in light, don't we think that it is also high time to think of maybe creating a database or a registration for the sheikhs we have in the country? Because you don't tell someone that just
Dr.
because
Mahmoud, I suppose you are noting.
You have finalized with Thanawi and then you are a sheikh. No, you're not. But those are the problems that we're facing. I have a professor who usually call them Baseka Seka, Baseka Were. And then we're thinking that they are actually knowledgeable, but they are not. We've seen sheikhs who are collecting Zakatul Mali every month. You see, so good enough we have very senior members in our faith, and Supreme Council is presented, and we have the Director of Sharia. So I think we really need, as we are pushing for the courts, because even if we have the Kadhi's courts, people have lost trust. Who tells us that they will come with their problems in the Kadhi courts? So I really think we need a database to know who is a sheikh and who is not. Thank you so much.
That is noted, but I remember the moderator posed that question to Dr. Sowed, that how do we deal with those imams? I don't know whether someone, let's hear from the Director of Sharia.
Thank you so much. I want to start with that one. Of course, we are aware of that challenge. And we have decided as the Department of Sharia at Islamic University in Uganda to start the Sharia Scholars Council. And we have started it, and I'm even happy to report that Associate Professor Dr. Sowed Mayanja is the chairman of the steering team to lead us there. That is the first one. Then the second that has come out of my brother Abdul Salam. Of course, there are issues with sheikhs, would be issues with others. Sheikhs are human beings. And if it is greed, even others have greed. But our emphasis usually, it has been professionalism. And this is, by the way, what we are training our students of Sharia and even other specializations. Finally, I would like to call upon those who are engaged in distribution to familiarize themselves with the law of the land. There is no way you can go ahead and handle such estates without knowing what are the dictates of the law of the land. I just want to cite one example and hand over the mic. The issue of letters of administration. We have taken concern that this is a requirement. That is why in our stages of distribution, there is a document gathering. I make sure that I don't dispute any estate until when I have a will, if it is there, I have a death certificate to confirm that, I have letters of probate or letters of administration, and then even the inventory, especially that has come up as a result of evaluation report. Because me as a Sharia scholar, I cannot come and I say that this building is worth this. I require them that please bring to me the property and I want an evaluation report from a professional. So if at all we familiarize ourselves with those dynamics, I'm sure that we can be in position to address many of such concerns. Thank you so much.
Before you take leave, a question has just been posed here, that do you ever distribute the properties before issuance of probate or letters of administration as your Sharia board?
In my court, never. It is one of the requirements. Once you don't have it, I will say that please go and look for it until when it comes to my table. Thank you.
Let's have an addition.
May I wait just? Okay.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa barakatuh.
I wanted Dr. Fiz or Dr. Sowe to clarify. Is it every sheikh that they are qualified to distribute? Because I think, picking up from what he said, we are going to send people to those sheikhs who have no idea. So before we let it out, can we know who qualifies to distribute the estate of a deceased person? So that we don't again create problems by sending them to people we very well know are not even knowledgeable. I think that's the criteria I wanted, but maybe also to add, they will respond to it.
All right.
I wanted to clarify on the will, which Council Ali talked about. Actually, the will when you've made a will, the person must witness your signature. That is the key thing. Don't sign the will from Kampala and send it to Kawempe. You send to him and the person is witnessing you signing the will. He comes to court to say, I saw him sign. Usually, I think he hinted on it. But I need to read inside. You're not supposed to read inside. You're witnessing my signature. You're not witnessing the content. The content you shouldn't even know. Because as he said, actually, sometimes people die because of wills. When a man discloses many kids than people have known. People thought the man has 3 kids. The man says, I have this wife, I even have this. Now, if a person read that content and passed it over to the kids, or he has named so-and-so as the heir, he has disowned you, or he has not made you a heir, that can be a cause of a problem. But let's emphasize that people should, when you are signing, people should be there to see you sign. Because one time, as a lawyer, I had a matter, I thought my case was watertight. When we appeared before Justice Chivuka, and the man said, okay, did you see him sign? He said, nedanze nalika, mutabani we naleta ekiramu nenkolachi. That was the end of my... You didn't even see him sign, now the man is deceased. How do we prove that? That is his will. So basically, let's emphasize the 2 witnesses must see you sign. Let them be there. They are seeing you signing. And they can at least show him signing on that document. Then the other issue, can we have wills in triplicate? One copy wills go missing. You are leaving it with a friend who is already siding with other people, and he vanishes with it. He goes, he talks to the wife, as they've said, maybe he wants to get into a relationship with her. Since the will unajirabye, let's go and distribute it as an intestate. So, but once you make a will in a triplicate, let it even be mentioned in the will. This will has been made in 3 copies. Now, whoever thinks of forging will think twice. Say, actually, maybe, I don't know who has other copies. Now, that may be a bar for people who want to come and forge wills. But when you make 1 copy, sometimes the person they have left the will with may even die before the other one. And people are finding wills after 10 years. I had a matter in civil division. Stanbic Bank inherited UCB. They said, we have a lot of documents, we don't know what is. And they wanted an order to open them. I told them, go and advertise. And then they found land titles and wills. People would write their wills, take them to the bank. The banks would always keep custody. Now, the man dies, the bank officials even don't know what they are keeping. They even distributed, others got special certificates of title, only to discover afterwards that the man had actually left a will. But when they are left in triplicate, sometimes people know, they may even mention where they are kept. But sometimes they keep it as security purposes of safeguarding those who are having custody. But please, let's ensure that we have 3 copies, and you must be witnessed as a person signing. Thank you so much.
I want to weigh in on some of these issues. One is the loss of trust. The preaching of if you marry a widow, you are assured of Jannah. If you marry a virgin, you are assured of Jannah. These narratives must be revisited because they are pushing people into despicable positions, manipulation and taking advantage of others. And nothing draws somebody closer to somebody when you give them a shoulder to lean on. When they come hurting and then this seeker is quoting the Quran and Hadith like nothing, that's where the whole problem stems from. But also this radicalism within the Muslim, the Muslim setup, we should benchmark. I know of a court that has failed to take off because there is a lot of Catholicism in the area where it operates. And people, for them, before they come to the formal courts, they first go to Bwana Mukuru at the parish. If matters spill over there, they come up to Rubaga. It is in the Rubaga Archdiocese, that court. Why is it that for us we've failed? You find the district Qadi is abusing Owetwale. Owetwale is taking this fraction, another one is taking the other fraction. We need to, it's a systematic leadership problem that we need to address. Addressing it at the grassroots will not solve the problem. We must systematically look at where we want to propel Muslim leadership in this country. Then the Qadhi's courts, they will not misbehave. Qadhi's courts, once operationalized, they are part and parcel of the judiciary because it is a constitutional establishment. We are just being cheated as Muslims. The argument that there are no funds, I don't understand it. We can start with at least circuit courts. We say Ankole Region Qadhi's Court, Acholi Region's Qadhi's Court, something like that. But where we have the functional ones, they are managed by the fractions and they are at the headquarters. What is their footprint in terms of serving? How many millions of Ugandans are we today? So the service cannot be able to fit everywhere. You'll find in Arua, for them, they want the Qadhi's courts completely. Are we together? But in Lango, what is the problem? They are not there. In Masaka, somebody will not trek in a search for justice long distances when they see the formal court, this door is open next door. Then, but they will be bound by the judicial codes of conduct and the ethics. And there will be supervisors, they're supervising the formal courts. And the appointment will come through the Judicial Service Commission. Then we need to come up with proposed distribution plan. Dr. Hafiz, I respectfully choose to disagree with you. You cannot wait when people have already gone through the formal court system and have the bring in the concept of Sharia. Sharia should be brought in at inception. Now, for Ali, I expect that these minutes we are getting from the CAO's office, if people had already gone into these courts, they've already come with a distribution from the Sharia. It should come through as an annexure to the petition. When I'm doing the identification as the registrar, as I forward the file to the judge, I'm able to make those notes. And the judge will now sanction that the distribution of this estate will be in tandem with Sharia law, invoking section 14 of the Judicature Act and 98. But if people have already gone through the formal distribution scheme under formal law, gone to the CAO's office, the sub-county chief, and so on and so forth, by the time this lady comes to tell her that now, you know, because we're invoking Sharia, you will take half what the boys have taken. Yet throughout the formal mindset has been, we shall take what is equal to others. That's where the mindset shift comes through. And then what has already been granted as a closed administration file comes back through a formal suit, either for revocation or intermeddling or interfering with the powers of the administrator. So let's try to integrate this scheme from the onset. Maybe after the 40 days dua, those that do dua or those that do not do, we should be able to have this conversation at that stage. I thank you.
Can I say something small? Moderator?
Who is that? Oh, yeah. Actually, after your comment, there's a question posed to you directly.
Okay, thank you.
How does someone who cannot read and write make a will?
Thank you very much.
Do you also allow video wills and audio wills?
Thank you very much. Video wills and audio wills are not allowed in Uganda as of yet, except for soldiers and mariners. But even then, soldiers and mariners who are already on the journey. If a soldier is at Shibuli, he must also make a written will. He has to be either in combat or en route to combat. So with Dr. Hafid also, the issue I had was
those who cannot write and read, how can
any person can make a will as long as they can own it. The issue is, actually, you can even, if you don't have hands, or if your hands are bandaged up, like you are burnt, you don't say that he cut the bandage and put the thumbprint or the foot, the can write for you, actually, your name. The only issue is that you own it. So another person can actually write on your behalf.
And how do you own it when you are dead?
No, I'm saying a will, the reason it's called a will, which means the ordinary word, My will, my wish. So if I say, my Lord, as you can see, my hands are bandaged up. Sign for me. Then the witnesses who are there, because the witnesses won't be now blind, because you can't have blind witnesses. The witnesses will see and attest to the fact that the late, when he was still alive, because of the condition he had been burnt up, he had been scalded by hot water and all his hands were bandaged. He told Bogere to write his name. And then the witnesses, so in essence it is ownership of the will by the, so the owner of the will even tell the people that I'm the one who has told him to sign on my behalf. The question I had for Dr. Hafid was, if this family has come to you and they already have a grant, and someone says we are coming to you, and then another person says no, we are going to Old Kampala, that type of situation, how do you handle a situation where people are falling the other side and others are saying we are going this side? Finally, I was also suggesting, like His Worship, is it possible for you to do a tentative distribution? A distribution scheme, not giving the house to a person, but a distribution scheme which they then attach and move with the process of getting letters of administration. Because if you wait, the biggest problem has been for us, as everyone has said, Muslims, we are like, forgive me Allah, we are like recorded in quarreling mode or something like that. We're like, we have a default setting of quarreling. Thank you very much. Thank you very much.
I'm giving Doctor 1.5 minutes to respond to that. Then there is a question posed to Justice Sekana and Justice Syria, and that is next before you go to our sister Nachtende, Fatina. Just switch it on.
Thank you so much. In 1.5 minutes, how do we handle cases where we have parties? One is saying that for us, we believe in Chibuli. The other one believes in Old Kampala. This matter, by the way, is not only in estate distribution.
Can we come back to the summit? Members, you're disorganizing backbenchers. Please come back to the summit. Proceed.
I'm saying briefly, it is not only in estate management, but even there are cases whereby marriage was concluded at Uganda Muslim Supreme Council, but now the parties want it dissolved from Chibuli. That has been there. And you find one party saying that, for me, I will not come there because my marriage was not concluded from there. How do we handle? First, we go into mediation. We try as much as possible to convince these parties to be on the same page. But failure to have that, I had always made it clear that we are in the same boat. And actually, the Muslim community is a very small community. I have had several cases whereby I call Sheikh Musana in case there is any issue between, which is at Uganda Muslim Council. And at one moment, by the way, I had made an error in handling a certain divorce matter. And he called me and said, my brother, this is not the way how we do it. So my point here is that since we are in the same boat, we should actually collaborate. And this goes back to what His Worship said. These issues of this one attacking this and so on, if we are to build a future of this community, we just need to do away with that and focus, and we register success. Thank you.
Thank you. Now the question which has posed, actually it has been sent by a fellow judicial officer, named can't be disclosed. In a situation where all the beneficiaries consent on how their estate is going, or how the estate is going to be distributed, the same is distributed, and thereafter they append their signatures on that consent before going to the Administrator General or to court. Is that also intermeddling? I repeat the question. In a situation where all the beneficiaries consent to a given distribution, they all sign that consent form, and they enjoy, if some even dispose of that property before going to the office of the Administrator General or even court. How do you handle that situation? Is it also intermeddling?
100% intermeddling, for as long as there is no will. It's a will. Again, without letters. If there is a will, and the will has stated Sharia, it's different. The moment there is no will, there is nothing you're agreeing upon. When you die, when they pronounce you dead, pop, powers are to the Administrator General, for as long as there is no will. But it's the Administrator General who is going to say, you come through to say, we have been nominated, we can assist you in administering this estate. Appoint us as administrators to assist you in administering the estate of the deceased. So when he finds you fit and proper, only when the Administrator General finds you fit and proper as that person that has been nominated by your colleagues, then you start administering. When you touch anything of the deceased without letters of administration, you are intermeddling.
Can I say something? The position is as her ladyship has said. The only nuance I want to put there, the only nuance I would want to put there is, in a situation where you describe it as it is, there would be no complainant. So there would be no one to go to police and say there is intermeddling. But supposing there was another person who never signed, that person would come and those people would have issues. Secondly, there are estates, especially of loaded Muslim men, tycoons, who deal in the clothing business. There's one who died whom you all know, and he left around 1 billion in stock in clothes, maybe t-shirts. Now, by the time you go to get letters of administration in Uganda, in a Muslim estate of the default setting we know, it will be 2 years. Those t-shirts will be off market. They will no longer be, they will have depreciated in value. So what that family did, they sold the what? T-shirts and deposited the money on the account. And actually they even decided that the mother will take this percentage, the children will take this percentage. Although it was black and white intermeddling, it is the situation which Professor said that abnormal situations, you are trying to save the estate from intermeddling. In effect, is you are taking over property and you are at the risk of wasting it. Now here, what they are doing is actually preserving the value of the estate, because you wait, the t-shirts will. So it is there's that nuance you have to have. Thank you very much.
Can we go to?
I beg to add to what my brother has said on intermeddling. Intermeddling actually has exemptions, and that is under, I think, 2653. You will not be intermeddling when you're getting money to bury the deceased. You will not be intermeddling when you have a patient. Maintenance. There are 3 specific areas where you're not intermeddling, where the law has specifically stated that this is not intermeddling. Yes? So other than that, the law is very specific. Yeah? But again, to add to what he has said, again, the Succession Act has a remedy for all of this, because we have what we call administration pendulate under section 214, where we give you a temporary administration. And this normally goes to the one who gets the largest portion, probably a widow, or if you have, say, children and it's one child and they're going to get 75%, or two children, they're going to get 75%. Then we give you the administration pendulate, which is managed and controlled by court. That one specifically states that you do not distribute. You can receive money, bank it, you know, that kind of thing. So the law would have found a solution for you. We give you a temporary as you finish without the letters.
Okay. Can we now go to our Honorable Mr. Justice Sekana?
I had a question. I think Dr. Sowed should answer that one, whether the
Okay.
sheikhs.
All right.
I think Dr. P says he's passing it over. But the other comment I wanted on the estates, I think what we are about intermeddling.
Yeah.
I think sometimes we need to live practically or in reality what is happening on the ground. Sometimes, yes, you can stick to the law, and then you get the absurd situations. Because I think there are cases where people have been given in a will. For them, they did not know about even getting letters of probate. The will was very clear. That land, this. They took possession until after, I think, when one of them died, now his children wanted to come and get the thing in their names. Unfortunately, they had never even processed since 1970. But no dispute, no wrangle, as I think Bogera said. So basically, there's no dispute about that. I think the court wouldn't even get into the issues of intermeddling. It becomes intermeddling when there's a complainant. When there's no complainant, grant them letters and they move on. Don't begin opening the course. But once there's someone complaining,
that's where
the trouble begins. But now the problem also is, who is this complainant? One who took benefit, ate it, sold off, now is coming back to cause havoc to
those who preserve it.
We are courts of equity, we are courts of fairness. You can't be seen to be claiming that there is intermeddling when what you received in the illegalities of intermeddling, you sold, you've wasted yourself. Now that you are very poor, you are saying, let's go back to court and we get. I think those are the cases the Bogeres are having there. Someone is opening an estate of 1970 when he took full benefit, wasted, now he's bouncing back and is even alleging all that. We should now redistribute. But what happened to the other? And you know the famous case where people benefited, and afterwards now they are saying, oh,
where
no.
father benefited.
Someone benefited. Jogere knows the case. Then after they are bouncing back to court, say no, that distribution was not properly done. But okay, said okay, what we do, all of you bring back what you took in that illegal process. Then we redistribute afresh. Meanwhile, they've already sold off theirs. They are targeting this one who received this. That's unfair. So, but I think that as courts, we have to be flexible and alive to some of those scenarios. Otherwise, you will find these people who have already benefited bouncing back to relitigate, or their grandchildren. That's what is happening. Now, the father didn't have a complaint with his siblings. Everything was okay. This is my land, I built it. Now, his kids come to court to say, oh, we've realized our great-grandfather's estate was never distributed. Now, their father never complained. We are back in court after 50 years to relitigate that. That's why we have to interrogate all this and address the problem where it is. We are not, I think, we are not mechanical or robots that they punch facts into us and we just make a decision. Thank you.
Wow. Can you now hear from our noble professor?
Thank you so much. Your Lordship, this is the reason why we started Sharia Scholars Council. It is at its initial stages to regulate and also to know who is good at what. Actually, like as you have the Law Society, we want to benchmark on that actually, and this is going actually to assist us in knowing who is good at which. And this is going to, we are envisaging
and who is eligible.
Yes, and we are envisaging to actually to assist such that people can contact us and we'll tell them that this one and this one is good at this one and this one, and so on. This, we think that this is going to assist us in actually regulating and yes, sir.
When you're studying Sharia, are there people who go to study distribution of estates and others don't go for it? Because we know you all come back with different qualifications. Is there a qualification, or we just have general knowledge? So that every person who has studied Sharia automatically can distribute? Or someone must have that specific qualification to make him qualified to distribute an estate?
Okay, when we talk about Sharia, this is a general name, where you have those in, as you have here in commercial, we have Fara'id, that one specifically for the distribution, inheritance. So those, there are people who specialize in Fara'id. There are those who say, yes, I have Sharia, but Fara'id, I cannot manage like that. So
that's why the SCC.
Yeah. So there is something I came across without mentioning specificities. Somebody, I think at Antas, you know, we were into this together. Somebody made a trust and said that when I die, my estate should be managed by the office of so and so. That office, the decision will be final. That office, if the holder doesn't have this qualification, the bearer of that office should appoint a person who has thanawi.
Who has these qualifications?
A lawyer, but must have what? Thanawi. So we went on a search for a lawyer who has what? Thanawi. I just want to understand, as Justice has been asking, everybody comes around telling us, Sharia, Sharia, I'm an expert in Sharia, Sharia. What is the stream of Sharia that deals with marriage and distribution of estates? So that when we are recommending people, we know whom we are sending them to. We might send them to a person with Sharia, but the person specializes in banking and finance. Or it specializes in Mudaraba, insurance. So how do we get to know the right person to send these people to? I think the managers of the Sharia Scholars Association should be able to tell us.
Okay. Allow me to take only two hands, one from a lady and another from a gentleman, and thereafter we shall have closing remarks. The first one is Shekat Fatina Nachtende.
Thank you very much. First of all, I would like to commend our judicial system. I am an advocate and I practice in the High Court and all court subordinate there are too, and I go with my niqab. And no advocate has ever kicked me out. So thank you for that. That's a recognition. Now, we want, in as much as we want to practice law, we want to keep it in line with our religion. I have a question for the Sharia consultants here and also our dear judges. Out there in our families, they tell us, why do you call an advocate, why do you call a judge my lord? Okay? They say while we, in courts, we claim to be following, following our religion, we bow to you people, we call you my lord, and they tell us we are actually doing shirik or something like that. Dear Sharia experts here, please content our hearts and the hearts of our parents who paid school fees for us to do law, that we are not doing shirik while, by going to the courts and by in quotes these judges, please.
Let's take another question, and then, is it a comment or question? Huh? A comment. We are taking a comment from Haji Katantazi. We've had a question. I think we have two experts here. We have professor and then doctor. They will guide us through. Your comment.
Thank you very much. I've been honored to be part of those who were selected to draft the Qadhi Courts bill. I want to give the following assurance. A couple of the drafters are in this room, so I don't want to take full credit. Zakia is one of them. Fatina is also another one. Understood by the local person and the Qadhi under the Qadhi Courts bill. Thank you very much.
So our sheikhs experts in Sharia, back to you. The question which was posed to you by His Lordship. Do you still remember it?
Are you talking about the minimum qualifications?
Actually, his question was as to whether when you go out there to learn Sharia, there are those who come out as experts in a certain field. Oh. Okay.
Okay, I just wanted to answer.
Oh, Hajat Fatina.
What Fatina
about
raised.
the question over there, sure. The word lordship
the issue
and
of,
worship.
My Lord, my worship, your worship. These are semantics. These are just terminologies. And as far as Sharia is concerned, you can be your lordship, but at a human level. Of course, we all know that Allah is the Lord. So there is no problem as far as Sharia is concerned by usage of that terms. One could ask, where is the proof? There are two verses in the Holy Quran. Number one, in Surah to Yusuf, Yusuf tells his brothers, أَلَا تَرَوْنَ أَنِّي أُوفِي الْكَيْلَ وَأَنَا خَيْرُ الْمُنزِلِينَ. Don't you see that I'm the one in charge of the treasures of Egypt, and I am the best settler, Khairul Munzilin. So Yusuf says, I'm the best settler. When you go to Surah Al-Mu'minun, Nuh alayhi salatu wassalam, he says, Rabbi anzilni munzalan mubarakan wa anta khairul munzilin. Oh Lord, settle me in the best settlement because you are the best settler. So this is the best settler. Allah is the best settler at his level, at his majesty. And at human level, then you are Lord, you are what, and so on and so forth. And that's it. Thank you so much.
Yes,
just
I
if
also
I
know
could
that
add
actions
on,
are
if
judged
I could
with
add on.
intention. I also know that actions are judged with what? Intention. If you have no intention to turn this person into your God, but you're following the practice, the tradition of a particular profession, I absolutely find nothing wrong. Because what is the near you bring when you say, my Lord? Do you turn him into God?
No. Finally.
Yes, thank you so much. Yes, that one was very good. Although that issue we had talked about it just a few minutes before we came here. That me myself, I feel as if when you say worship, whatever we are saying from Sharia perspective, there isn't a problem if actually your intention is not to make him. But then the question of bowing also is also contentious. Yes, bowing is also contentious, but as he says, the intention matters here. Okay? Yes, although I would not, me personally, I don't bow. Me personally. Yes, but I'm not saying that it is
It can be
prohibited.
termed as contempt.
Sorry?
Contempt of court. Anyway, that.
But the court no longer have those archaic
we
judges.
shall organize a webinar on that.
You know, when we don't clarify these things, we are here where we are the epitome of knowledge. I've not seen a judge requiring people to bow for them. I've not also seen magistrates requiring people to bow for them. Really, when we say that people are bowing, maybe it's somewhere where I don't sit. But me, where I sit, I practiced law for 17 years before going to the bench. I didn't see these things you people are talking about.
Okay, now.
Yes, we have cultures like kneeling. We have whole countries like Japan, where courtesying and bowing is a sign of respect to your elders. Some of these things, I was in a mosque and someone read, is it a fatwa from Saudi Arabia, that kneeling is haram. I asked that person, have you seen how people greet, how they greet the king of Saudi Arabia? How do they greet them? They kiss and they do like this. So I told him that why don't the Saudis first issue a fatwa on that issue of kissing their king's ring? Why would they issue a fatwa about Ugandan practices? Me, when I call a judge her lordship, I'm giving, that's a title. I believe the concept, I'm not a serious sheikh. Oh, I'm not a sheikh. I believe Islam says, La ilaha illa. God is not saying that there are no other gods. He's saying people have. Don't worship them. Settlers, isn't it? But they are not him. They are other kings, isn't it? But he's the king of. There are other lords. He's the lord of. Don't worship these people. Thank you.
I think we shall have a conversation some other time.
Just 1 minute.
It doesn't speak into the theme of why we are here. We should leave it at that.
So,
allow me to call upon. I'm so sorry, Dr. Professor. We are behind schedule.
Regulated by Sharia, then the custom. Okay? So the custom, where there is no regulation of Sharia, the custom takes precedence. And that's all.
That is noted with thanks. Allow me, I'm sorry for those who have more questions and comments. We can't take them all. We are behind schedule, and people have to pick kids from school and other obligations. At this material time, allow me to call upon Hajat Zubeda Namugenyi to give her closing remarks, and after, we shall have a closing prayer from our brother Sheikh Sekandi, inshallah.
Assalamu alaikum wa rahmatullahi wa barakatuh. Isn't it an honor to have Muslim intellectuals in one room talking about matters that touch upon our daily lives? Muslims for Muslims by Muslims. I would like to thank you so much. Thank you for responding to the call. You know, it's one thing to organize something, but it's quite another for people to show up, and to show up big time the way you have shown up for this cause. I thank you. We should all clap for ourselves. In my closing, I would like to refer to a quotation by Said Jafar Raza, who wrote a book called The Essence of Islam. And he said, if I'm asked to summarize the principles of Islam and the essence of Islam, I would say it is justice. Islam is synonymous with justice. Justice to the Creator by worshipping Him and obeying His injunctions and mandate. Allah is justice. Justice to the Prophet sallallahu alaihi wasallam by following him as he represents the authority of God on earth. Justice to oneself by keeping it secure from sinfulness and egotism. Justice to the body by keeping it healthy and free from undue exertion and illness. Justice to the soul by keeping it pure with piety. Justice in the matrimonial sphere. Justice to the parents as they have been instrumental in gifting our existence. Justice to the spouse who shares the burden of raising a family. Justice to the offspring as they are extensions of our own life by motivating them to take the right direction in life. Justice to our neighbors by sharing with them in their moments of trial. Justice to the sick by helping the sick restore health. Justice to and the poor by supplementing their basic needs. Justice to the motherland by enjoying its fragrance, the fragrance of its soul, by loving and promoting its prosperity and being ready to sacrifice for it. Justice to the entire humanity by contributing to its development. Justice to knowledge, and this I would like to emphasize. Justice to knowledge by making it reach far and wide, by enabling mankind to enjoy its fruits without discrimination. Justice, therefore, is the foundation of Islamic principles and occupies a place next to the oneness of Allah. I would like to thank you all for contributing to all these forms of justice, but more importantly, to contributing to justice of knowledge by contributing to the Ummah in such intellectual ways. Thank you very much. May Allah take you back to your homes peacefully. Okay. May Allah take you back to your homes peacefully, and and hopefully, since this is the beginning of the Justice Summit, I would like to encourage each one of you to contribute in whichever way you can. There is knowledge, there is financially, there is contacts, because we want to hold a bigger session next year. Actually, the beginning of this idea, we wanted to have a 2-day session, because you've realized we could not cover everything. Someone was asking us, why didn't you cover Islamic finance? But we only had a day, and we could only do so much. But inshallah, next year, we are coming back bigger and better. I would like to request all of you to come forward for a group photo. Yes, after the dua, we'll take a group photo, and then we'll take, the panelists will also take a group photo, and I think at that point, we will call it a day. Thank you. Assalamu alaikum wa rahmatullahi wa barakatuh.
بسم الله الرحمن الرحيم الحمد لله والصلاة والسلام على رسول الله صلى الله عليه وسلم اللهم اجعل اجتماعنا هذا اجتماعا مرحوما واجعل تفرقنا من بعده تفرقا معصوما ولا تبق فينا ولا منا ولا معنا شقيا ولا محروما اللهم لا تؤاخذنا إن نسينا واخطأنا ربنا ولا تحملنا ما لا طاقة لنا به واعف عنا واغفر لنا وارحمنا أنت مولانا فانصرنا على القوم الكافرين اللهم ما لا سهلا إلا ما جعلته سهلا فاجعل أمورنا كلها سهلا ميسرا يا رب العالمين اللهم وفقنا لما تحبه وترضى إلى ما فيه خير للإسلام والمسلمين ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار وصلى اللهم على سيدنا محمد وعلى آله وأصحابه وسلم والحمد لله رب العالمين.
memorial photos. Let's start with the panelists. All panelists. And moderators, please come over quickly. Yeah. It's still on. We have 2 minutes for that episode. Panelists, we are sorry for bothering you, but the scholars told us that memorial photos are allowed in Islam. Hajat Zakia, you are missing on the panel. Cameraman. And then a group photo, everybody should come over. We have only 10 seconds to have everyone on board. 15 seconds left.
رمضان كريم وخير كثير يضيء القلوب كما ينشر النور نرفع أكفنا ندعو الإله نريد ونحيا بكم يسكنون الحب في كل داع ونملأ دنيانا بدءا النهار تحلق أحلامنا في السماء ونسأل ربي سلاما يدون رمضان كريم وخير كثير يضيء القلوب كما ينشر النور نرفع أكفنا ندعو الإله رضاه نريد ونحيا بطوح يا رب زدنا هدى ونقاء وامحو الذنوب بنور السماء لك المنتهى وإليك المصير فأنت الرحيم وأنت الغفور رمضان جاء ونوره عم ففيه الحياة وفيه النعم نحمد ربي ونسعى لخير ونبرأ